1 minute.
If it is GMCPC, if it is admission, then only it will be taken.
Land acquisition.
Huh?
Land acquisition.
Land acquisition, is it admission?
Fresh.
Day after tomorrow, madam.
Yes.
But one date given matter is not.
Date given.
Your lordship has heard this matter.
ಆಯ್ತು ಡೇಟ್ ಗಿವನ್ ಕೊಟ್ಟಿದ್ರೆ ಯಾವತ್ತು ಇದು GMCPC
ನಾಳೆ tomorrow. ನಾಳೆ
GMCPC ಇದ್ರೆ ನಾಳೆ
ಹಾ.
ಲ್ಯಾಂಡ್ ಇದಾದ್ರೆ ನಾಳೆ
tomorrow. Pages. Adjournments. B group matters. Serial number 42, 47.
42 matters. Permit me to withdraw.
Put
42.
42 dismissed as withdrawn.
Government, sir, government. 42. Ajra madam. 47. 48 to 55. Adjournments.
Serial number 50, my lord.
Hmm.
Next 2 weeks time may be granted to file my statement of objection.
Badrinath.
I'm yet to receive instructions.
You have for respondents, sir.
Please, my lord, I'm for BDM. my lord.
1 and 2.
Have you informed the
My
other
lord, yes,
side?
my lord, I have texted my lord, he didn't receive the call.
2 weeks.
Please, my lord.
48, my lord.
Huh.
I'm per respondent, I informed other side. I informed other side, my lord. It may be called next week or 10 days.
2 weeks.
56 to 65. 56 to 65. Adjournments. 66 to 71.
66, my lords,
Hmm.
and for the petitioner in this matter, it may be taken up in the next week. I'll have to
Lord.
file, my lords,
Respondent, brother.
lords, he's a formal party, my lords. My claim is against the special land acquisition officer, my
Lord,
lords.
this
Be
takes
taken up in the next week, my
years.
lords. There is some
In some
inconvenience.
time, sir.
Please.
Lord,
60 obliged.
67.
There is an interim stay granted by this honorable.
Sir, if you are aggrieved by the interim order, please file a vacating stay application. We'll consider that. Okay, 2 weeks.
Interim order may be extended. my lord.
Yes, interim order, if any is extended.
Yes. 67, my lord.
Huh.
Pray for next week. I will
Have
file
you-
my
Have
objections.
you informed the other side, sir?
Ramesh KR.
Have you informed the other side? You should know, you should, it's a date given matter. I don't know why date was given. You mention it when it reaches.
Yes, ma'am.
Let's see.
Yes.
Yeah.
57 no adjournment. First is
that's correct.
72, 73.
Correct.
List 1, serial number 1. Maheshwarappa M.
Petitioner in this case.
Ah.
The petitioner challenged the preliminary notification dated 23/3/1987, final notification dated 4/11/1987, passed by the deputy commissioner, third respondent here. My lord, the husband of the petitioner, one Srinath,
Just explain delay and latches, sir.
yes, please. Delay.
Delay and latches, you
Yes,
address your
Yes.
arguments on that.
Ram, I can see, the Honorable High Court of Karnataka already quashed the entire notification, partly, land measuring 56/1.
Where is the order?
My lord, I mean, see the page number. Annexure D. Yes, madam. Page number 56 here. 57. Annexure D. One of the landlord, Vannaya, was challenged the.
Where is it, sir? Where is it, sir, that it has been quashed?
Page number 63. For the reason stated in the order, while partly allowed in the petition, it is the final notification dated 4/11/87.
Only in so far as relates to land of the petitioner therein is concerned.
Yes, please.
And then,
But in this order, partly allowed only for the survey number 56/1 measuring 9 acre 33 guntas. Thereafter, the petitioner's husband, my lord, kindly see the page number. Yes, ma'am. Page number,
sir, you have to explain the delays.
yes, my lord. Yes, my lord. Page number 64, already petitioner requesting wrote a letter to the land acquisition officer on 3/12/2014. Thereafter, the said Srinath, husband of the petitioner, Again, 15/5/2017, wrote a letter to the land acquisition officer, specifically stated in the, ಜಮೀನನ್ನು ನನಗೆ ಬಿಟ್ಕೊಡಲಾಗಿದೆ ಎಂದು ಇಬ್ಬರು ಹುಡುಗರ ಬಗ್ಗೆ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಅಲ್ಲಿ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ದೇರ್ ಆಫ್ಟರ್ ಪ್ರಿನ್ಸಿಪಲ್ ಸೆಕ್ರೆಟರಿ ರೆವಿನ್ಯೂ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಪೇಜ್ ನಂಬರ್ 78 ಇವರನ್ನು ಇದರಲ್ಲಿ ಇಂಬರ್ ಹಾಕೊಟ್ಟಿದ್ದಾರೆ. ಕೈಂಡ್ಲಿ ಈ ಕಚೇರಿಯಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಸದರಿ ಕಡೆಗೆ ಲಭ್ಯವಿರೋದಿಲ್ಲ ಅನ್ನುವಂತ ಎಂಡರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಇದಕ್ಕೆ ಲೆಟರ್ಗೆ. ಸೊ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ನಂಬರ್ ಇಂಪಾರ್ಟೆಂಟ್ ಪೇಜ್ ನಂಬರ್ 81. ಇದರಲ್ಲಿ ಪ್ರಿನ್ಸಿಪಲ್ ಸೆಕ್ರೆಟರಿ ಸರ್ಕಾರದ ಪ್ರಧಾನ ಕಾರ್ಯದರ್ಶಿ ಅವರೇ ಲೆಟರ್ ಬರೆದಿದ್ದಾರೆ ಯಾರಿಗೆ, ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಫೀಸರ್ಗೆ. ಸೊ ಸರ್ವೆ ನಂಬರ್ 189 2 ಎಕರೆಸ್ ಲ್ಯಾಂಡ್ ಸಂಬಂಧಪಟ್ಟಾಗೆ ಶ್ರೀನಾಥ್ ಇವರು ಸಲ್ಲಿಸಿರುವ ಮನವಿಯನ್ನು ಉಲ್ಲೇಖಿತ ಪತ್ರದನ್ವಯ ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಿದ್ದು, ಸದರ ಪತ್ರದಲ್ಲಿನ ಅಂಶಗಳ ಬಗ್ಗೆ ಈ ಹಂತದಲ್ಲಿ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ವಹಿಸುವುದು, ಸರ್ಕಾರದ ಮಟ್ಟದಲ್ಲಿ ತೀರ್ಮಾನ ಕೈಗೊಳ್ಳಬಹುದಾದ ಪ್ರಕರಣವಾಗಿದ್ದಲ್ಲಿ ತಮ್ಮ ಸ್ಪಷ್ಟ ಅಭಿಪ್ರಾಯದಂಗೆ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದ ಮೂಲಕ ಸೂಕ್ತ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸುವುದು ಕ್ರಮ ವಹಿಸಬಹುದು ಅಂತ ಇವರೇ ಲೆಟರ್ ಬರೆದಿದ್ದಾರೆ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಬಗ್ಗೆ. ಈವರೆಗೂ ಅವ್ರೇನು ಆಕ್ಷನ್ ತಗೊಂಡಿಲ್ಲ ಇದರ ಬಗ್ಗೆ. ನಾವು several times
Can't be
request
helped, sir. You
ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ.
should have approached the
Moreover,
court.
the petitioner is a widow, 75 years.
There's no ground, sir.
Alla.
It's not the interest of the petitioner that is being catered to, it is the interest of the GP holder which is being catered to.
Yes, yes.
ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ.
My one kind submission, my lord.
Yes.
In grounds, already, the government of Karnataka cabinet subcommittee on dated 14/1/1991 ಎಲ್ಲ ಆರ್ಡರ್ನು ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ. ಇವ್ರಿಗೆ ಯಾವುದೇ ಆಧಾರ ಯಾವುದೇ ಅಲಾಟ್ಮೆಂಟ್ ಕೊಡೋ ಹಾಗಿಲ್ಲ ಅಂತ. Already seized the all powers of the operating the society as per the order dated, order number 45 of 105 dated 3/30/1990.
AJ access notice for respondent 1 to 4,
ಮಾಡೋದಕ್ಕೆ
issue emergent notice for respondent number 5. Nodi, see, the only question is, see, for a cooperative society, the land could not have been allotted. Now, if it has already been allotted, if the layout has been formed, the sites have been made, nothing can be done. It has to be dismissed on delayed latches. If nothing has been done so far, okay, if the land remains as it is, there are no photographs ಹಾಕಿದಾರ?
ಹಾಕಿದ್ದೀವಿ.
If the land remains as it is,
ಹಾಕಿದ್ದೀವಿ.
I'll seek instructions
You'll
and
seek
I'll make my submission, my lord.
Okay.
Yes, ma'am.
Yes.
After.
Please.
Adavishaya B.
Petitioner,
Respond.
the respondent have issued notification under 28/1 for 3 acre 20 guntas, my lords. But they have issued 28/4 for 3 acres, my lords. I have obtained the compensation also for 3 acres, my lord. Remaining 20 guntas, they have taken a position, my lords. That's what I have.
AGA for R1, 2, 3 ಗೆ PV Chandrasekhar.
I filed already objections. Lord, the question is, my lord, notification itself is for 28/4 itself is for 3 acres. my
3
lord.
acres. my lords.
Lord, it is a land granted to the vendor, 3 acres were granted to the Tahsildar. Lord, by selling the vendor to his mother, they sold 3 acre 20 guntas. Somehow the manner entries also based on the sale date. Actual land is available only 3 acres, though it was notified 3 acres 20 gunta. In the final notification, it restricted only to 3 acres only. 3 acres compensation was also paid to him, totally 2 notice was issued for 3 acres. Compensation received by the petitioners also, by his mother. Who is the Katazar? After demise of mother, after lapse of 10 years, 20 years, 10 years, if he come up, they play that, I got up to 20 gunta excess. The person was handed over to the board only 3 acres. If that is the case, my lord, question of quashing notification does not arise at all. Notification itself is for 3 acres. Where is the question of quashing or paying the compensation to the petitioner?
Yes, you have taken only 3 acres?
Yes,
3 acres
yes,
only.
my lords, they have taken, I have already received compensation for 3 acres, my lords.
So paid, notification itself is for 3 acres. Then how can he seek for quashing of 3 more than when he received compensation?
Yes, Bani.
Actually, A is the sale deed, my lords, for the 3 acre
Can't
20.
be helped, sir. If you have that land with you, you enjoy that. Yes, Bani. The case of the petitioner is that whatever said,
They is seeking to direction to pass award. for
Award or
alternatively
alternatively
quash
quash
the-
the-
where have you said that 20 guntas has been taken?
My lords, I have taken
It's
Trying
it
to,
is too late.
trying to take one, evict.
Right, development working is going on, my lords. They have,
The case of the petitioner is that he is the owner of 3 acres, 20 guntas of land in survey number
41 bar P2, my lords.
P2.
41 bar
8P2, my lords.
41 bar 8P2, Sorekunta village, Belak,
government land.
Tukkur Taluk and district.
Government lands.
Okay. Full stop. That KADB has acquired to an extent of 3 acres of his land, but is trying to dispossess him of the entire 3 acres, 20 guntas.
Grant itself for 3 acres. Better.
Full stop. Hence, he has filed the on the said ground. It is prayed that KADB should be directed to pass a supplemental award to an extent of 20 guntas of land, or in the alternative, direct KADB not to acquire the said 20 guntas of
Quashing
land.
the notification, he's seeking quashing.
Or in the alternative, set aside the notification in respect
For
of
20 guntas.
20
20 guntas of land.
But there is
Full
no
stop. Per contra, next para. Per contra, the advocate for KDB draws the attention of the court to the preliminary notification and final notification, which states that only 3 acres of land in survey number so and so belonging to the petitioner has been acquired.
Preliminary-
Only 3 acres of land belonging to the petitioner has been acquired.
That is
Final notification.
28 for 1 for 3 acre 20 guntas, 28 for 3 acres, my lords.
Okay, ಏನ್ ಬಂತ ಹೇಳಿ? ಅಲ್ಲ ಅದಕ್ಕಿಂತ ಫಸ್ಟ್ ಏನ್ ಬಂತು? Preliminary notification, but ಹೊಡೆದಕ್ಕೆ. To the final notification, wherein only 3 acres of land belonging to the petitioner has been acquired.
Petitioner's mother, my lord, actually was the
Full
Ratnamma,
stop.
she
It is
received
submitted
compensation.
that upon measurement, it is submitted that though the preliminary notification was to an extent of 3 acres, 20 guntas of land, upon measurement, it is realized that petitioner was in possession of only 3 acres of land,
And grant also 3 acres.
and his predecessor in title was in fact granted only 3 acres of
Acres.
land.
I am purchaser, my
And
lords.
for reasons unknown to KADB, the sale deed of the mother of the petitioner who purchased the said land shows the extent as 3 acres, 20 guntas. But on the ground, it is only 3 acres, because of which final notification is confined only to 3 acres.
And they accepted compensation also 29
Yes,
days
my lords. I have accepted.
And compensation has been paid in respect of the said 3 acres.
by consent.
And it is categorically stated that only 3 acres of land of the petitioner is acquired and nothing more than that. Has been acquired and taken possession of it. And
Possession
taken
ಅವರೇ hand
possession
over
of,
ಮಾಡಿದ್ದಾರೆ.
and nothing more than that. Full stop. The petitioner is, next para, the petitioner is unable to dispute the above said averment made by the
Yes, my lords.
respondent KADB. Full stop. Next para, for the aforementioned reasons, the writ petition being devoid of merits is hereby dismissed. Yes.
The preliminary notification was issued,
Hmm.
my lord, in the year 1992, in respect of survey number 282/2, my lord,
Hmm.
measuring an extent of 3 acre 27 guntas.
Hmm.
My lord, thereafter on 16/4/1994, my lord, the final notification was issued.
Hmm.
My lord, subsequently, my lord, the third respondent passed the general award In the general award, my lord, the land, there is no award in respect of the petitioner land is concerned. I have produced the award, annexure D, page number 94, my lord.
ನೀನ್ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ. ಆಮೇಲೆ then we gave the representation to the respondent, my lord, whether they have paid the
But it's 92 no, sir. How do you explain
my
that?
lord, kindly say annexure, my lord, annexure F, page number 113, my lord.
Notice order ಮಾಡಬೇಕು.
113, my lord.
KGF for R1. Muda,
Muda,
DP Vivekananda,
DP Vivekananda.
R2 and R3.
Four. Sri Harsha AK.
Lords, for the petitioner, my lords. My lords, I'm seeking for the mandamus direction of writ of mandamus, my lords. They have to consider, my representation has not been considered, my lords, at annexure G.
What is your, what is that you are seeking?
My lords, to consider, my lords, my property has been acquired by the respondent number 4 and 5 for the widening of a road, my lords, without paying any compensation or the alternative remedies, my lords. This has been second time where I have approached this honorable court, my lords. My lords may see annexure F, my lords. The
Okay.
writ
KGA for, one, two and three. 1, 2 and 3. ನೀವು ಬರ್ತೀರಿ.
1 and 2. Building.
No, no,
occupancy.
3 also.
1 to 3.
1 to 3. Issue Amazon notice to 4 and 2.
grateful.
By Vishwanath R Hegde.
Lord, my objections to the acquisition has not been considered, my lord. 5 guntas of land, my lord, where my house is existing, my lord, in respect of the adjoining lands, my lord, those properties have been given up from acquisition.
KGA R1, 2, 3. So on.
Sri KDB.
Lord,
Sir Shirali.
Lord, let them not take precipitative action, my lord. I'm in occupation of the house, my lord. There is a power connection also, my lord, to the house.
What ground you are challenging, sir?
Lord, I have challenged the final notification, my lord, annexure F, my lord, where, my lord, all other adjoining landowners, my lord, which are within the Gram Tana limits, their lands have been given up from acquisition.
Petitioner will not be disposed from the lands which is from the land which is the subject matter of the writ petition, provided he is not already disposed.
Please.
Full stop. This interim order shall continue till next date of hearing.
That I appear for the petition.
Hmm.
It says same that Nada Prabhu Kempegoda layout, your lordship posted these matters on 25th, my lord.
Hmm.
Your lordships already directed these connected matter to be listed. That these are all. matters-
Arguments ಇವತ್ತು ಹೇಳಂಗಿದ್ರೆ ಹೇಳ್ಬಿಡಿ.
Yeah.
Ready ಇದ್ರೆ.
Yes. I am giving the list of those connected matters, my lord, which your lordship directed to be listed.
It's just 2 days, na?
Just, it will not take more than 20 minutes, my lord.
No.
Award is not passed after 14 years.
KGA for R1, BDA,
BDA. K
ಯಾರು
Krishna.
K Krishna ಕೊಟ್ಟಿದ್ದೀವಿ.
K Krishna.
Krishna is
For
there.
2 and 3, list the matter on 25th along with WP number so and so.
My lord, a list I am giving it, my lord, this.
Yes,
Court of,
along with WP number so and so, 1 writ petition ಹಾಕಿ ಸಾಕು, main writ petition.
my lord, 6, 7, 8, my lord.
6, 7, 8, same on.
32 also is there, but I will mention when it reaches.
32 also same, huh?
Same, my lord.
Can office petition ಅದು ಇದು ಇಲ್ಲ ತಾನೆ?
Your lordships overruled those, and your lordship said it will be
Sir,
kept open, my lord, same.
32 office petition kept open,
Yes,
huh? ಬರೆದ್ಬಿಟ್ಟು same order pass ಮಾಡಿ.
please.
Yes.
9 Vishwanath R Hegde.
See, Lord, this area is a developed area, my lord. As per the circulars of the respondent authorities, my lord, the developed areas cannot be acquired for acquisition for purpose of industrial layout. The land was purchased by me. Before that, a layout was formed. Land was converted for residential purpose. And now, my lord, we are all in occupation of the property.
KGA R1, 2, 3, KDB,
KDB.
so and so.
Gopal V Bilalmane.
Petitioners shall not be disposed of the lands which are the subject matter of the writ petition till next date of hearing, provided they are not already disposed.
Please.
10 JM Rajana Shetty.
Wait for the petitioner, my lord. My lands came to be acquired and the award has been passed.
While passing the award, they have not considered the damages caused to my another land, which is at a depression level of 6 feet. And they have not considered in granting the additional compensation for the same.
Yes, AGA R1, R2 AGA, Karnataka State Highway Corporation Limited. Karnataka State Highway Corporation Limited. Any standing counsel? ನೀವೇ ತಗೊಂತೀರಾ ಅಥವಾ ಇದಾರ ಹೆಸರು ಇದೆಯಾ ಗೊತ್ತಿದೆಯಾ ಏನಾದ್ರು? ಆಯ್ತು, ಇಶ್ಯೂ ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್ ಟು R2.
Kumar HD. 11.
To consider representation with annexum to collect the revenue tax. He is ready to pay the revenue tax, that BDA is not,
Yes, BDA,
BDA.
so and so for respondent.
Ajay Kumar M.
ಸುಮ್ನೆ ಎಸ್ ಅಂತ ಹೇಳಂಗೆ ಹೇಳ್ಕೊಡುದು. You have to verify and state whether he has got any right over the property or not. Whether the property comes within your jurisdiction.
Please.
Okay, yeah, there are so many pitfalls here, yes.
Well, it's just Vasant Santosh.
My lord, I am appearing for the petitioner, my lord. Annexure E is the representation. Petition seeking for a writ of mandamus. My lords, the allotment was made in the year 2002 to the petitioner. Right from 2008, he is making representations for marking, for measuring and marking the rate which was allotted to him in 2002. But the
Yes.
representation is not yet considered.
BDA,
BDA. BDA.
ಹಾಕ್ಬೇಕು ಅಬ್ಜೆಕ್ಷನ್ಸ್. ಸುಮ್ನೆ ನೋಟಿಸ್ ಇಸ್ಕೊಂಡು ಡಾಟ್ಸ್ ಮಾಡೋದಲ್ಲ.
HT Baswaraj.
R1 and R2, HT Basuraj, issue emergency notice to 3 and 4.
Obliged.
13 N Kumar.
The petitioner and 3 others, my lord, are the owners of land 4 acre 28 guntas, my lord, including 2 acre 9 guntas of Kharab land, my lord, where out of 4 acre 29 guntas, my lord, 20 guntas have been acquired by the National Highway Authority, my lord. And compensation has taken by the petitioners, my lord, being the owners. Thereafter, it came to know that, my lord, the land so acquired by the National Highway is in the Kharab land, my lord. Thereafter, they made a representation saying that conduct a podi by excluding the Kharab land, and they are ready to deposit the compensation before the court, my lord.
Yes.
Thereafter, my National Highway Authority also, my lord, they admit that the land so acquired by the National Highway Authority is.
So a portion of your land is not acquired according to.
Yes, my lord. So for that reason, my lord, they are neither conducting the podi, my lord. That's what, my lord, made a representation, my lord, at annexure.
Shilpa Shah for R1, R2. AGA for 3 and 4.
14 Banu Prakash VG.
Suit for specific performance.
Respondent number
Not to
13.
find the plaintiff at page 45. 11 lakhs was paid, 1 crore 21 was to be paid at the time of registration. When we say that we are ready and willing to pay the money, they do not come forward for registration, a suit is filed. In the proceedings, at the time when the defendant has to lead their evidence, they come out with certain documents and certain averments in their evidence, which has nothing to do with the suit for specific performance, but would say that there are other people who have got into agreements and they do not have the right to so and so. So I filed an application to delete those, my lords. My lords will find my application at page 75 annexure E under order 13 rule 3. However, the trial court would reject the said application on the pretext that, on the premise that once the documents are adduced and exhibited, we cannot delete it.
Here for,
And for the respondent number 13, 14 and contesting this.
what about other respondents?
They have to be served, my lords. He was on K-bed, so I have served him a copy, my lords.
No,
My
are
lords,
they essential?
my lords, they are the ones who are to answer this court as to why they have produced.
That notice go and come, no?
ಅಲ್ಲ, ಅವರು
Please,
contest
Lords.
ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ application.
I'll take out notice for them also. my
You
lords.
take out notice for them.
Please.
Issue emergency notice, so and so access notice for respondents,
Respondent number 13, 14 and 15.
13, 14 and 15. Issue emergency notice to other respondents. Bengaluru,
Bengaluru.
petitioner is also permitted to serve the counsel for respondent so and so who has appeared for them before the trial court. Post the matter immediately out of service or notice.
I've sought for stay of the proceedings because evidence is going on.
Eight
Well, our
minutes.
evidence continue ಮಾಡ್ಬಿಟ್ರೆ I will
It's
lose out
already
my right.
commenced, my lord.
Till
Already twice the DWN has been cross-examined by the,
I have found out that this
90.
and I made an application under 13.
Okay, you made
if
an
these
application
documents are
for-
That
removed,
application
nothing,
is
nothing
rejected.
remains in
My
the
lords may
evidence.
stay the matter only till the service is done. I am
Right.
ready. Even on the first day when the matter was listed before my lords, I
Right.
undertook say that we will argue it on
Kindly
the
peruse the
final.
order passed by the trial court, my lord.
What is the difficulty? I don't understand for the reason.
The exhibits are confronted to the PW1. He himself admitted about the said exhibits.
I have pointed out as to what are
Where is
the,
the
admitted.
application, Banu Prakash?
sorry, my lords.
Where is the application?
Page number 75, annexure E, my lords. I've stated which are the paragraphs and which are the documents. And the examination in chief, my
ಅದರ
lords will
remove
find
ಮಾಡಿದ್ರೆ
that
nothing remains in my evidence, madam. Our almost evidence of the DW1 and the documents produced by the DW1 ಎಲ್ಲ ರಿಜೆಕ್ಟ್ ಮಾಡಿ ಅಂತ
lords,
ಕೇಳ್ತಾರೆ.
what needs to be
Nothing
seen in a,
remains.
So
Alla, what
sentence-
need, my only submission is this.
You can hesitate.
Alla, what needs to be seen in a specific performance is whether there is a valid agreement, whether there is an advance paid, and subsequent to that, whether there is willingness to pay the remaining sale consideration at the time of execution of the sale deed.
Ready and willing
If at all
to-
the said documents are not
Now,
relevant or not irrelevant.
bring in
They
new
can, they can agitate it in the cross examination.
no, to bring in new evidence at the time of evidence,
Even the said documents are admitted by the PW1, not in the course of, not produced by the DW1.
my learned friends allows me to
Confront
make a
ಮಾಡಿದಾಗ
case, I'll make out my lords.
ಎಲ್ಲ ಪ್ಯಾರಲಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇದೆ ಬೇರೆ ಸೂಟ್ಸ್ ಅಲ್ಲಿ. The very same plaintiff executed the sale, entered into a compromise in respect of the very same property. ಆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ.
Kindly see the order sheet. In which
Property
my
is not at all available for granting the relief of specific performance, my lord.
my lords must kindly see the order in which my application came to be rejected.
Our-
They say that once
our
the doc-
almost
Yes, the only thing is the 2008 matter suit. See, the contention you are taking now, you can always take it in.
I do understand, my lords. I only want to establish before my
want to
lords.
remove 6 paragraphs in my evidence and they want to
It's a
remove
bit-
entire exhibits.
Servant.
In ನಾನು evidence ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
I'm only requesting my lords to grant me an order so that the evidence doesn't continue. I will serve them next week, my lords may have it.
Evidence.
My lords, what happens is if evidence continues, this will come on record, which will be detrimental to my main prayer for specific performance. They are taking a contention that these people are not involved in the entire
Got
transaction.
a case, we'll hear it in due.
Please, my lords,
They got a case.
please.
Yes, what is the application that you filed?
Under order 13, order 13, rule 3, page 75. I have sought for rejection of the following portions from DW1's evidence and also the documents. I have culled out which are the paragraphs which I am seeking for deletion. My lords would find in my application, paragraphs 3, 4, 5, 14, 15, and 17. The evidence of the defendants starts from page number 67, my lords. The paragraphs, I'll just read it out, my lords. Paragraph 3 at page 68. I submit that the plaintiff does not have any power or authority to enter into an alleged agreement of the sale with the defendants, as the suit filed by the defendant number 12 against the other defendants in verse number so and so is still pending adjudication on the file of the principal so and so, and the said other defendants are also signatories to the alleged.
Yes, sir.
Agreement.
No need to stay the suit. Yes.
She Shankar Reddy.
Please, my lords.
Petitioner, as per annexure, yes, this honorable court issued direction to execute sale deed, but the same was not complete till today, my lord. So representation given several representations.
Yes, BDA.
and
PDA.
K. Krishna,
Hey Krishna. 16.
correspondence.
Naveen Chandra V.
I appear for respondent number 2.
Because here we are seeking that site which has actually been directed to be maintained as a park by orders of this honorable court, in fact, should be handed over to BBMP so that they can actually maintain it as a park. It is really dilapidated. In fact, if my lord sees the order at page 40, sorry, not at page 40, no, it's 43. There was an order at page 43, 5th January 2023 order. And the operative portion, para 4 onwards. Para 4 is at.
What is your locus, madam, and
No, we are the residents. It's a residence of the area.
now,
There is already, it is
what
to
is
be
your-
kept as a park.
now what is your right?
No, Now, my lords, we only want the BDA says that we are told to leave it. So we've left it, and I've produced the photos. It is like a jungle.
It's all right.
Now they have to send it. BBMP develops all these lung spaces as proper parks. They can put a children's area. They can put a pathway. They can look after it, my lord. So we are saying, in fact, we wrote to the BDA, please hand it over to BBMP and direct them to maintain it. As
Now,
a
what is
park.
your right to ask for such a direction, and what provision of law do you get such a right?
My lords, as as residents of the locality, under the BDA Act, BDA is required to maintain certain lung space and to maintain certain percentage, which it has been directed to be done by this honorable court. We have left this place as a park. As per the BDA's own policies, as of now, they are not looking after any park areas. They are giving it to the BBMP. That is their internal decision. If either BDA themselves develops it as a park, it is their duty under the BDA Act. And if they don't do it, then BBMP is another civic body which also has this obligation under the Municipal Corporations Act or under the BBMP Act.
Show me a provision of law where you can see there are two separate things. One, asking the authorities to maintain the area as a park.
Yes.
Which they have neglected. For that, you need to file a public interest writ petition. This writ petition is not maintainable. The second aspect is handing over of the site from BDA to BBMP. If that is the relief, you'll have to show when they'll have to hand over and how they have failed to hand over in spite of that particular requirement has to be done. Where have you pleaded?
I'm looking at the second option because the fact that
PAL, ma'am.
the fact that they have to maintain it as a park is already a court order. My lords may see the court order at page 45, which BDA also has accepted at para 4. At para 4 at page 45. May I just show it to my lords? Yet another reason, my lords have found that, yet another reason for not taking up the matter for a deeper consideration is that the lease tenure itself has expired and no application can now be made for renewal of the lease either on cancellation of allotment itself being on the fault ground. Learned BDA counsel in all fairness submitted that the said site has been retained as a public park. He is not in a position to make a statement as to whether the same would not in future be allotted to a third party. A civic amenity site that has been maintained as a public park cannot be allotted to anybody since it needs to be maintained as it is, at least as a lung space in a densely populated city like this. Now, this order was there. After this order, it has been left as a lung space by the BDA. Our submission, my lords, is just leaving it as a lung space which nobody can use and is fully dilapidated and overgrown is of no use to anyone. And under the BDA Act and under the legislations, my lords, maintaining it as a park means taking all the due care to upkeep it, including the maintenance, beautification, all of that. So on that basis, my lords, we have written representations. It may not necessarily be required to make it a public interest. These are all residents which are directly adjoining that area. So in fact, we wrote to both authorities, whether it is BDA has powers to maintain it and to beautify it. BBMP also has the powers. So whether BDA does it under the BDA Act or if they take a policy decision that no, we are handing over all our parks to BBMP to maintain it, it is up to the authorities. Therefore, we have made both of them parties.
You come to page number 41.
Yes. My lords, this was a previous PIL.
Yeah. See
Yes.
what happened in that.
Yes. This PIL, my lords, let me give you the history, my lords, just briefly. This site was initially a civic amenity site, which was allotted to a party. It was cancelled around 5 times.
Allotted to you.
No, not to me. No, not to me. The name sounds similar. It is not at all to me. It was allotted to an organization called Indranagar Social Welfare Trust. Not to me. It was allotted for civic amenity purposes.
Who are you?
My lords, I am a residence group. I am totally unconnected. It was never allotted to me. And there is nothing to do with the allotment. In fact, we are saying it is now with the BDA. Let the BDA, we just want the residents and the children to use it.
Yes, Bunny, Barkul.
My lords, may I make a submission?
Yes,
If
ma'am.
my lords are not convinced whether it should be a PIL, then my lords, may I just at least submit some authorities can be taken up next week and then ultimately I leave it. Or
No.
my lords may send this to Court Hall 1.
You can withdraw and present a PIL. If you want, I'll give you the liberty.
Then my lords, I'll take the liberty to withdraw and to, with the liberty to file it as a PIL.
Yes, the advocate for the petitioner in the course of the argument submits that the writ petition being in the nature of a public interest writ petition, she may be permitted to withdraw the same and present APL in this regard. Full stop. The more is taken on record, writ
With
petition
liberty, my lords.
is dismissed, reserving the liberty to the petitioner
Great,
to file FEL if need be,
great.
in accordance with it. Sorry.
The 17 MC Basuraj.
For allotment of alternate site track. Annexure G is the representation made by the petitioner. That petitioner's land was acquired for the purpose of formation of non-Bharati layout plan. And subsequently, they have received the amount from the petitioner as per annexure E. Madad.
Yes, BDF.
BS Karthikeyan. 18 Radhanandan BS.
Yeah, for the petitioner merits. That's in this seek for compensation with the new act, my lords. And crashing of the general award.
Make a submission. Lordship has already,
R1, KDB, P. Chandrasekhar, Harish for R3 Metro.
Lordship has already passed the order in WP 812 of 2019 on 4th July 24th. In the same terms, it can be
Same
disposed.
order may be passed.
Is the order number?
Copy release agila. The main order is this Bhaskaran's case. Lordship followed
WP
Bhaskaran's case.
54368, my lords. It is similar to that.
Based on this, your Lordship already dictated.
Idu ತರ ಆಗ್ಬೋದಾ?
Please, my lords.
Same Radhanandan appear ಅದರಲ್ಲೂ. Same lands.
ಇದು 8/12 of 2019. 8/12 of 2019.
8/12 of 2019 and 4, I think, other matters.
Other connected matters, sir.
Lordship disposed.
2019 ಏನ್ order ಆಗಿದೆ?
6 matters are disposed.
ಅದ್ರದ್ದು
4th July.
4/7.
4/7.
ಇದನ್ನು ಇಟ್ಕೊಂಡ್ರೆ. Yes, dispose.
I have already filed my wakala.
Yes, so ಅಂತ ಹೇಳಿದೀನಲ್ಲ.
Okay, not ಏನೇನು ಹರೀಶ್ ಸರ್ PV ಚಂದ್ರಶೇಖರ್ KVD 19 Prasanna DP.
Petition. This land is unauthorized petition, my lord. 20 Gunta, survey number 40, Malakapura village, Pintamani Taluk.
Yes, AGA for response. Yes, what is your right over the property, sir?
Madam, more than 40 years in occupation in the land.
So what? Has it been regularized by the committee?
Already an representation on
So that does not
12/5/1993,
suffice, sir.
my
See, when they acquired, it was a government land. Okay,
but
when they acquired
on
the property, it was a government land, sir. If some right had fructified in your favor, question of granting compensation arises.
that already occupation in application filed on the 12/5/1993, but acquisition on
You did not pursue it,
12.
nothing happened, nothing happened. What to do? See, you should be the person interested. ಆಯ್ತು ನೋಟಿಸ್ ಮಾಡ್ತೀನಿ, ನೋಟಿಸ್ ತಗೊಳ್ಳಿ, ಅದು ಏನಿದೆ ಹೇಳಿ.
For the petitioners, my lord, petitioner got the land converted much before the acquisition, my lords, in the year 2010. Acquisition is of the year 2011, my lords. However, for the purpose of compensation, my lords, the land is determined as agricultural land and the compensation is awarded. Conversion order is at annexures.
ಈಸಿಯಾಗಿ ತಗೊಂತೀರಾ ಎಲ್ಲದಕ್ಕೂ?
ಎಲ್ಲರೂ ಸ್ಟೇಟ್ ಹೈವೇ ಪ್ರಾಜೆಕ್ಟ್.
ಸ್ಟೇಟ್ ಹೈವೇ ನಿಮ್ಗೆ ಬರುತ್ತೆ ಅನ್ಸುತ್ತಪ್ಪ? No corporation is involved, it's your departments, that's all.
1 to 3,000.
ಎಲ್ರಿಗೂ ಬರುತ್ತೆ ನೋಡ್ರಿ.
1 to 5 ಎಲ್ಲರೂ ಸ್ಟೇಟ್ ಹೈವೇ.
Okay, 1 to 5.
AGA for respondents.
Great.
Call after 2 weeks, objections if any by then.
Yeah, Lingraj.
Get instruction council. It
Yes,
doesn't
ma'am.
matter whether it's converted for converted land or agricultural land. If it is converted land, you have to pay compensation as per
Fair compensation.
that. Okay.
Annexure A, page 14 is under challenge, my lord. It is the preliminary notification of their 1985. Conversion godaga, this notification reflect, my lord.
Only preliminary notification, na?
Only preliminary notification.
Final illa.
No final notification.
AGA R1 Siddharth.
Muda.
JB Sharath Gowda ಅವ್ರಿಗೆ ಒತ್ಸರಿ ಕೊಟ್ಟು. JB Sharath.
GB Sharad Gowda.
GB Sharath Koda.
234.
Please.
Call after 2 weeks, objections if any by then.
Sri Hari AV.
Date may be given, my lord.
The date but roast change ಆಗ್ತದೆ.
Please.
Petitioner. Fund number. General award matter 29-2.
ಮಾಡ್ಬೋದೇನ್ರಿ? Consent award. General award.
Annexure D.
Government D. ಬೋಪಣ್ಣ ಬೆಳ್ಳಿಯಪ್ಪ.
ಆಯ್ತು. General award consent award ಮಾಡ್ಕೊಂತೀರಾ? Case of the petitioner is that he is the owner of 2 acres of land in survey number 85/P15 brackets new survey number 139 of Mindahalli village, Malur Taluk, Kaspa Hubli, Kolar district. ಮಾಮೂಲು ವಿಜಿಲೆನ್ಸ್ ರೆಕಾರ್ಡ್ ಅದಲ್ಲ ಗೊತ್ತಾಗುತ್ತಲ್ಲ, ನೋಟಿಸ್ ಅಲ್ಲ. AGA R1 2-3 ವಸಂತ. ಕೃಷ್ಣನೋ ವಸಂತನೋ?
The annexure DL last column ಅಂದ್ರೆ ಇದು wording ಇದೆ ಸ್ವಾಮಿ, ಅದೊಂದನ್ನು ಸೇರಿಸಬಹುದು.
ಏನಂತ ಬರುತ್ತೆ?
It is needless to state that in the event of the petitioner failing to provide necessary document to establish.
That goes without saying. I think you have not seen our orders on consent awards. If it does not provide the necessary documents, or if there are any dispute, the general award stands restored. It goes without saying. Okay. Yes.
23 Shri Rajshekar.
So the mandamus notes direction to the respondent 5 to disperse the remaining balance compensation amount. Notes annexure E page 31. Pursuant to direction of this honorable court, fresh award came to be passed. At page number 39, your lordship will see 13,15,318 is the additional compensation amount. Annexure G, your lordship will find what they have paid is only 4 lakhs. For remaining, I have given a representation. The remaining amount has to be disbursed.
AGA R1 South Railway Construction, Southern Railway Construction. Yaru, who is the?
That's fifth respondent has to now disperse the amount.
Okay, 1 and 5 AGA.
1 AG.
1 and 5 AGA.
Please, please.
2, 3, 4 Yaru, standing council.
Notes on previous occasion, Uni Krishna appeared.
Okay, so and so is directed to accept notice for respondents 2, 3 and 2, 3, 4 alla? 2, 3, 4. 2, 3 and 4, yes.
24 Mahabaleshwar Rao Kane.
Question under the Compensation and Transparency Act has been made. And without paying compensation, the respondent entered into a position and carrying the work. Now, under the act, payment of compensation is mandatory before taking possession. And even before declaration under section 19(1), there is a clause that beneficiary has to deposit entire cost of the acquisition. This is section 19,
When was the acquisition, sir?
22. ma'am. Thank you.
Yeah.
Annexure A, the declaration.
There's AGF for response.
That's right.
After 2 weeks, objections, if any, by then.
The
Yes.
status quo regarding work.
No, sir.
25, Rajeshwar PN.
Respond.
Affidavit. Directed to file affidavit. That's fine. Copy on the your quoted.
Yeah, 2017. Put it. Audition. ಬಂದಿತ್ತು ಇಲ್ಲ See, these things I don't read. ನಿಮ್ದೇ ಇದು ಇನ್ಫ್ಲುಯೆನ್ಸ್ ಅನ್ನೋದಕ್ಕೆ ಇಂಟ್ರೆಸ್ಟ್ ಅಂತ ಬರೀತೀರಾ ನೀವು. See these types of mistakes. It's a major mistake. If you don't understand, please go to it or send the draft. Inference will be drawn against them and necessary orders will be passed on. Interest will be drawn against them. You don't even understand what is happening in the court. And we are made to sign the wrong orders.
Well, please. Pass on. Directed to file an affidavit with the sketches and all produced.
They have given the affidavit right now, my lord. So much of cases that we post. Every word I have to read and yes, what is this matter?
This is the matter, my lords. The petitioner's land, my lords, forms part of survey number 146, which was notified for acquisition for HSR layout. My lords, in the last previous occasions, my lords, after we pointed out that the entire survey number 146 has been acquired. In fact, there was a writ petition which was filed. The writ petition came to be dismissed. The writ appeal was filed. Writ appeal was also, the order was confirmed. And the acquisition, so far as this particular survey number is concerned, was upheld. But the court directed us to find out what structures exist in so far as this contentious plot is concerned. But that I have produced now, my lords, we have an affidavit. I'm filing the same. And I have produced
Go on with the matter.
sketch.
My lord, they've given the affidavit now, my lord. Kindly pass over the matter. We'll go through it. And you have seen it here.
Lords may kindly see the earlier order passed by this honorable court.
Earlier order ಕೊಡ್ರಿ.
Directing them to produce the documents.
They have produced.
Challenge to the writ petition. That's the order dated 10/4/2024.
Copy ಕೊಟ್ಟಿಲ್ಲ.
Yes, where is the sketch council here in the, where is the land of the petitioner in the sketch?
Produce.
Hmm?
Sketch produce ಮಾಡಿದೆ.
Where is the land of the petitioner in the sketch?
Please, let's have the first sketch in. Sketch ನಲ್ಲಿ. Let's below the portion where the BMTC bus depot ಏನಿದೆ. That means after the road. Below. This is the entire portion 2 acre 30 guntas which they are claiming. We have identified the structures which are existing there. ಇದರಲ್ಲಿ ಒಂದು ಮಾತ್ರ RCC structure ಇದೆ. Rest of them are all temporary structures. The rest of the land is completely vacant.
What about the adjoining lands which are being denotified? Where is their status and where is their sketch?
Please.
Why have you not indicated? The order says that you are required to indicate those things also on the sketch.
Please, they have produced one more sketch. Doddu sketch ಹಾಕಿದೆ. Last sketch. May kindly note. This is Sadiq, it is on the reverse ಕಾಣೋ ಹಾಗಿದೆ. Top ಅಲ್ಲಿ my lords would see the BMTC bus depot.
BMTC bus depot.
Northern side. North side ge BMTC bus depot ಇದೆ, that's been highlighted.
ಅಲ್ಲಿ ತೋರಿಸಿ ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ. ತೋರಿಸಿ ಅವರು ಫೋಟೋಸ್ ತೋರಿಸಿ. ಎಲ್ಲಿದೆ ಹೇಳಿ?
Top ಅಲ್ಲಿ. The top is the BMTC bus depot. Right below that, well, it's after the road, the land which is claimed by the petitioners.
7th cross road ಆದ್ಮೇಲೆ.
ಹೌದು. That's to the western side, my lord, survey number 143, where the outer ring road is found.
ಯಾವ್ದಪ್ಪ? ಇದಾ lands of the petitioner?
ಅದು ಕೆಳಗಡೆ ಇದೆ. Just below that.
ಇದಾ? You come here and show.
I'm sorry.
You should mark it, no, in the map.
Sorry. This is the land which is claimed by the petitioner.
Okay.
Lot of 146.
No,
which sketch where the rest of the portion is there. This is 143.
No, see,
This is where ORR has been.
the court wants to know which are the lands that has been left out from acquisition.
This is the portion that's where. 137. Portion of the land, there is an apartment which has come up. This is the portion. This portion is I'm told it is an open space.
I am asking you which were the lands that were left out from acquisition.
No land is left out from acquisition. This is the only portion of land which is there, which is left out, which has been built up. The rest of the portion is all acquired.
They are not left out from acquisition.
That's the reason I produced this entire for the sector. To show us the abutting survey numbers are also acquired and layout is formed.
Okay. What about this?
Entire stretch of 146 minutes, entire stretch layout is formed. We have
The layout is
CSI
formed here also?
Yes, ma'am. This is a CSI which has been allotted to BMTC.
Okay.
The other CS sites are also marked here. So this entire section I brought it out. So I could highlight this.
Okay, so this is the only
This
place
is the only portion which is abutting that towards. This portion is built up, which is not now part of.
that has been
Please.
left out.
Oh.
Well, okay.
But it does not form an island. This is which a petition is claiming. That's the reason the entire full sector is what I had produced.
Oh, okay. So this is what is left out.
That's what is.
This is what they are asking
They're
for it to be left out.
Please.
This is left out on the ground that this portion is built up.
Built up. There is a apartment complex.
Here what happens?
This portion. This portion.
But Mark is only here about apartment complex.
But this entire thing, 3 apartments. These are. This entire this is.
Okay. When was the notification, preliminary notification? 1986 and 87, this was built up?
1986, 87 minutes. So,
Then?
I have not sought for that.
Then leave these people also.
There's no reason for to do that. There's only a portion of this lot is what is there, not the entire. There's only one RCC structure I have said so in my
in the other specific affidavit sketch we have directed to produce, there are pointed out where the RCC structure exists. The rest of us, there are some temporary structures, the entire area is still vacant. I've got one more the photograph which they gave, but I didn't know whether it would be appropriate for me to produce. I'll produce that also.
See, the point is, as on the date of preliminary notification, nothing is built up over here. Nothing is built up over here.
What's the reasons why this one is concerned, when I may not say, when I get the not, I'll produce it.
See, the only obvious reason would be they're influential. That's all.
Possible, but the
See, because according to you, as on the date of preliminary notification, nothing was built up here, nothing was built up here. But on the ground that in spite of notification, something comes up over here, you leave out that particular portion.
that portion is de-notified and put somewhere in 2002. I couldn't get those details actually.
No, it's all right. You argue. Much is. Yes, Council.
My lords, I may be permitted to file those notifications.
So I have some Google photograph or something to understand the present.
I'll produce it.
Huh? Have you produced the photographs?
Google photograph Hakilas.
Other one, otherwise, the permanent structure photographs.
Lords, I have produced along with my petition.
ಒಂದು ಮನೆಯದು ಫೋಟೋಗ್ರಾಫ್ ಇದೆ ಸುಮ್ಮನೆ.
Page
That they are
44.
not denying.
Page 44, annexure 45, 46.
Yes, his contention is a small RCC structure is there. Beyond that, nothing else is there.
Lords, this was there even when the notification was there.
He is not disputing that particular fact.
Lords, kindly see, my lords, he says the preliminary notification is of the year 1984. And final notification is 1986.
86.
Till date, we are in possession of the property. And there's no question of taking over possession or formation of the layout. And my lords have seen that on the northern side of this property, they have left out. Admittedly, they have left out.
ಆಗಿದೆ.
ಏನ್ ಪೊಸಿಷನ್ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತಾನೆ ಆಗುತ್ತೆ.
The entire 7146 is taken possession of. It is not portions.
Division bench, my lord, taken a view that 16-2 ಆಗಿದೆ ಅಂತ ತಗೊಂಡು.
Very same survey number, my lord. Another person had challenged. Same survey 146. This honorable court had upheld the acquisition. Writ appeal was filed. In writ appeal also, the acquisition has been upheld so far as the entire survey number is concerned. The portion, the aspect of me taking possession has been upheld.
What remains?
Lords, my submission is, my lords, what treatment is meted out to a person who is above me? Same treatment has to be meted out to me. Plus now, if the layout had already formed, then this land was used up, my lords, is a different aspect of the matter, my lords. And even my lords have seen the layout map. They have not earmarked my property for any purpose.
I have produced that also. Earmarking has been produced. Site numbers also have produced. Sketch will produce ಮಾಡಿದ್ದೀನಿ ನಾನು. The second sketch I have produced the show. So that site numbers and all I have produced it. About 22 sites are shown. Road is also shown. The second sketch.
This entire area is owned by one person, only the petitioners.
Please.
Can you leave out
Yes.
the house and acquire?
They would have to make application at section 38D is what my lords are indicating.
For the person who is above me, no section 38D application. For me, it's section 38D. Lords, there must be some fairness on the part of Bangalore Development Authority.
You do one thing, you file your objections to this affidavit, argue out the matter.
Please. Please.
ಹಾಗೆ ಭಾಷಣ ಬಿಗೋದಲ್ಲ.
Understood.
With relevant.
Yes, ma'am. In fact, I had some
Yes,
documents, ma'am, I wanted to produce.
The request of See, case laws you need to produce.
Yes.
The request of petitioner, call after 2 weeks.
Please.
Let's time for the petitioner minutes.
Hmm.
In serial number 26, let's seek short accommodation methods.
The request of petitioner, call after 2 weeks.
27.
Please.
Rakshita DJ. TV Chandrasekhar.
My lords, on behalf of the Council of R5 and R7, is due to inconvenience, fresh.
Timmappa.
Timmappa.
I am preparing for respond 2 and 3.
During the pendency of the writ petition, my lord,
They want
my
some time.
application for amendment.
So they want some time, sir.
Yes.
The request of
R5 and R7.
5 and 7.
5 and 7, call next week.
If you let me kindly
Uh,
extend the interim order.
That interim order yesterday, I had said until next date of hearing, but it has been clarified as for a period of 4 weeks or 2 weeks or whatever.
Oh, sorry, my lord, if
That matter.
yesterday's matter.
Yes, yes,
What
because
was
it's a very old matter.
Yes, sir. Certainly, I will assist, my lord. Ultimately, your lordship has to.
Uh,
Interim order may be kindly based.
Right, but the request of respondent number 5 and 7, call next week, interim order if any is extended till next date of hearing.
Obliged.
28. Devendrappa.
I undertake to file wakalat for R5 man.
Yes, sir.
GM Ananda.
GM Ananda.
So wants to undertakes to file wakalat on behalf of respondent number 5. Advocate for the petitioner absent, call next week.
2 weeks man. In the
Call
meantime,
after
I'll
2 weeks, objections if any by then.
please.
9.
PH.
Hey Krishna. Obbugowda Trimbagi.
Understand. English, if you read, you will understand. Okay, don't. If you don't know anything, just go there. Or you ask me once again, no problem. You could look very bad on those mistakes. Interest see. Yes.
Petitioners. In this case, I am appearing for the respond 2, 3 and 4, my lord. Last time directed to submit some report, my lord. Seeking some time, my lord. And but in the prayer is concerned, my lord, they are seeking mainly for compensation. Compensation is already deposited in the civil court.
I am the impleading applicant. Lot of the property belongs to me. Lot of the petitioner, he has no right to lot of the over the property. Lot of I had filed a writ petition before this honorable court, lot of which was allowed against me, lot of.
Yes, BDA want, BDA thane.
BDS.
BDA want some time.
Main my lord, these petitioners are there is a dispute between the impleading applicant and the petitioner. The petitioner claim, my lord, they have purchased the revenue sites from the original owner. The impleading application claim that he is the wife of the original owners. Therefore, my lord, the compensation was, we passed the award and compensation was deposited because earlier the impleading applicant filed the writ petition seeking direction to.
All sets are ready, I will hear them.
My lord, only that question and regarding the claim of the petitioners is the revenue site is concerned, my lord. This the matter pertaining to the Arkavati layout, this honorable court, my lord, they refer the matter to the committee. These persons also revenue sites, they can approach the committee, my lord, as per the batch of the order passed by the learned.
What was the order passed wherein we have said about now?
Arkavati, there is.
Filing of.
Last occasion, my lord, your lordship directed to do
Arvind Kumar.
the status report. My only relief is, my lord, we are all purchasers way back in the year 2003. We have constructed residential houses. We are residing there.
Photographs could you-
750.
Photographs also I have produced.
750. 750.
Now BD has to file status report, madam. No, photographs also.
Photograph is last time producing. ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇನೆ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಅದರಲ್ಲಿ ಇದರಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟಲ್ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಮೇಲೆ
No, Krishna, if construction has come up, you'll have to.
No, these, my lord,
At the time of Lord's acquisition, there was no
no
construction.
construction,
at all.
therefore, my lord, they have some put up, try to that demolition.
No.
ಅದು ಇರುವ ಬಿಲ್ಡಿಂಗ್ ಅವರದಲ್ಲ.
You file the status report, let's see.
My pleading application.
We'll consider it, you will allow you to participate in the proceeding. You are the beneficiary.
No, they are the rival claimant.
At the time of acquisition also, my lord, land was standing in my name. Till today, my lord, land is standing in my name.
There are four.
And, my lord,
Who are the petitioners then?
petitioners is not, they claim to be purchased
No,
from Dominic. My lord, from whom, my lord, they have, my lord, the unregistered power of attorney, they have stated to have taken, and my lord, they registered the sale deed.
No.
But in fact, 2005 itself, he, my lord, expired.
There are four claims, my lord, the son, daughter, and wife, and the petitioner.
Yes, so the request of
2 to 4.
2, 3, and 4.
serial number
29.
29.
29.
2 to 4, call next week.
30.
1 var saka,
2 weeks, my lord.
call after 2 weeks.
Late my pleading application.
Irli,
I
barutta.
file my objections also. my lord.
It's all right, let's see.
Adavissayya, B, number 30. Petition 29 to my lords. This, with respect to office objection 2 is concerned, when the award was passed, respondent to 3 office was in Bangalore, my lord. Now they are in Tumkur. That is the only office objection, my lords. Remaining office objections I have complained.
Consent award ಏನಪ್ಪಾ? ಅಲೋ ಮಾಡ್ಬೋದಾ?
ಇದರಲ್ಲಿ
Private respondent.
Lordship passed an order on 25/6/24, WP 9066 of 24. Same properties ಗೆ private respondents ಗೆ dispense ಮಾಡಿದ್ರೆ.
Dispense, I will file a memo.
Total dismiss ಆಗಿದೆ ಅಂತ. In terms of that, your lordship, they can file a memo to dispense in notice to others. Will also accepted and pass order on 25/6/24.
red petition ಅಂದ್ರೆ? Red petition number
9066.
9066
of 24.
9066 of 24.
25/6/24 DD.
ಬರ್ಕೊಂಡ್ರಾ?
25/6/2020.
In terms of that.
Yes, my lords.
Memo okay.
I will file.
Disposed. ಇದಕ್ಕೆ ನೋಟಿಸ್
Filed ವಕಾಲತ್ already.
ಹಾಕಿದಿರಲ್ವಾ?
R1 government.
R1 AGA,
R2 and R3.
3 years.
PV Chandrasekhar, notice to other respondents dispensed at the risk.
I will file my notes.
Yes, disposed.
Sir, memo ತಗೊಳ್ಳಿ sir. 31, Rakshita DJ.
Paper on 3 and 4. My name has been wrongly taken as Gopinath, my lord. It is just GA Gopi, my lord.
I'll serve a fresh copy on now this, sir, as well. I'll serve a fresh copy. my
You
lord.
couple with the office objection, man.
Please, my lord, I'll do that.
1 week to do the need.
Please.
My name may be rectified, my lord.
So and so file Sokalakshma untext to appear for so and so.
Much.
GA Gopiniya,
House.
Gopinath alla.
Illa.
Yes.
Good night.
Office registry to is direct, registry is direct.
Copy no now,
The name
direct,
of
sir.
GA Gopi as the advocate for
Authority.
point number 2 and 3, 2 and 4.
My lord.
2 and 4.
32, Arjun. 33, Nagesh.
1 week to do the need.
34, Nagaraju.
All the respondents are served, my lord. Respondent number 7 is also served. By way of hand summons.
Yes, who appears for respondent 3 and 4?
1 to 6, my lord, directed
Yes, Karthikeyan.
Karthikeyan to file wakalat for 1 to 6, respondent 1 to 6, because they are all the officers of BDA.
Yes, where is Karthikeyan? 3, 4 appear ಆಗ್ತಿರೇನಪ್ಪ?
3 ಗೆ ರಿಫ್ಲೆಕ್ಟ್ ಆಗ್ತಾ ಇದೆ, 4 ಗೆ ರಿಫ್ಲೆಕ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ ಕಾಸ್ ಲಿಸ್ಟ್. 3, 4 are the officers of BDM.
What about 7 and 8?
7 and 8 are served. 8 is filed as wakalat, but is not represented. 7 is not filed as wakalat. He was served on 18th of July.
Yes, let them come. We'll give 1 week time.
Date maybe.
Roster change agata. And fix a date. The request of respondents call next week. Let us.
They're trying to alienate, my lord. Respondent number 8 is now trying to alienate the same land to the third party.
Case Mohit Kumar.
Put in 1 second.
The petition scheduled property, my lord, was allotted to me.
Hmm.
Possession certificate is issued. Lease cum sale agreement is executed.
Hmm.
Thereafter, my lord, they execute a sale deed in favor of respondent number 7
Hmm.
in respect of the same site. On the same day, respondent number 7 executes a sale deed in favor of respondent number 8. On the same day, my lord.
Next, first day or
Yes, parties are directed to maintain status quo and respect to the property which is the subject to writ petition till next date of hearing.
Please, Thursday.
At the request of respondents, at first at the request of respondents, call next week on the Madi, then interim order.
Please.
Yes. 1 week to do the need for 35.
35, Sharan and Majge.
Petitioner, my lord, the matter pertains to general award.
Yeah, complain ಮಾಡಿ office objection.
ಅಲ್ಲ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನಂದ್ರೆ there was a double pagination ಆಗಿದೆ ಅಂತ ಜನರಲ್ ಅವಾರ್ಡ್ ಪೇಜ್ ನಂಬರ್
ಮಾಡ್ಬೋದಾ? Okay, office objection kept open. ಯಾರು?
Government V surety.
So also accepts notice for respondent number 1, 2 and 3.
HL Pradeep Kumar.
Pradeep Kumar.
Yes, general award to consent award. The land
Great.
all ನೋಡ್ಕೊಂಡು ಮಾಡಿ.
grateful.
36, Chandrasekhar HB.
Similar matter, my lord, sorry. Matter of general award, my lord.
Good.
Copy serve ಮಾಡಿದ್ದಾರೆ ಸುಮ್ಮನೆ.
HL Pradeep Kumar.
HL Pradeep Kumar. Serve ಮಾಡಿದ್ದಾರೆ. They served a copy to us. ಸರ್ ಅದು ಮೊದಲಿಂದ ಹಳೇದು matter. ಹಳೆ matter.
Government V surety.
ಈಗ ನೀವಿಬ್ರು ಜಗಳ ಆಡಿದ್ರೆ ರಾಮಕೃಷ್ಣ ಅವರು ಆಯ್ತು ಚೆನ್ನಗೌಡರು ಇರ್ಲಿ ಬಿಡಿ.
C Chennaigoda.
For R2. General award to consent award.
C Chennaigoda R2 and R3.
R2 and R3 ಇಲ್ಲ, R2 ಅಷ್ಟೇ ಅಲ್ವಾ? R1 AG.
Government
Yes.
may be disposed of.
Disposed of. Prosecutions kept open.
Great.
37.
Next ರಾಮಕೃಷ್ಣ ಕೊಡೋಣ ಅವನು.
Naganand.
I believe the date given was 1/8. We got some information from the connected writ petitioner that their senior is not available.
I would not have given date at all.
No, Lord, on that day it was called out before the in-charge court.
ನೋಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಏನಿದೆ? ಮತ್ತೆ ಯಾಕೆ ಇಷ್ಟ ಆಯ್ತು?
connected matter.
No, post the matter on 1/8.
Right.
38 CS Madhu.
For petitioners, my lord.
CS Madhu.
For petitioners, my lord. Lord, I have challenged the notification passed by the respondent authorities acquiring my land for the purpose of laying 4-lane road, national highway, my lords. The first writ petition was filed on the ground that no description of the property was given by the respondent authorities in the
Yes,
notification.
ready, both of you? Are you ready?
Yes, Lord. For respondent 2, my lord.
And in the second writ petition, I have challenged the correctness of the road constructed, my lords, on the basis of change in alignment, my lords. This honorable court has appointed court commissioner and he has submitted a report stating that there is a change of alignment for about 30 meters from the original plan, my lords. So because of change of alignment, my residential house, cow shed, and my temple as well as borewell is gone, my lords. So on the basis of that, I have challenged this.
So this is not for some industrial area or for residential area.
I agree, my lords.
This has been acquired for the purposes of formation of a road.
True, my lords.
So, I don't see any reason to entertain the writ petition. Only thing is, he will be entitled to adequate compensation.
Let's
If they have not surveyed the area properly, we can issue direction to them to survey the area and pay you the compensation.
My lord, for the survey is concerned, we have done the survey and we have deposited 2 crore amount for its structure only, and for land we have already deposited with the competent authority. For land as well as for the structure.
Then what remains? We'll give you the liberty to seek for enhancement of compensation if you feel that the compensation is inadequate.
My lords, the very notification itself is incorrect, my lords. No description of the property given, my lords, as per the guidelines laid down by the Honorable Apex Court in competent authority against Bengaluru Jute Factory and others, my lords. Lords, notified land was something else and acquired land is something else, my lords.
How
Both
do
are
you
different,
prove
my
that?
lords.
How do you prove that, sir?
Lords, this Honorable Court has appointed court commissioner and he has submitted report to this Honorable Court, my lords.
Yes, where is it? Where is it?
And it is in court file, my lords, page number 6 of the compliance memo filed by the court commissioner, my lords. As per the preliminary and final notification, 86/3 is also included, my lords.
So what is the area that has been encroached according to you?
Lord, the alignment has been shifted from northern side to southern side to northern side, my lords.
So ABF is the area utilized without acquisition.
Yes, my lords. ABEF is the now the ongoing road, my lords. Now my property lies in between.
Now, do you own the area between DHGC?
Yes, my lords. Yes, my lords.
You own DHGC also and ABEF also?
Yes, my lords.
You own both?
I own both, my lords.
So you virtually own the plot between ABHG?
ABHG, yes, my lords.
Okay. Huh?
And a little portion of the land belongs to someone else, which is 86/4, my lords.
That's okay. Now, what is the area acquired or area left out?
My lords, 81 guntas have been acquired, my lords. There is no change in the acquisition extent, my lords.
Sir, what is the area between AEFG, FB and DHGC? Which is more?
I'm sorry, my lords, I have not calculated, my lords. I may be given 1 day's time, my lords. I will file objections, my lords.
No question of objections over here. Okay, we'll just dispose it all.
Kindly have it tomorrow, my lords. I will physically appear before your lordship and try to convince my lord. Kindly have it tomorrow, my lords.
Day after tomorrow.
Please, my lords.
The request of parties called day after tomorrow, date for it.
Grateful.
Samit. This matter pertains to National Highway acquisition, my lords, along the Shimoga-Mangalore Highway. Now, my lords, what has happened is they have notified the entire town as Uru without designating the survey numbers or the Khata numbers or any number. I do not know, my lords, what portion of my property is being acquired. Now, the officials, my lords, are coming to the properties every other day. They're marking the properties, my lords. Now, my only apprehension is this. I do not want to come in the way of the acquisition itself. Let them give me compensation. Let them notify what portion of my land is going to be acquired. If your lordships kindly sees the notification itself for a moment, my lords. R4. The notification, I have annexed it, Annexure D, page 31 of my first writ petition, my lords. If my lords are having one, sorry, my lords, if your lordships can take 14753 of 2024.
Notice or
39.1.
notice. Notice we are not received any response number 4. We are the contested of the land acquisition.
Adu AGA was supposed to take the notice, my lords. We have served the AGA.
I am the applying for National Highway Authority. Respond number 4. 4 marks.
State SLA.
State SLO.
Number 2.
Is not.
So accept notice for
P.
responding.
Prasad. P. Prasad.
If your lordships
P. Prasad.
sees page 31.
Page
31, my lords.
Hmm.
Adralli, at the bottom right corner, my lords, Grama Tuduru, serial number 24, Uru. It just says Uru, Samanya Kasagi / Sarkari, and the total extent is mentioned. What portion of whose extent is going to be acquired is not mentioned, my lord. Neither the Kata number, assessment number, or any of those numbers are not mentioned.
Now, which
My,
is your,
I am all of these writ petitions, my lords, fall within the Tuduru Ur limits.
now which is your Uru?
The Tuduru, my lords. Grama is Tuduru. It is at the very top. If your lordship sees,
Top it is big only.
just in gray color, it is highlighted, my lords, at the bottom right corner. Tuduru, Grama Tuduru.
Survey number mention agidala.
Survey number ಆದ್ಮೇಲೆ ಕೆಳಗೆ last ಗೆ, if your lordships kindly sees 24, serial 24, it merely mentions Uru. All these writ petitions, my lord, are challenging whoever comes within the town limits, my lords. They have not mentioned, although the survey is being undertaken by the National Highway authorities, no extent is forthcoming as for insofar as the area that is going to be acquired of a particular person or a particular owner.
Okay, let them file their objections.
Now, my lords, my only apprehension is let them not proceed with the acquisition until at least they mention what is the area that is going to be acquired.
No,
This is
it
the
is
fourth
not a-
time it is coming up before this
See,
honorable
I
court.
tell you,
lords.
similar matter.
ಇದರಲ್ಲಿ copies or ಮಾಡಲಿಕ್ಕೆ
Where
file mags.
land was utilized illegally.
Yes, yes.
Okay. In the sense it was not part of the notification.
Yes, please.
But they utilized the said land not in NHI matter, in KDB or BDA matter.
Yes, please.
In BDA matter it was. Where they had utilized, the allegation was land has been utilized for formation of road without
Acquisition proceedings.
acquisition proceedings. I did not strike it down because it would serve no purpose at the end of the day. But I said a survey has to be conducted. And if it is found that they have utilized the land without acquisition, then compensation has to be fixed as on the date of the survey. Not as in the date of issuance of preliminary notification, because that part of land was not part of
covered in the
preliminary notification. So I said as on the date of survey, that takes care of your interest.
maybe observed that in the event.
Let them file their objections. Let
What
them-
has happened, my lords,
let
my
them
only
clarify what
apprehension
that-
is
what do you
this.
mean by Uru and how they can come up with that Uru concept. Is it valid in law?
In fact, my lords, I had passed on the judgment passed by the coordinate bench, if I may just pass it on once again, my lords.
Then objection, then I have to.
What has happened is, in a similar case, my lords, Hodalkere Uralli, they had passed a similar order and the entire notification came to be quashed. It is as of March 24, if your lordships kindly turns to.
Yeah. So, you need to be practical also at the same time. See, you quash the notification, you are putting.
No. Therefore, my first submission is that, my lords, I do not want to come in the way of the acquisition process. I do not want to come in the way of the acquisition process. My only apprehension is that, my lords, without actually notifying that this is the portion of area that I am going to be acquiring, let them not proceed with the survey or any other activities.
Proceed with the survey.
Very well, my lords.
But the point is, let them explain how they can say just Uru and leave it at that.
Yes, please.
It should be alignment with the sketch and other things.
We have to pursue the records.
Yeah. When you notify, it has to be notified properly.
We'll see that, Your Honor.
Because you call for objections, right?
Yes, please.
Uru ಅಂತ ಹೇಳಿದ್ರೆ ಊರಲ್ಲಿ ಇರೋರೆಲ್ಲ ಬಂದು objection ಹಾಕ್ತಾರೆ.
Survey number alignment also will be shown, rough sketch.
No. See, what happens, that doesn't come out in the newspapers.
Yes.
In newspaper, survey numbers are mentioned. Survey numbers ಜಮೀನಿಗೆ ಸರಿ ಹೋಗ್ತದ.
Yes.
See, ಅಲ್ಲಿ ಗ್ರಾಮ ಇರುತ್ತ.
ಹೌದು ಸರ್.
ಗ್ರಾಮದಲ್ಲಿ ಹೈವೇ ಹೋಗುತ್ತೆ. So, you demolish it. Okay. So, ಅಲ್ಲಿ ಊರು ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಅಲ್ಲೊಂದು
Identification of property numbers.
Numbers, Tata number, Kanishkumar.
Gram Panchayat.
You should have always scheme wherein some
Identification is
required. Who will come and file objections? ಊರ್ ಅಂತ ಹೇಳಿದ್ರೆ ಊರಲ್ಲಿ 1000 ಜನ ಇದ್ರೆ 1000 ಜನ ಬಂದು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕಾ ಗ್ರಾಮದಲ್ಲಿ?
Nobody can anticipate how it passes.
10,000 ಜನ ಇದ್ರೆ 10,000 ಜನ ಬಂದು ಹಾಕ್ಬೇಕಾ? ಅಲ್ವಾ?
Yes, please.
Where
How
it is
can you
proposed.
sustain such a notification? Such notification cannot be sustained.
True, man.
Only thing is, national highway should not be held up. I am taking this view.
Yes, please.
I am taking this view.
It should indicate through which area it passes through. So who are the affected person in that?
Probably Uru will have to go.
Yes.
I'll issue a direction, you conduct a survey
Yes.
and say which are the properties that are being acquired.
Yes, please, Your Honor.
And compensation has to be paid as on the date of making that survey and publishing that numbers.
I file my objections.
Okay.
Yes, please.
So, can you sustain the notification when you simply say Uru? ಎರಡು ಕಡೆ ಹತ್ರ ಆಗಿದೆ ಇದರಲ್ಲಿ.
Right. I'll pursue that record. Note, sir.
ಒಂದು ಕೂದೂರು, ಇನ್ನೊಂದು ತೀರ್ಥಹಳ್ಳಿ. ಆಮೇಲೆ ಇದೇನ್ ಮಜಾರೆ ಸಲಕೊಪ್ಪ ಅಂದ್ರೆ ನಡೆಯುತ್ತೇನ ಮಾಳೂರಲ್ಲಿ? ಏನ್ ಮಜಾರೆ ಅಂದ್ರೆ ಏನು?
It's one of the villages, more than 10,000 people, Majra is a, apart to the, some other villages, Majra, there is a, including that another village. It's a small population.
See, this notification is issued in pursuance of section 3, ಏನ 3C na?
3G. 3G.
3A, man. 3A.
3A.
3 capital A.
Is already.
See, 3A is issued to notify the owners to file their objections.
Yes.
Because 3A subsection 2, my lord, says every notification shall give a brief description of the land.
Exactly. And the reason is sometimes, if it is thickly populated, they can come around and say, it is thickly populated, you change the alignment. Because there are so many other areas that also has to be considered, vacant areas, farmlands, you can just, agricultural lands, you can, the highway can pass through it.
Yes, sir.
There have been instances where you have changed it. See, putting a road in a village doesn't make sense. Demolishing already built up houses and disturbing their lives and all that. You can change the alignment.
Let's check.
Correct.
Right.
It should facilitate them to file their objections, no?
Yes, please.
Yes.
At least, my lords, some protection, my lords. Let them not. What happens is National Highway authorities proceeded.
Right.
Very good.
The case of the petitioner is that ಎಲ್ಲಾದ್ರಲ್ಲೂ ಇದೇ ಪ್ರಾಬ್ಲಮ್ ಇದೆಯಾ?
Yes, my lords.
All the writ petitions?
All the writ petitions, my lords, 11 writ petitions before your lordships, ಎಲ್ಲದು ಊರು ಅಂತ ಹೇಳಿ ತೋರಿಸ್ತಾರೆ.
ಎಲ್ಲ ತೂದೂರದ?
ತೂದೂರ್ದೆ, ಎಲ್ಲ ತೂದೂರ್ದು. One single gram.
Okay. The case of the petitioners is that they are residents of Tuduru village. ಯಾವ ತಾಲೂಕು? Tuduru.
Tuduru village, Tirthalli taluk, Shimoga district, my lords.
Tirthalli taluk, Shimoga district. Full stop. The National Highway authorities are contemplating construction of a highway between Shimoga to Mangalore.
Shimoga to Mangalore highway.
Shimoga to Mangalore
highway.
And in the process,
That's point number 4.
they have expressed their desire to acquire properties in Tuduru village. It is submitted that the notification issued under section
3A, my lords.
3 capital A
Clause 2.
of
The National Highways Act, my lords. National Highways Act 1956.
National Highways Act 1956. 3A no 3C? 3A.
3A
National Highways Act 1956 does not identify the exact properties that is sought to be acquired in the village, but it simply mentions but it is mentioned as, but the property sought to be acquired is mentioned as Uru, single inverted comma, meaning city, ಅದು ಊರು ಅಲ್ಲ, ಅದು ಹಳ್ಳಿ ಅದು actually.
ಹಳ್ಳಿ
Is mentioned.
City, meaning city. In brackets to be construed as village, brackets close. Full stop. For that reason, it is submitted that the petitioners are not aware whether their properties are going to be acquired or not. And they are not in a position to file their objections.
We have given representations, my lords, to give clarity.
They are not in a position to file their objections
File an
to the
objection.
to the acquisition proceedings, Full stop. It is further submitted that without any clarity of the property being sought to be acquired, which are being sought to be acquired, the National Highway authorities are
Point number 4 maybe specifically.
my respondent number 4 is marking certain areas, surveying and marking certain areas in the city, in the village. Full stop. Next part. For the aforementioned reasons, respondents are directed not to dispossess the petitioners from their properties till next date of hearing, if they are not already dispossessed.
Respondent number 4 specifically, they are the one who is taking, no other respondents.
ಯಾರಿಗೊತ್ತು respondents ಅಂತ ಹೇಳಿ.
4 and ಯಾಕಂದ್ರೆ ನಾಳೆ suppose some all will be brought in contempt, man. Kindly make it respondent
number 4.
Submission. Directly kindly to serve the copy of the petition. I have not received any.
Copy.
I will serve all
From
copies.
my name, P. Prasad for.
So and so access notice for respondent number 4.
P. Prashant.
Prasad.
Grateful, my lords.
Yes, call after 2 weeks, objections if any by that.
40 R. Badrinath.
Number 40.
Paper petition. Seeking for writ of mandamus. Well, the respondent has allotted me a lease cum sale agreement in the year 1993. Respondent number 1 has allotted me a site in.
Yes, ready?
Ready, my lords.
Yes. Hello.
The respondent 1 has allotted me a lease cum sale agreement in the year 1993. On 6/1/1993, annexure E, page number 33. Where I had filed the writ petition.
1 second. Site on?
Writ petition is filed on.
No, site, when was it allotted?
Lease cum sale agreement on 6/1/1993. Annexure E, page number 33.
Okay.
And I had filed the writ petition on 29/7/2017.
WP?
Writ petition on 29/7/2017.
29?
7/2017.
For what?
For writ of mandamus.
For?
For consider my representation to execute the sale deed.
Consider on order ಆಯ್ತಾ?
Where the respondent 1 has executed a sale deed in favor of respondent number 2 on 22/2/2019.
On?
22/22 February 2019. Respondent number 2 executed a sale deed in favor of respondent number 3 on 14/8/2019.
(14/8)
2019. I am seeking during the pendency of the writ petition, the respondent 1 and 2 and 2/2/3 as executed the sale deed. I am seeking for alternative to quash those sale deeds also. But the pendency where they,
So 2 and 3.
they have been served and represented.
My lords, sir, may I draw my lordship's kind attention?
How
to
can you
annex-
dispense with notice to R2, sir? It's important. ಬದ್ರಿನಾಥ್ ನೀವೇ ಹೇಳ್ಬೇಕು. R2 ಯಾಕೆ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿಸ್ಕೊಂಡ್ರಿ? ಅವ್ರಿಗೂ ಸರ್ವಿಸ್.
There is no dispense. The R2 has sold the property to R3.
Correct. But see, if we set aside the sale deed to R2, R3 can.
See, R3 has been stepped into, R2 has been stepped into the R3.
Sorry.
Lords, may I draw my lordship's kind attention to annexure C, my lords. In page number 25, which is the power of attorney that has been, the petitioner is the power of attorney holder of the original lot.
Who is the original lot?
Ramasubbaya.
Okay.
The petitioner is the power of attorney holder.
Hmm.
Lord, sir, the power of attorney does not have any powers to sell the property, my lords. To sell the property.
Fine.
My lords, and also the power of the attorney that is being given under this, under the power of attorney, my lords, under the GPA, he says that he is of ill health. He is of ill health and aged as on that day itself, my lords. We have credible information that Ramasubbaya was never, never made the application because he was dead even before the application was made.
When did Ram Subbaya die?
No, he is not died. He is alive. As on date of writ petition, he was alive.
Now?
And now he is.
My lords, there was a police complaint under criminal miss 8 of 2012, wherein in 1978 itself Ramasubbaya has passed away, my lords. The power of attorney is the year 1993, subsequent to the death of Ramasubbaya. And also, my lords, if I may draw my lordship's kind attention.
Lakshmi Kantamma is alive?
Huh?
Lakshmi Kantamma is alive?
Wife of
she
the
is alive.
petitioner.
She wife.
Wife of the petitioner. The power of attorney holder sells the property in favor of his wife, wherein the lease cum sale is executed in the favor of Ramasubbaya. And Ramasubbaya himself, we have credible information that there is a police complaint that he was already dead.
That is created by the respondent number one here.
Created or not created, will have to be.
That is,
It's a matter
those
of mixed
documents
fact
have
of
been
trial.
with the respondent
And
number one.
facts, my lords.
Without considering, when his Ram Subbaiah is alive, his death certificate is not been produced by the respondent number one. Where at any point of time, I had not produced a death certificate of Ram Subbaiah at any point of time.
Produce now. I'll issue direction.
My lords, may I draw my lordship's kind attention to annexure M, ink page number 73, my lords.
Till I get the conveyance date, I could not execute the sale. By mistake, it has been done by in favor of my wife. By oversight, it has been done. Which
By
the
oversight, what has been done?
sale deed till the Ram Subbaiah itself has been not executed a lease cum sale deed by the respondent number one. I could not be executed in favor of petitioner number two. That has been by mistake. That it is no sanctity in the eye of law. Where the respondent number one has.
Sir, he is Ram Subbaiah alive or dead?
Now he is dead as on date of.
Then you have to implement his legal heirs. The power of attorney dies with.
His wife is there, madam. Wife is on the record.
Whose wife is there?
Ram Subbaiah's wife is there.
It is not Ram Subbaiah's wife.
She has not given the power of attorney order.
She is Janaki Raman's wife. GP holder's wife.
GP holder's wife. Respondent number two is also a necessary party, my lords. They also have to be heard, my lords.
Badrinath. Land is allotted to Ramasubbai.
Yes.
During the pendency of lease cum sale agreement, he alienates the land in favor of Lakshmi Kantam. Okay.
No, my lords. If I may clarify, my lords. Ramasubbayage allot agats. Ramasubbayya gives the power of attorney to the petitioner, Janaki Ram. Janaki Ram executes the sale deed in favor of his wife.
See, lease cum sale agreement is executed by BDA in favor of Ram Subbaiah.
Yes.
Ram Subbaiah gives GPA to Janaki Raman.
Yes.
Janaki Raman executes a sale deed in favor of Lakshmi Kantamma, his wife, his own wife. Okay, now that sale deed is invalid.
Yes.
Because
power of attorney goes.
Because BDA had not yet executed the sale
deed.
So that's an illegal sale deed. So Lakshmi Kantamma does not have any right, title or interest over the property concept. Okay. Now it is only open for Ramasubbayya to pursue the matter with BDA. Okay, he has given general power of attorney in favor of Janaki Raman, and Janaki Raman pursues the matter with BDA.
Yes.
But later Ram Subbaiah dies.
Yes.
Okay. Yes. The moment Ram Subbaiah dies, when did he die according to you?
1978 minutes.
No, it's not
I nim prakara re, our prakara bada.
In the year 2018, 19 or 20 he had died.
Hi, Ram Subbaiah dies. The moment Ram Subbaiah dies, the GPA also dies. Okay. The moment GPA also dies, writ petition also dies, unless you bring legal heirs of Ram Subbaiah on record.
Without executing the lease comes, GPA has been gone, I'll agree.
Sir, GPA dies with Ramasubbayya's death. Let us presume for a minute Ramasubbayya died in the year 2017 itself, 2018 itself, after filing of writ petition. You have to bring not your wife on record, but you should bring Ramasubbayya's legal heirs on record. Lakshmi Kantamma or Janaki Raman does not get any right, title or interest over the property concerned. That is the law. You want time, I will grant time.
Day after tomorrow, I'll.
The request of petitioner call out for 2 weeks. ಹುಡುಕಾಡಿ ನೋಡಿ ಏನಾದ್ರು ಕಸರತ್ ಮಾಡಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ವಿಲ್ ಡಿಸ್ಮಿಸ್ ದ ರಿಟ್ ಪಿಟಿಷನ್ and none appears for the purchase.
When the writ petition pending, they had been alienated.
Yes, so what?
41. MS Nagaraja, Harish NNHL, Pradeep Kumar.
Therefore, respondent number 3 in this matter.
Yes, sir.
Last occasion, my lord, Lordship has directed me to get the instructions from the first respondent, whether it was accepted. The beneficiary is, my lord, is not ready to pay the compensation, he is not required
I'll
for.
make my submission regarding that. Although, 63 square meters of land there, although it is remaining in the petitioner's, out of the petitioner's land, and the petitioner is seeking compensation in respect of that. So that portion actually, even BMRCL does not require it, therefore I had.
But you take, acquire that land, we will direct you to acquire that.
I think an order may be passed, but then, I'm not saying that I have conceded.
Yeah, I'll not say you are conceded.
I had, of course, given a proposal to my learned friend, because my instructions were that if the petitioner is willing to sell the land by way of a sale deed, so I had put it across to my learned friend. I don't know that is. Instead of acquiring, then solution only public money will be saved. That was the thinking. Therefore, I leave it to this honorable.
Maybe take it on Monday, my lord. My friend has given some proposal. They said that maybe we are going, we'll ask them, my lord, because their land is acquired, my lord. Remaining portion also acquired in second notification.
He has given you some proposal, consider it. At the request of parties, call next week.
29th.
29th, roster change ಆಗತ್ತೆ ರೀ. I don't want to
Date
unnecessarily.
ಕೊಡಕ್ಕಾಗಲ್ಲ. Next week.
Next week.
ಇಲ್ಲಾಂದ್ರೆ ನಾಡಿದ್ದು ಹಾಕ್ಸ್ಕೊಳ್ಳಿ, Thursday ಬೇಕು.
2 ದಿವಸದಲ್ಲಿ ಏನಾಗುತ್ತೆ? Next week ಹೋಗಿ ಬರ್ರಿ. Next week.
Any date, it's understood.
I don't want to give a date only because the roster changes.
Yes.
Otherwise, I would have given a date. So that's the reason. Yes, the request of parties, call next week.
B. Vachan, Janardhan ji.
Yes, sir.
For 2 weeks' time in this matter.
May I make one request? Land has been acquired 2003. Land has been acquired in year 2003. But we have surrendered our value without raising objection. And the compensation has been apportioned because the brothers into the reference to the court. But from that date, we are requesting to grant the incentive scheme on the side, but that they are not doing. You are almost 12
I
years.
shall make my submissions securing instructions.
Almost 12 years are over, still they are not considered.
Sought for,
Policy ಏನಿದೆ ಮಾಡಿ ಇದೆ next week.
Please.
No further agenda.
sought for mandamus, my lord, regarding to intention. 3 sites, they were sought for 3 sites, my lord. That regard, my lord, BDA should say.
You'll have to say, at the request of respondents, call next week.
Please.
4. Vijaya PK, Siti Basuraj. 44. Ramesh Gowda.
ಯಾವ್ದಿದು?
Vijay, 44,
Vijay B.
petitioner, yes. Petitioner, my lord.
HT Basuraj.
Lord, for the last 2 hearings are not coming. In this case, I'm not allotting.
ಕೊಡಿಲ್ಲ. Order sheet ಅಲ್ಲಿ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ will direct someone else to take notice. ಯಾರು? ಯಾರು respondents?
BDA.
The advocate for the respondent BDA, it is seen from the order sheet that the advocate for respondent BDA has been absent continuously. For that reason, full stop, for that reason. ಯಾರಿದ್ದೀರಪ್ಪ BDA?
HT Basuraj.
ಅಲ್ಲ, ಕಾರ್ತಿಕೇಯನ್ ಇದಾರಲ್ಲ.
VDA.
Just sometime back.
ರೀ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ರಿ ಮಾಡೋದು?
Girish is also here.
ಕಾರ್ತಿಕೇಯನ್ is here, you will take note. So and so accepts notice for, is directed to accept notice for respondents. For one copy, sir, ಮಾಡಿ, call next week.
Kindly give a date, ma'am. Usually, we are not allottees. The property was given to us.
See, I would have
as a
given a date,
compensation.
but for roster being changed, that's the reason, yes.
45. Mohan Kumar N.
My lord, I appear for respondent. My lords may kindly pass over. Counsel on record is on his legs.
Pass over.
Great.
46. Gautam V. Gowda.
Not appearing for petitioner, my lord.
This petition is regarding cancellation of allotted site, my lord. In fact, the petitioner has already paid the amount with interest, my lord.
They have served some more file ಮಾಡ್ತಾರೆ.
Lord, at page number 28, my lord, Annex G, my lord. The entire amount has been paid and they have prayed for to pay.
Plus, it's been cancelled, my lords, because they did not pay it in time. It was cancelled.
How have you treated similarly situated persons?
Lord,
They don't pay, my lords, so how do I? It's the procedure which I had to follow, my lords. They have not paid it. so therefore
ಓಕೆ
they-
ಬೇರೆಯವ್ರಿಗೆ ಏನಾಗಿದೆ ಇವಾಗ ಯಾವಾಗ ಕಟ್ಬೇಕಿತ್ತು ಯಾವಾಗ ಕಟ್ಟಿದ್ದಾರೆ?
my lord, 2019 December 15 ಕಟ್ಬೇಕಾಗಿತ್ತು ಸ್ವಾಮಿ. ಕೋವಿಡ್ ಔಟ್ಬ್ರೇಕ್ ಇಂದ ಮತ್ತೆ ಇವ್ರು ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿಲ್ಲ ಪಿಟಿಷನರ್ಗೆ. ಅದಾದ್ಮೇಲೆ ಇಮಿಡಿಯೇಟ್ 6 monthsಗೆ ಪೇ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. 6/6/2020 ಪೇ ಮಾಡಿದ್ದಾರೆ. ಅದಾದ್ಮೇಲೆ ಇಂಟ್ರೆಸ್ಟ್ ನೋಟಿಸ್ ಬರುತ್ತೆ. ಇಂಟ್ರೆಸ್ಟ್ ನೋಟಿಸ್ ಇಸ್ ಆನ್ 15/9/2020. Then after lapse of 2 years, my lord, that is on 29/7/2022, the respondent number 2 issues cancellation of allotment, my lord.
That is after payment.
After payment of interest, my lord. They had called us for.
Paid all the payments.
Yes, my lord. They had called us for execution of lease cum sale deed, my lord. On that day, they issue the cancellation letter to us.
ಇವಾಗ how can you do it?
Lord, there is the supportive findings by the honorable state also.
There is this one ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. There is a.
We will allow it.
More.
You charge furthermore interest if anything has to be paid.
Lords may have it on Thursday. Day after tomorrow. ಒಂದು ಮೆಮೊ ಕೊಟ್ಟಿದ್ದಾರೆ ಇವಾಗ.
ಆಯ್ತು, ಡೇಟ್ ಚೆಕ್ ಮಾಡಿ.
ನೋಟಿಫಿಕೇಶನ್ ಒಂದು ಇದೆ ಅಂತ ಸ್ಟೇಟ್
ಆಯ್ತು,
ಕನ್ಫರ್ಮ್ ಮಾಡಿ.
request of respondent called day after tomorrow.
25th. I may be extended.
Remote revenue is extended till next date of hearing.
47 Narendra Gowda.
Mandamus to consider annexure A and B. The petitioner's land was acquired for Hemavati Reservoir. And they, under the rehabilitation scheme, the land was allotted in survey number 35/3 of Kerodi village. Then my lord, one of the first petition made a representation to cancel his grant and made a grant in favor of his brother, second petition. As per his request, my lord, the grant has been made. Till today, my lord, Podi and Durasti, nothing has been done. Hence, I request to consider representation.
We have granted, my lord, land, my lord. Kindly see, my lord.
Annexure grant has been made.
He
As
is
per
not
annexure C.
disputing the grant. He is saying do.
We are not disputing the grant.
Please, my lord. 4D is concerned, no, now they're seeking, my lord, the other land should be given. Kindly see, my lord, page number, my lord, 15. May I read, my lord? The granted, my lord, 4 acres land is granted.
Yes, 4 acres land is granted. I am seeking only.
Second representation says that your other land will be granted. ಬೇರೆ ಲ್ಯಾಂಡ್ ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾ ಇದಾರೆ ಅವರು.
ಇಲ್ಲ 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 ಇದನ್ನೇ ಕನ್ಫರ್ಮ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಸೆಕೆಂಡ್ annexure D is the grant certificate, but till today, my lord, they have not taken.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ ಗ್ರಾಂಟ್?
4 acres.
4 acres.
We'll allow it.
Consider representation, my lord. Only sought for the mandamus regarding the consider that.
Do podium durasti, no?
Please.
The case of the petitioner is that he is a land loser for Hemavati Reservoir project.
Please.
For Hemavati Reservoir project. And
under rehabilitation scheme.
He has been allotted 4 acres of land in survey number.
In survey number 9 of Ebbanhalli village, Belagodu Obli, Sakleshpura Taluk.
Survey number 9 of
Ebbanhalli village.
Ebbanhalli village.
3 ಅಂತ ಇದೀರಾ?
ಇಲ್ಲ ಇಲ್ಲ Ebbanhalli village. Annexure D.
16 ಅಲ್ಲಿ ಇದೆ. Page 16.
Of Hebbanahalli village.
Ebbanhalli village, Belagodu Obli, Sakleshpura Taluk.
Belagodu Obli, Sakleshpura Taluk.
To an extent of 4 acres.
In survey number 9.
ಏನ್ಮಂತೇಳಿ ಬಿಗಿನಿಂಗ್ ಇಂದ ಹೇಳಿ. His family is a land loser. His joint family is a land loser. His joint family is a land loser. Sakleshpur Taluk, full stop. That he has requested the authorities to consider the, to allot the said land in favor of his elder brother, one Nanjagowda.
Nanjegowda. So petitioner, second petition.
Second petition.
That is the second petitioner here. Second petitioner, ಸರಿ ಬರ್ಲಿಲ್ಲ. ಮೇಲ್ಗಡೆ the case of the petitioners is ಅಂತ ಮಾಡ್ಬೋದು. The case of the petitioners is the, ಏನ್ ಅಂತ ಹೇಳಿ, the case of the petitioners is that their joint family are land losers, that their giant family are land losers, and they have been allotted, and petitioner number 1 has been allotted. Full stop. That the first petitioner has requested the respondents to allot the land in name of his elder brother, the second petitioner herein. Second petitioner herein, in brackets, Shri Nanjagowda, brackets close. Instead of his name, brackets close, instead of himself. Elder brother antira, but 60 years ತೋರಿಸ್ತೀರಪ್ಪ. ನಿಮಗೆ 63 years ತೋರಿಸ್ಕೊಂತೀರ.
Elder is Krishnegowda and younger is Nanjegowda.
ಇಲ್ಲಿ ನನ್ನ ಅಣ್ಣ ಅಂತ ಬರೀತೀರ. ನನ್ನ ಅಣ್ಣನಾದ ನಂಜೇಗೌಡ ಅವರಿಗೆ. ನಿಮ್ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ನಿಮ್ಗೆ 63 ವರ್ಷ, ನಿಮ್ಮ ಅಣ್ಣಂಗೆ 60 ವರ್ಷ. ಏನ್ ಸರಿ ಸೆಂಟೆನ್ಸ್ ಹೆಂಗ್ ಬಂತು? Elder brother in the name of his brother, second petitioner here, instead of himself, and also to conduct Podi and Durasti. Podi and Durasti of the said land. Full stop. In spite of the said representation, there has been inaction on part of the respondents. Full stop. For that reason, the present writ petition is filed to consider, is filed with a prayer to consider, with the prayer to direct respondents to consider the case of to consider the representation of the petitioner and take suitable action. Full stop. Next para. The learned AGA upon instruction submits that the state will consider the representation of the petitioners and take appropriate action in accordance with law within a period of 4 months. 4 months. Full stop. Hence the following order. Respondent number
1 and 3.
1 and 3 are directed to consider the representation of the petitioners and pass appropriate orders in accordance with law, including conducting of Podi and Durasti of the land concerned.
Land granted as per Annexure D.
Within a period of 4 months from the date of receipt of certified copy of this order. Please.
It has to become land granted as per Annexure D.
Sir, I initially wanted to issue a mandamus directing them to conduct Podi and Durasti itself. But because of all the
And also
improper information
and also, my lord, they will, my lord, as per the condition
given by you, I'm not able to rescue you. ಅದರಲ್ಲಿ ಏನು ಹಾವು ಚೇಳಿರುತ್ತೋ ಯಾರಿಗೂ ಗೊತ್ತು, ಅವ್ರು ನೋಡ್ತಾರೆ.
ಕಿಮ್ಮತ್ತೆಲ್ಲ ಕಟ್ಬೇಕು ಅಂತ ಇದೆ ಇದ್ರಲ್ಲಿ, ಅದು ಮಾಡಿದಾರೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ.
ಅದಕ್ಕೋಸ್ಕರ
48 Arjun, 49 Jagdish and Siddharth Suman.
Number 49 for the petitioner lordship. Morning.
One second. P.V. Chandrasekhar, ಎಲ್ಲಿ?
P.V. Chandrasekhar sir.
He said he informed you. What can I do?
Judgment agida. May interim order may kindly be extended.
ಆಯ್ತು, interim order extend ಮಾಡಿ.
48 CH ಗಾಡಿ. 49 Jagdish and Siddharth Suman.
I appear for the petitioner, my lord. My lord, being agreed by the order dated 8/12/2022, it's a commercial OS pending before the CH-83. It's an amendment application filed by the defendant for amendment of the written statement, my lord. My lord, the by filing this application, nowhere the defense taken by the defendants is nowhere going to change. Only thing is that the defendants company, being a partnership company, they got separated. During the time, certain computer data were lost. And when the defendant counsel came on the record and record to be sought to be produced before the honorable court, and at that time they were missing, and subsequently it was found because of contacting other partners who went separately. That was a situation arised and necessitated to file the amendment application before
Where is
the
the
honorable court.
amendment application?
Amendment application is at Annexure D, page 75, my lord. It's a facts, because the nature of the transaction is that supply of aluminum to the plaintiff's company. Suit is for money suit.
At what
And
stage you wanted to file?
chief of plaintiff, my lord. Even cross-examination had also not been commenced. That is one thing. Second thing, now the stage is for setters for different cross-examination. Because at the time, chief itself, the case, the fate could not be even analyzed at that time. Chief. That was the stage.
Where is the affidavit?
Affidavit, my lord, is at page 83, ink page 83. Ink page 83. At paragraph number 3, last 8th line, we have avoided that statement, my lord, that the partners have severed.
When was the partnership reconstituted?
Yes, my lord. I have produced the partnership deed at 99, my lord. That is new register of firms. That is 23/9/2020. Again, it was registered.
Where have you pleaded that in spite of due diligence, you could not have formed it? Where have you said that?
My lord, in the affidavit I have said, my lord.
Where have you said that?
My lord, just if I may be permitted to read, my lord.
Yes.
Paragraph number 3. I'm reading that. I said that the written statement on 13/10/2015 by another partner of the different company, that is Mrs. Minus Corporate Systems, but due to the division of separations of the partnership firm of the different company between the partners, namely Ajay Maini and Pramod Maini, there were loss of the computer data as well as the physical data, due to which the accurate facts and all documents could not be filed and be placed on record before the honorable court. It is submitted that the said documents and facts are material for the purpose of disposal of the present suit in correct and efficacious manner. It is also pertinent to mention here that erstwhile counsel of the present matter was also engaged by Pramod Maini, who is no longer a partner of the different firm, pursuant to the above said divisions. It is also pertinent to mention here that the other business of the partners were also undergoing changes and some major losses, due to which there was a reshuffling in the entire workforce of the office of the defendant, due to which the true and correct facts could not be brought about in the written statement filed by the defendant. So mainly,
Where have you said in spite of due diligence, you could not do it?
my lord, in the sense that since the most of the partners who were engaged the counsel as well as appeared in this matter, and later it was severed, means separated, he did not brought to the knowledge of the present partners at that time, my lord. That was the only submissions by the different partner before this honorable court as well as before the trial court, my lord. And also been stated different in the written statement, in the affidavit. It was unable to take this contention at the time of filing my written statement because the defendant was not able to recover the lost data from its network, which is essential to understand the dispute and the real controversy between the parties therein, and for effective adjudication thereof.
My lord, the application filed by the sorry, petitioner is opposed to the law. I am placing 3 judgments of the Honorable Supreme Court. My lord, before going to the judgment, my lord, with regard to the my lord's query, page 39, paragraph 10, the Honorable trial judge also posed the very question and then said he has nowhere stated in the written statement and sought liberty that he has lost the computer data and physical data. That being the case, he may be permitted to file the additional statement subsequently, as is evident from paragraph 10. May I read, my lord? Admittedly, in the affidavit of the partner of the defendant firm, he has nowhere stated that due to division of the and separation of the partner of the defendant company between the partners, namely Ajay Maini and Pramod Maini, there were loss of computer data as well as the physical data, due to which accurate facts and all documents could not be filed and be placed on record before this court. But the defendant has not stated that when the division has taken place, and when he has not specifically stated that the date mention the date when they have actually find the data in the computer. They also not specifically stated on which day the data, physical data was also found. Now 7 years is lapsed. 2015 is the written statement, and he has not pleaded so in the written statement as rightly observed by the Honorable Judge Miller. In paragraph 11, further, the plaintiff has rightly stated that the defendant has nowhere stated in the written statement with regard to the computer data as well as the physical data that also not sought permission of the Honorable Court to file additional written statement. My lord, here, my lord, with the Honorable Supreme Court in case of Vidyabai from our High Court, my lord, has categorically held that trial means framing of the issues. Here, my friend admits that issues are framed, evidence is also entered. This is started, that being the case, trial is started. And due diligence, as my lord was time and again pointed out, my lord, due diligence. Here, my lord, Pramod Mahini is the person defendant in the suit. He says he has not even produced the partnership deed having been division. He only shows the registration of partnership firm. There, Pramod Mahini name himself is not there, and no details are forthcoming. And I am the plaintiff. I filed the suit for recovery of 1,65,00,000, my lord. He is dodging the matter since 2010. I am the builder, I am the developer, my lord. Hard-earned money I have paid to him. He gave a fall-through material. I have suffered. I have constructed. I suffered through damages from various corners. And now he files application only to that. He is nobody. I have not filed against him. And my lord, with regard to the judgments, my lord, the relevant for us, Vidyabai case 10, 12, and 15. My lord, time and again has considered this judgment, my lord. Paragraph 10. By reason of CPC Act 2000, Amendment 2002, 22 of 22, Parliament inter alia inserted a provision to Order 6, Rule 7 of the Court, which reads as under, provided that no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that in spite of due diligence, the court could not have raised the matter before commencement of the trial. My lord, here, what is stage when the trial starts? My lord, paragraph 14, my lord, in a civil suit, the trial begins when issues are framed and the case is set down for regarding evidence. My lord is well aware, for my benefit, read out. The 2 judgments also support this. These are all the latest judgments which is holding the field. And there is no reason for him to file application after 7 years delay, my lord. There is no due diligence, and it changes the character, nature and character. He says that now I enter, there is some division. If all that were to be, then how that I am concerned within their concern, my lord, he has to choose his own remedy. I am concerned with the person with whom I make payment. And he has not produced the partnership deed. And in the affidavit also, he won't say he's speaking on behalf of the company. He's sole affidavit.
Yes, counsel, shabbily conducted, can't help.
My lord, kindly peruse the documents of registry of firms produced by the petitioner at page 99, registry of firms. This is the latest one. Latest one I have produced before this honorable court. The last page, your honor. Last second page. Before partnership deed and last second page. Could see the date of registration, 23/9/2020. The suit is much before that, my lord, 2015. This is reconstituted, could be clearly seen. Only two partners are there. Reconstitution of partners, only two partners are there. And partnership deed is, old partnership deed is also been produced, which is the last deed of partnership is also there. Now, my lord, the contention of the respondent is that they have taken already contention, delay tactics, all these things. In fact, the true fact is that, my lord, we done the cross-examination of the plaintiff on day-to-day basis. Day-to-day basis means very, very short dates. Now, for them to conduct the cross-examination, their senior counsel itself is not available, where the plaintiff, the defendant has to come in a wheelchair from Delhi to here. Despite, I could show it to this honorable court if it requires and demands. The group we have created where the defendant respondent has taken n number of times just to cross-examination the defendant. I think my learned friend is not aware of the group as well. I am appearing before the trial court as well.
The registrar firm is on 23.
That is the thing, my lord.
The registrar firm on 23/9/2020, my lord. Application filed on 23/22.
Of course,
after 2.5 years.
The partners who have severed has not opened his mouth and he is working somewhere else where because of the gurges and internal disturbances, obviously, my lord, it could be presumed that he has hidden certain things.
And
efficaciously conduct the trial before this honorable court and to take up the correct defense and to brief the trial court about the facts and events. The amendment was very much necessary, my lord. That too at the time of just filing an affidavit of examination chief by the plaintiff. Not even a stage of cross-examination was commenced.
See, you should show in law how it is, how you can seek that amendment. If you want, I will call it next week. Let it
Paragraph number 21 of.
I will give you time. That's all. You want to make some more research and come?
No, I have stated a few citations in
The counsel, as of now, I am inclined to dismiss your writ petition. Okay, if you want more time to make necessary research and show that such an amendment can be allowed, we'll call it next week. You come and argue.
Please, my lord, I have got citations which I have stated in my grounds as well, my lord.
At the request of petitioner, call next week.
Interim order may be granted, my lord, till then, because cross-examination, because this writ petition becomes
No
infectious.
interim orders, I am not convinced at all. If you want, I'll dictate it now itself.
No, my lord, the interim order, at least by then.
No interim orders. We cannot stay a commercial suit of the year 2015.
2015, my lord.
15, impossible. Yes.
My lord.
Ajahn, 51. 51. Yes, Mali Patil.
Any specific date may be given, my lord.
No date because roster is changed.
Refer one short accommodation to file objections, my lord.
What, Girish? In all matters, you take time and go.
It's a Krishna is appearing, my lord. I am.
The request of a respondent call next week.
Next date you will next
Sir,
week
roster change ಆಗ್ತಾ ಇದೆ,
ಒಂದು
ಅದಕ್ಕೆ
date ಕೊಟ್ರೆ
ರೋಸ್ಟರ್ ಚೇಂಜ್ ಆಗ್ತಾ ಇದೆ, ಅದಕ್ಕೆ ಡೇಟ್ ಬೇಡ, ಇಲ್ಲದ್ರೆ ಕೊಡ್ತಾ ಇದ್ದೆ. Yes.
C2, Sravanish Lokre.
This case, I appear for the petitioner in this case, my lord. It's a case of National Highways Authority of India acquisition.
Respondent.
Wherein there is a second notification which is passed on the very same land, which was the subject matter of acquisition, my lord. And it was proposed for road widening. I made my objection before the honorable authority as per as per Annexure B, the order was passed considering my objections, because the only reason why I made this objection was this was the only land which I had acquired during my lifetime. And this also has been taken away because initially when the first notification was passed, I consented to the acquisition, and they had taken almost 60% of my land. And further, the present notification has been issued, wherein the remaining portions are also being taken up for the use of extension of the existing national highway.
Yes.
Now, the reasons contemplated is they want to use this road for the putting up of the extra service road and for other purposes. Now, my only objection was that there was more land available on the opposite direction, and there was possibility of them taking that road. And the other aspect was that there is some this is my only piece of land which is available with me.
Yes, anything else, sir?
That's all, my lord. That's the only objection.
It can't be helped. Yes, Bunny.
I may be permitted to seek for at least higher compensation.
You can always do. Agreed by issuance of the notification, agreed by the issuance of impugned notifications, wherein the lands of the petitioner has been sought to be acquired for formation of for widening of national highway.
Formation of expressway, Bangalore-Chennai expressway.
Formation of a national highway. For formation of a national highway, the present writ petition is filed. Full stop. Next para. The case of the petitioner is that
that they are required for building and maintenance. They required this
he
road.
does not possess any other land other than the land that is sought to be acquired, and he is eking out his livelihood, and he is eking out his livelihood from the land concerned. Full stop. It is further submitted that the land is sought to be utilized for formation of service road and other infrastructure facilities sought to be provided by the highway authorities, and that they could have utilized some other property instead of the property of the petitioner for the same purpose. Full stop. On the said ground, it is prayed that the impugned notifications be set aside. Full stop. Next para. Per contra, the respondents submit. You appear for National Highway Authority.
Yes.
If you come regularly, we can issue notices in.
About 2 and 3, sir.
Yes, please.
2 and 3, 2.
These matters.
2 and 3.
You accept notice also?
Yes.
You accept notice also?
They have some system, my lords. By project they assign, my lords. So in respect of Bangalore-Chennai expressway, they come to me.
You are not for others.
Depends, my lords.
Per contra, the respondent submits the grounds raised by the petitioners cannot be considered for setting aside the impugned orders. Full stop. It is further submitted that
we have passed an order under section 3C.
National highway is sought to be constructed. National highway, but Bangalore Chennai expressway is sought to be constructed, and for that reason, the lands of the petitioner have been sought to be acquired, and the lands are determined after scientifically analyzing where the highway has to proceed. Full stop. On the said grounds, it is prayed that the writ petition be dismissed. Full stop. Next part. Admittedly, as per the requirements for constructing Bangalore, Chennai Expressway, the lands of the petitioner are sought to be acquired. Full stop. Merely because the petitioner is not having any other lands, comma, it cannot be a ground for setting aside the acquisition. Full stop. It is for the concerned authorities to determine what facilities have to be produced, have to be provided for, along with the national highway, and where they have to be situated. Full stop. This court cannot substitute the wisdom of the national highway authorities with its wisdom. Full stop. Next, for the aforementioned reason, the writ petition is hereby dismissed. Full stop. It is needless to state that if the petitioner is desirous of seeking higher compensation, he is always at liberty to approach the appropriate forum in the manner known to law.
Much obliged.
Great.
53, Ganapati Bhatt, Ajay Kumar.
My lords, in
Ganapati Bhatt.
Desirous it is needless to state that if the petitioner is of the opinion that he is entitled to a higher compensation, he has the liberty to approach the appropriate forum in the manner known to law and seek for the same. Yes, sir.
I'm appearing.
My lords, we have sought for the petition copy. ಕೊಡ್ತೀವಿ ಅಂತ.
ಒಂದ್ಸತಿ ಕೊಟ್ಟಿದ್ದೇವೆ, ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಮಾಡಿದ್ವಿ, ಇನ್ನೊಂದು ಕಾಪಿ ಬೇಕು ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೆ.
ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್ ಡೇಟ್ ಅಲ್ಲಿ ಕೇಳಿದ್ವಿ, ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿ.
ಕೊಡ್ತೀವಿ. Yes. Request of respondent. Call next week interim order if any is extended till next date of it.
Please.
54, Chandrasekhar.
ಕೊಟ್ಬಿಡಿ so that they can file.
Chandrasekhar TA.
Here for the petitioner's counsel.
Lord.
Question involved in this petition is very short. So far as the applicability of section 19(7) of the new enactment, Land Acquisition Act, wherein the final notification is required to be issued within 1 year. Whereas in this case, the state went on extending the validity of that, as my lord finds it at page number 14. Several extensions were granted from 13/12/2021 to 10/4/2023. We have put it in a tabular form at page number 14. So the extensions have been done in an arbitrary manner and without following the procedure laid down. Every extension as it is sought, the first extension would my lord get it at annexure F. Annexure F at page number 52. I'll just take my lord through that 52 and similar endorsements. It is in Kannada, annexure 52. ತುಮಕೂರು ಚಿತ್ರದುರ್ಗ ದಾವಣಗೆರೆ ಹೊಸ ರೈಲ್ವೆ ಮಾರ್ಗದ ಯೋಜನೆಗಾಗಿ ಹಿರಿಯೂರು ತಾಲೂಕಿನ ಐಮಂಗಲ ಹೋಬಳಿ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಐಮಂಗಲ ಮತ್ತು ತೀಸಿಹಳ್ಳಿ ಗ್ರಾಮಗಳ ಜುಮ್ಲಾ 19 ಎಕರೆ ಜಮೀನನ್ನು ಭೂಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳುವ ಸಂಬಂಧ ಭೂಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆಯಲ್ಲಿ ಪಾರದರ್ಶಕತೆ, ಸೂಕ್ತ ಪರಿಹಾರದ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಲು ದಿನಾಂಕ 2/7/21 31/12/21 ಕಾಲಾವಧಿಯನ್ನು ವಿಸ್ತರಿಸಿ ಆದೇಶಿಸಲಾಗಿದೆ. So similar extensions are granted on 17/3/2022, 25/8/2022, 25/11/2022, 6/3/2023, 10/4/2023. The humble submission of the section 19(7) of the new enactment, the clearly stipulates. May I just? I have extracted section 19(7) and para 13, page 13, para 6.
Government has power to extend their my lord. Reason is not, my lord. On that regard, I have filed statement objections, my lord.
Correct, but what about the compensation aspect? If it is extended, what date will be considered for granting of compensation?
Sort of, my lord, last notification, my lord, which has last out.
The law says. See, Shankar, this is like mainly for awarding of compensation.
Yes, ma'am.
See, preliminary notification will be of some date and final notification of, will be of some other date.
Yes, ma'am.
If it is not done immediately,
Yes, ma'am.
you will, compensation.
No, the
there will
legal
be-
position is that the preliminary notification, the first preliminary, if they were to make that submission, that the so far as pegging compensation will be pegged as on the date of the excluding the extension period. It is not so. The award gets passed in the instant case, the proceedings have taken place, we have come before.
No,
this-
what does the statute says as to when the compensation has to be
On the date of the preliminary notification, I'll assist my lord on that. Okay?
section?
I'll assist my lord on that. I have extracted section 19(7). I will just take my lord through section 19(7). At page number 13. Page number 13, my lord gets
Where
it.
no declaration is made under subsection
Yes,
1. Huh.
19(1), where no declaration is made under subsection 1 within 12 months from the date of preliminary notification, then such notification shall be deemed to have been rescinded.
Provided that,
My lord?
provided that,
the extension can be granted. That extension for subject to following the procedure which are laid down. Yogesh, would you mind? I think my apologies. Section 19(7), what I read just now. Provided that in computing the period referred to in this subsection, any period or periods during which the proceedings for the acquisition of the land were held up on account of any stay or injunction by the order of any court shall be excluded. In the instant case, it is not there.
No.
Provided further that the appropriate government shall have the power to extend the period of 12 months if in its opinion circumstances exist justifying the same. Provided also that any such decision to extend the period shall be recorded in writing and the same shall be notified and be uploaded on the website of the authority concerned. No procedure have been followed here. No reasons have been recorded. I will take my lord through the extension notifications which I listed.
no, what is the effect of this such extension?
Section 19(7), the preliminary notification gets rescinded. That is the relief which I am seeking from the honorable court. If my lord were to kindly see the prayer. Prayer is that declare that the acquisition, it's humbly prayed that I have sought, if my lords were to hold that the extensions are invalid, if I'm able to convince that, the preliminary notification will go away. Because it is contrary to section 19(7) of the act, which I repeat, that the preliminary, the 19(7) says, where no declaration is made under subsection 1 within 12 months from the date of preliminary notification, then such notification shall be deemed to have been rescinded.
So, the second and third proviso have not been complied.
Yes, it is not compliant. No, yes, ma'am. If they are not coming within the proviso, the legal effect of 19(7) would be that they have not recorded any reasons. In fact, it will be relevant if my lord were to kindly look at page number 52, stereotyped extensions.
Yes,
Now,
but
by
the
doing this,
in the notification, we has not recorded, my lord. But of other things, my lord, if that is the reason I want to file objection. Why we are extended?
You cannot file your objection.
No, we are not filing.
Let him file his objections.
Lord, the difficulty is that the landowner who loses the land, if these extensions were
also,
to
my
be
lord-
ultimately held to be.
We'll hear and pass out.
And also, my lord, they made a beneficiaries made a party, my lord, because the land is acquired for the railway project.
You are justified. Why we should?
Please,
mention?
please.
Not required.
As per the, my lord, if requiring authorities, my lord, beneficiary, that is the reason, my lord, whether the land is required or not. Because 19(1) say that the requiring authority should deposit the amount to the state. Then, my lord, state proceed the further.
You can't deny.
I am not denying that.
See, for him, railways are non-existent. It's you who is he is concerned with about.
2 years an invalid acquisition is extended, my
Request
compensation.
of AGA, call after 2 weeks, objections. File objections.
Please.
Interim order to be extended.
Interim order,
Yes,
yes. Interim order, if any is extended till.
Would my lord consider fixing a date? There will be difficulty.
There will be change of roster this weekend, so I may not, I don't like to fix a date.
Yes. At least the objections time which it may kindly be noted, they are seeking objections time for the second time now.
This is not the last.
I think it's all right. Yes.
At least let my learned friend file it up by the.
My lord,
Within
2 weeks, my lord.
2 weeks.
55, Veerabhadraya.
Vishal, my lord.
Response. Not here. The
Authority
learned
was
friend
under-
has not disclosed as to what is the litigation which was pending against the BDA. If they can disclose it, Mulad, I'll see to that, Mulad, something can be done in this. They only say litigation is pending, give me an alternate side. After 40 years, Mulad,
No, what is the
no, Mulad,
litigation?
I
Very
still
simple,
don't,
my lord.
I don't have anything in my records at all. That is why I'm asking.
ಏನ್ litigation ಇದೆ ಹೇಳ್ರಿ ಅವ್ರಿಗೆ.
No, my lord. Site was allotted, authority has allotted the site in favor of the father of the petitioner, my lord. In the meanwhile, without consent of the petitioner, authority has allotted the same site in favor of the Veeramaya, my lord. Lease cum sale deed as executed by the authority. And thereafter, their authority has given the absolute sale deed, my lord. In the meanwhile, again, the authority has same site, very same site allotted to the Veeramaya. Veeramaya is wife of the Veeramaya, is in the possession, my lord. Numbers of time he has petitioner has given the representation to allot the alternative site, even though they are not
You
responding.
have allotted the site to somebody else. That is the.
EWS scheme, my lord, very.
File ಎಲ್ಲೋ ಸಿಗ್ತಾ ಇಲ್ಲ ಏನೋ ಡೀಟೇಲ್ಸ್ ಕೊಟ್ರೆ I'll get it verified and if something can be done we'll do it.
Do it.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಲೀಸ್ ಕಮ್ ಸೇಲ್ ರಾಮಯ್ಯದು ಏನು ಕೊಟ್ರೆ
You have to.
no nothing is there. I got the original file only. It is not, nothing is available in here.
Whom it is allotted then,
So
site?
that is what Murad, he has got the sale deed executed in 2017. But after 30 years he comes and says that sale deed is to be executed. We executed the sale deed. No, then subsequently he comes, there is a litigation. Nothing else is written here. That's why I'm asking if something can be given to us, particulars, we'll
Try
have
to
it
help
set
them.
right.
Try to help them in giving particulars. At the request of
Already over
respondent
30 years,
allotted
my
2
lord.
weeks.
Already over 30 years.
Not that.
ರೀ ಅವ್ರಿಗೆ ಏನು ಗೊತ್ತಿಲ್ವಂತ ನೀವು ಅವ್ರಿಗೆ ಕೊಡಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ತೆಗೆದ್ಬಿಟ್ಟು ನಿಮಗ್ ಬೇಕಾಗಿರೋ ಸೈಟ್.
Please,
Let
EDI
there not be
itself has
inaction on
given
your part.
the absolute. EDI authority as itself has given the absolute.
ಇದಪ್ಪ ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಇವಾಗ ನಿಮಗ್ ಬೇಕಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ ಏನಿದೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಒಂದು ಕಾಪಿ ಕೊಡಿ ಆಮೇಲೆ ಇರೋದನ್ನೆಲ್ಲ ಕೊಟ್ಬಿಡ್ಬಿಡಿ. ಕಾಪಿ ಇಟ್ಕೊಂಡ್ ಕೊಡಿ ಆಮೇಲೆ ಅದನ್ನು ಕಳೆದಾಕ್ತಾರೆ.
Xerox ಕೊಟ್ರೆ ಸಾಕು.
ಏನೋ
ಮಾಡ್ತೀನಿ.
ಹಾ. Next case.
56, Leela Raju.
Bring for the petitioner, my lord.
Here in this.
My lord, the property in question here is a marginal land that is annexed to site number 46, which is formed in BDA layout, my lord. My lord, the petitioner has purchased this property in the year 2013 from its original allottee. The original allottee through the lease cum sale agreement in the year 1975 has been allotted to him. In subsequently in 2002, it has been registered in his favor. But after the purchase of the property, my predecessor in title in previous also had made a representation, the initial representation to BDA to allot the marginal land in his name. But after the purchase of my property, I have made a fresh representation to BDA in 2013 to allot the property. My lord, in subsequent, after 4 years, BDA in the year 2017, specifically 11/12/2017, I have issued an endorsement stating that I will allot the property to you, but to pay the property, the fixation of price as of 2017, my lord. But I am aggrieved by it. I write another letter to BDA and there was no response. Agreeing by this, I filed a writ petition before this Honorable High Court. But writ petition number 43796 of 2018. My lord, if I may pursue your lordship to page number 56 of Annexure G, my lord. I am reading out the order of this Honorable High Court. The request of the petitioners to allot the marginal site taking note of price of 1975 would be unreasonable. The learned counsel for the petitioner submits that the petitioner would make one more representation requesting the respondent BDA to recalculate and collect the value of the marginal site as on date of the application of 2012. The petitioners are permitted to submit fresh representation within 30 days from the date of receipt of this
copy of this order. If such representation is made by the petitioners, the respondent be due to consider the same along with the representation. So and so date of 2018. My lord, here the problem is, I have made my representation in the 2013, my lord. Previously, my predecessor in title has made representation in the year 2012. They have the unnecessary delay out of 5 years. They give an endorsement in the year 2017, giving the fixation of rate in the year
You are a
2017.
prudent and sensible person. The first thing you would have done is you would have paid the money and got it registered in your name.
My lord, the situation is, my lord, it has been 5 years, the land value would have been increased for another
Finally,
30 lakhs.
they will form a site there and sell it to somebody else.
My lord, if I may, my lord.
No, that's what is going to happen.
My lord, no, my lord, if I may,
Listen,
if I may,
that will be the final outcome.
my lord, if I may, if I am producing a memo along with photographs of the annexed land.
Objections?
Lord, I'll file my objection.
My lord, if I may, given an opportunity to explain the situation, my
He
lord.
wants time. Why should I waste my time? Yes, the request of respondent, Mr. Be practical. If he is, you make a request in the year 2012
Yes, my lord.
for allotment of marginal land.
Yes, my lord.
They agree for it in the
Yes, 17.
year 2017. The wisest thing.
My lord,
We
the
do-
marginal land which has been annexed to my property is of the dead end, my lord. Other than me, no other person can utilize that property. I have photographs of the property. It comes to the dead end, western portion of the property. It is a very small portion. It is annexed to my side. It is of conjugal matters where no one else other than me can access that land itself. That is the situation of the marginal land. Other people in the same layout have been using the land for free. I wanted it to be in my name, so that I made my representation, my lord.
Where is the property situated?
My lord, I am submitting the memo. I have photographs of the property also, sir.
Sure. Where is the property
I'll give
situated?
you the
Property.
Tilak Nagar, my lord. My lord, the last page, I have submitted the photographs, my lord. It is my backyard, my lord. There's no, after that, there's a wall, compound wall. Beyond that is a private property. No one can access this property, my lord. I'm not going to sell this property. That is not my intention. I'm going to retain the ownership of the property.
They will file their objections. Yes.
40 by 25 is the marginal land. It will.
It is of 1,000 square feet, my lord. My entire property is of 2,500 square feet. The major property is of 1,000 square feet.
Yes.
Please.
Please.
57, Manjunath KV, Girish NR.
For the respondent.
But I fear for the petitioner.
Ready?
I filed an objections.
About 6 acres, 20 guntas plot came to be acquired by the BDA, the petitioner's land. Later on, it was denotified. After denotified, the denotification came to be withdrawn. That was challenged by us. We succeeded in the High Court. Writ appeal was also allowed. This withdrawal was set aside. Then, my lord, another person, adjacent persons went to Supreme Court. In Supreme Court, that it was reversed. So the net position is, my lord, that 6 acres came to be acquired, even though in the meanwhile we had developed the property. Then we came to this honorable court, having regard to the development.
There was a stay in Supreme Court?
But
was there any interim orders against you in Supreme Court?
But there, my lord, after the withdrawal, there was no interim order.
There was
And
no withdrawal.
yes.
Okay,
because-
what was the decision of the apex court?
My lord, what happened was the withdrawal denotification is on 12/4/2001. It is there in my
Acquisition,
synopsis.
sir?
Then withdrawal of
No, sir, first acquisition,
the acquisition is on 7/2/78.
7/2/78. Okay.
Denotified on 12/4/2001. Your lordship may take the list of dates, my lord.
Denotification?
12/4/2001 denotification.
Ah.
Withdrawal is on 22/3/2005.
Withdrawal on
22/3/2005.
2005,
Yes.
Ah.
On 30/3/2007, my lord, the writ petition was allowed and withdrawal was set aside. Denotification was upheld.
SLP reversed?
Yeah, the denotification in our favor, my lord, was confirmed.
Yes, SLP reversed?
No, this writ appeal, my lord, was dismissed on 11/12/2008.
That's okay, that's
Then
okay.
on 9/8/2017, SLP was allowed.
Ah.
Then, my lord, we filed a writ petition that out of 6 acres, give us only about 1 acre, 18 guntas of developed land. That is only a small portion of it. The court directed at page 197 to consider that issue. Page 197. At page 201, relevant portion. Then after that direction, my lord, the matter was placed before the board. At page, my lord, 208. 208, last para, my lord. This is survey number 50, last but one para. ಸರ್ವೆ ನಂಬರ್ 50 6 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನನ್ನು ಪ್ರಾಧಿಕಾರದ BTM ಬಡಾವಣೆಗೆ ಉಪಯೋಗಿಸಿಕೊಂಡಿರುವ ಬಗ್ಗೆ ಸೋ ವರದಿ ಕೋರಲಾಗಿ ಕಾರ್ಯಪಾಲಕರು ಕೆಳಕಂಡಂತೆ ವರದಿ ನೀಡಿರುತ್ತಾರೆ. ತಾವರೆಕೆರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 50 ಸ್ಥಳ ಪರೀಕ್ಷಣೆ ಮಾಡಿದಾಗ ಸದರಿ ಬಡಾವಣೆಯ ಪ್ರಾಧಿಕಾರದಿಂದ ಬಡಾವಣೆ ರಚಿಸಲಾಗಿದ್ದು ಸೋ ವಿವಿಧ ಅಳತೆಯ ಸ್ಥಳದಲ್ಲಿ ರಚಿಸಲಾಗಿರುತ್ತದೆ. ಈಗಾಗಲೇ ಉಪಕಾರ್ಯದರ್ಶಿಯು ನೀಡಿದ ಹಂಚಿಕೆಯಿಂದ 30 ನಿವೇಶನಗಳನ್ನು ಹಂಚಿಕೆ ಮಾಡಲಾಗಿದೆ ತಿಳಿಸಿರುತ್ತಾರೆ. ನಿವೇಶನ ಸಂಖ್ಯೆ 82, 83, 84, 85 ಅನಧಿಕೃತವಾಗಿ ಗ್ಯಾರೇಜ್ ಶೆಡ್ ನಿರ್ಮಾಣಗೊಂಡಿದ್ದು ಇವುಗಳನ್ನು ತೆರವುಗೊಳಿಸಬೇಕಾಯಿತು. ಹಾಗೂ ವಾಣಿಜ್ಯ ಉದ್ದೇಶದ ನಿವೇಶನಗಳು 7, 8, 9 ಸ್ಥಳದಲ್ಲಿ ಖಾಲಿ ಇರುವ ನಿವೇಶನಗಳು 48ರಿಂದ 61, 72ರಿಂದ 100 ಉಳಿದಂತೆ ಹಂಚಿಕೆಯಾದ ಹರಾಜು ನಿವೇಶನಗಳ ವಿವರಗಳನ್ನು ಪ್ರಾಧಿಕಾರದ ಹಂಚಿಕೆ ವಿಭಾಗದಿಂದ ಪಡೆದುಕೊಂಡು ಮುಂದಿನ ಕ್ರಮ ಕೈಗೊಳ್ಳಬಹುದಾಗಿದೆ. ಈಗಾಗಲೇ ಒಂದು ಬೃಹತ್ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಸ್ಟ್ರಕ್ಚರ್ ಥಿಯೇಟರ್ ನಿರ್ಮಾಣಗೊಂಡಿದ್ದು ಇದೇ ಸರ್ವೆ ನಂಬರ್ನಲ್ಲಿ ಒಳಗೊಂಡಿರುತ್ತದೆ ಎಂದು ವರದಿ ನೀಡಿರುತ್ತಾರೆ. Then my lord, on that the next date on 13/10/21, there my lord at page 210, last para there at page 210, ಅರ್ಜಿದಾರರು ಭೂಪರಿಹಾರದ ಬದಲಿ ಜಮೀನನ್ನು ಕೋರಿರುತ್ತಾರೆ. ಈ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಹಿಂದೆ ಜಾರಿಯಲ್ಲಿರುವ ಸರ್ಕಾರಿ ಆದೇಶ ಶಶಿಧರ್ ಸಮಿತಿ ಶಿಫಾರಸುಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. Then my lord, you lords may go to the last line, page 211. ಈ ಮೇಲ್ಕಂಡ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಅರ್ಜಿದಾರರಿಗೆ ಬದಲಿ ಜಮೀನು ನೀಡುವ ಬಗ್ಗೆ ಇನ್ನೂ ಹೆಚ್ಚಿನ ಮಾಹಿತಿ ಪಡೆಯುವ ಅವಶ್ಯಕತೆ ವಿಷಯವನ್ನು ಮುಂದೂಡಲಾಯಿತು. Page 211. Then next, my lord, on 19/3/22, they said that you decide at your own end, no need to place it before the committee. At page 212, top. Accordingly, the committee, subcommittee, my lord, at page 213, at relevant page at 214, made a recommendation to allot 64,222 square feet.
ಎಲ್ಲಿದೆ ಸರ್ ಅದು?
At page 214. ಅದರಲ್ಲಿ ಅದರಂತೆ ಸರ್ಕಾರದ ಪತ್ರದ ಸಂಖ್ಯೆ 19/10/2018 ಆದೇಶದಂತೆ ತಾವರೆಕೆರೆ ಗ್ರಾಮದ 56 ಎಕರೆ 20 ಗುಂಟೆ ಪೈಕಿ ಪ್ರಾಧಿಕಾರದ ವಶದಲ್ಲಿರುವ 5 ಎಕರೆ 24.45 ಗುಂಟೆ ಜಮೀನಿನಲ್ಲಿ 10 ಗುಂಟೆ ಖರಾಬ್ ಹೊರತುಪಡಿಸಿ ಉಳಿದ 5 ಎಕರೆ 14.45 ಗುಂಟೆ ಜಮೀನಿಗೆ 64,272 ಚದರ ಅಡಿಗಳ ಅಭಿವೃದ್ಧಿಪಡಿಸಿದ ನಿವೇಶನಗಳನ್ನು ಸರ್ವೆ ನಂಬರ್ 50 ಜಮೀನಿನ ಖರೀದಿದಾರರ ಶಿವಾಜಿರಾವ್ ಎಂ ಪೋಲ್ ಅವರಿಗೆ ಹಂಚಿಕೆ ಮಾಡುವಾಗ ಉಪಸಮಿತಿ ತೀರ್ಮಾನಿಸಲಾಯಿತು. ಇದರಲ್ಲಿ ಸ್ಪೆಷಲ್ LAO, ಲಾ ಆಫೀಸರ್, ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಭೂಸ್ವಾಧೀನ, engineering, all of them are there. Then my lord, without ignoring on page 215, next page 25/9/2023, without reference to this, they said no, it can't be given at page 217, which is by the deputy commissioner, not even by the authority. So my request to this court, my lord, is since the authority itself has taken a decision to allot, that accordingly that decision should be implemented. Now this deputy commissioner who has given this endorsement at 217 is not the competent authority to take a decision also. Bangalore Development Authority under section 8 is the authority which will have to take the decision. That authority has taken the decision, subcommittee also has given the decision. And the resolution is only to give me, out of 6 acres, 20 guntas, to give me only 64,222 square feet. There is some political controversy regarding 50%. I don't get even 1 acre of the land.
No, the question is, see, acquisition 7278 preliminary notification.
Yes,
huh?
bro.
Huh?
Yes, my lord.
Preliminary notification.
Okay.
7278 is the preliminary notification. Where is the SLP order, sir?
SLP order is at page 125.
125. It is upheld, my lord. That acquisition is upheld.
That is why.
That acquisition is upheld. Only the respondent can approach the authority for alternative remedy for allotment of
The
any
relevant
land.
portion over the one,
Yes, please. But at page 190, paragraph 74 on this.
So SLP does not speak anything about compensation or anything like that.
It does not say anything.
It speaks only about
It only says that
the writ petition and writ appeal orders being set aside.
yes, but they say in para 76, if any person is in occupation, what decision to be taken is left to BDA.
That's okay. That goes without saying. The year got nothing to do with. Can you show me the withdrawal order of denotification?
Yes.
22/3/2005.
Well, happy Diwali. That withdrawal it is extracted in the writ petition order at page 10. That order is not produced.
Indian order, the withdrawal order of denotification.
I don't.
No, because the issue pertains to compensation.
There are.
What should be the date?
There are.
No, my lord, we are not asking for compensation at all. We have said that don't give us any compensation in respect of 6 acres. Give us some alternate site, which the subcommittee has decided to give about 64,000. I don't want
Humble
compensation.
submission is, Lord, they are asking under the government order 9/10/2008. As per the 9/10/2008, they are not eligible.
They are eligible under what according to you?
That where the lands are used by the BDA without acquisition. For those lands, BDA can give 50% of the developed lands. On that basis, they are requesting the BDA to allot the alternative sites now, alternative lands. But that is not possible in this case because it is already acquired, layout is formed, developed, amount is deposited, award form, award passed, the amount is deposited before the trial court. Everything has been done, my lord. On that government order.
Council, this is a peculiar case where acquisition is of the year 1978. Okay. Then due to your inaction, what happens? There is denotification in the year 2001.
Yes.
Thereafter, till 2017, third party rights are obviously created.
But
listen, you make people suffer. And SLP also is not filed by you.
Somebody else. They have accepted that. Correct. They did not file SLP.
You accepted that you are going to let go of the entire land. you willingly allowed third party rights to be created on the property concerned.
Thereafter,
You are party to third party rights, to put it in other words.
however, my lord,
You wanted to favor somebody else.
no, my lord,
Then what?
thereafter,
Supreme Court goes and it upholds. What do you say? That withdrawal of the denotification order.
but however, my lord, that in the they have filed one writ petition in page number 190.
Okay, what about this? See, this committee took a.
Committee has wrongly decided to give an land
See, committee takes a
decision under the government order dated 9/10/2018, my lord.
Can committee's order be overruled by
the deputy commissioner, who himself is a party to that earlier subcommittee,
deputy commissioner?
who is a party in the earlier subcommittee also.
He is a party, the same person is a party
10%.
in the subcommittee, same signature.
It's only that. Yes, because it is not possible as per that no government order. It is not possible to give the lands, my lord. That's the
You
reason.
do one thing. We'll set aside this annexure J, remand the matter back to BDA, you take fresh decision.
Yes. Yes.
Huh?
But anyhow, they are not entitled. That's my submission.
No, that is different. The point is, subcommittee takes a decision. Subcommittee takes a decision to give them an alternative land.
Yes.
Okay.
Yes, ma'am.
Now you are a party to that decision. In your rules and regulation, how can you alone give an endorsement contrary to that?
That is only the yes. Either commissioner or the authority has to give that endorsement. However, the same person is given my lord.
Do you have the power? Does he have the power?
No.
He does not have the power.
He doesn't have power.
On that short question, we will set it aside. They have the liberty to reconsider it in
Let them
accordance.
reconsider in the light of the subcommittee recommendation.
No, let them take appropriate decision in accordance with law. That's all.
Yes.
We set aside annexure J without getting into any muddy waters.
Likely then.
That's all. That's all can be done. Nothing else.
Very well. Lordship may note my contention with regard to subcommittee.
Yes. Agreed by the endorsement dated 25/9/2000. Issued by respondent number 2. Respondent number 2 tana?
Respond number.
Hmm.
Respond number 2.
Respondent number 2, the present writ petition is filed. Next para. 6 acres, 20 guntas of land in survey number 50, Tavrekare village, Begur Hubli, Bangalore South Taluk, belonging to the petitioner, was acquired by BDA in the year 1978. Full stop. However, the same was denotified on 12/4/2001. Full stop. Thereafter, the said order of denotification was withdrawn on 22/3/2005. ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರ ಅದನ್ನ?
we challenge.
The said order of withdrawal of denotification was challenged on, challenged by way of WP number
13404 of 2005.
30404, huh?
A list of dates, synopsis.
ಎಲ್ಲಿದೆ synopsis?
The
Page
P-
number 1.
Page number 1 ಅಲ್ಲ 13404. A list of dates.
13404, 13404 of 2005. Huh? Full stop. The said writ petition was allowed. And the denotification has been upheld. Denotification was upheld, was upheld. Full stop. The said order was challenged in WA number 936 of 2007 by the BDA, which was dismissed. Huh? Full stop. BDA did not challenge the order passed in the said writ appeal. Full stop. However, in a connected matter, in SLP number 5911-12 of 2001, the Honorable Apex Court has set aside, has dismissed, has set aside the orders passed in WP number 13404 of 2005 and WA number 936 of 2007. ಇದು however in a corrected ಮಾಡ್ಬೇಡ. However, at the instance of a third party. At the instance of a third person.
Layout association, NEL, in
This
layout association.
SLP was filed by Lordship, pardon?
SLP was filed by a person who was a party to the proceedings.
No, a third party.
The third party. ಏನ್ ಬಂತ ಹೇಳಿ? In SLP number so and so, the Honorable Apex Court has set aside the orders passed in WP number so and so and WA number so and so and has upheld the withdrawal of the denotification of the lands concerned. Full stop. The same has attained finality. Full stop. Thereafter, the petitioner submitted a representation for grant of developed land instead of compensation. Full stop. The respondent number 1, BDA, resolved by way of its resolved through ಯಾವ order?
Page 213.
ಅಲ್ಲ ಇದು ಏನ್ ಸಬ್ ಕಮಿಟಿನ ಏನದು?
Subcommittee.
Earlier to that, BDA resolution is also there at page 2.
BDA ಏನ್ ಬಂತೇಳಿ? To grant
board of British.
Grant
64,000.
alternate land in lieu of compensation. Alternate developed land in lieu of compensation to the petitioner. Full stop. In pursuance of the same. 214. 214.
Subcommittee.
By an order dated 8/7/2022, the subcommittee of BDA passed a resolution to allot ಎಷ್ಟು 64,222 square feet of land. And of developed land in favor of the petitioner in lieu of compensation. Full stop. The special additional
Deputy Commissioner.
ಅಲ್ಲ ಅಪರ ಭೂ ಸ್ವಾಧೀನ ಅಧಿಕಾರಿ ಅಂದ್ರೆ ಯಾರು?
Deputy Commissioner.
ಅಲ್ಲ ಅಪರ ಭೂ ಸ್ವಾಧೀನ ಅಧಿಕಾರಿ ಅಂದ್ರೆ ಯಾರು?
Special land.
No. ಅಪರ ಅಂದ್ರೆ additional.
Additional.
Additional land acquisition officer, comma, law officer, additional land acquisition officer, BDA, comma, law officer, BDA, deputy commissioner, land acquisition, BDA,
Member.
ಅಭ್ಯಂತರ ಸದಸ್ಯರು ಅಂದ್ರೆ ಯಾರು?
Engineering member.
Engineering member, BDA, and the secretary BDA constituted the subcommittee and they have signed the said order. Full stop. However, thereafter, instead of allotting the land, the second respondent, Deputy Commissioner BDA, has issued the impugned endorsement stating that their petitioner is not entitled for developed land and he is entitled only for compensation. Full stop. Agreed by the same, the present petition is filed. Next part. The case of the petitioner is that pursuant to the resolution of the board of BDA, the subcommittee of BDA wherein the additional land acquisition officer, law officer, deputy commissioner in brackets land acquisition, engineering member, and the secretary being the members having resolved to allot the additional developed land in lieu of compensation, comma, the second respondent could not have issued the impugned endorsement. Full stop.
Is a party to the.
It is further submitted that the same person, that the same individual, the individual who has issued the endorsement himself was part of the subcommittee which has approved it, and he has issued the impugned endorsement only to harass the petitioner. Full stop. It is also submitted that the BDA has a scheme to allot developed land in lieu of compensation. Full stop. It is also submitted that the land was acquired way back in the year 1978 and the BDA wantonly adopted a partisan attitude, because of which the land was developed at the by the petitioner by spending a lot of money. Then that's not required, I suppose.
Existing structures are there.
Sir, 1972 ಹೇಳಿದ್ನಲ್ಲ ಅದ್ ಬೇಡ ಹೊಡೆದಾಕಿ. it is further submitted, for that said reason, it is prayed that writ petition be allowed and the impugned order be set aside. Full stop. Next para. Per contra, the counsel appearing for BDA justifies the order passed by justifies the impugned order. Full stop. He submits that BDA does not have a scheme to allot developed land, taking into consideration the timeline of the acquisition.
Yes.
Full stop. However, he concedes that the impugned order is passed by, the impugned endorsement is passed by the second respondent, Deputy Commissioner, who himself was a party to the proceedings of the subcommittee, and he does not have the necessary authority to overrule the subcommittee, the order of the subcommittee. Full stop. Next para. In the light of the submission made by the learned counsel for respondents, to the effect that the impugned order could not have been issued contrary to the resolution of the subcommittee, the writ petition is hereby allowed, and the impugned endorsement dated 25/9/2023 issued by respondent number 2 brackets wide annexure J to the writ petition is hereby set aside. Full stop. However, it is clarified that setting aside of the impugned endorsement shall not come in the way of BDA taking appropriate decision in accordance with law.
Like.
Yes, adjournments.
My lords, serial number 62, my lords.
Ah.
The petitioner will have to implead KADB also, my lords.
Yes, so the request of respondent call up to 2 weeks.
Interim order may be extended.
Interim order, if any, is extended till next date of it.
72, serial number 44, my lord. He was in other court, my lord.
44. J. Karthikeyan sir notice ಆಗಿದೆ.
Sorry, my lord.
Continuous absence ಇದೆ ರೀ, ನಾವೇನ್ ಮಾಡೋದು?
The last occasion same ಆಯ್ತಲ್ಲ, ಬೇರೆ ಕೋರ್ಟಲ್ಸ್ಗೆ ಹಾಕೊಂಡು ಎರಡಪ್ಪ ಆಯ್ತು.
ಆಯ್ತು 44 ಅಲ್ಲಿ the request of respondent number 1 and 2 call next week ಅಂತ ಮಾಡಿ.
Sorry, I'm very sorry, my lord.
Next time you have to file your objections. ಕಾರ್ತಿಕೇಯನ್ ಹೇಳ್ಬಿಡಿ, ಎಲ್ಲಿದಾರ ಅವರು?
ಇಲ್ಲ ಇದೆ.
Number 64, my lord.
60?
64, my lord. 2 weeks, my lord. 2 weeks, my lord.
The request of AGM. Petitioner ಹೇಳಿದಿರಾ ಸರ್?
ಹೇಳಿದ್ದೀನಿ.
At the request of AGM, call out for 2 weeks.
Serial number 59, my lord. Objection is ready, my lord. It has to be.
You are for?
I'm for the respondent.
I'm for the petitioner.
At the request of respondent, call out for 2 weeks.
My lord, because the case of alternate is like allotment from alternate side.
No, that is, sorry, my lord. In the
objection
objection is ready, my lord.
Objection ಆಗ್ತಾರೆ.
Next
week ಅಂತ.
Say number
5. Next week.
Say number 45 minutes. 2 weeks time.
45.
Pass over.
45.
Pass over ಆಗಿದೆ.
Respondents.
The request of petitioner call next week.
My lord, serial number 60, a week
72,
time.
my lord. 72, my lord. I appear for the petitioner, my lord. Week's time, my lord. Request me.
The request of petitioner call next week.
Serial number
69, 69, my lord. ಅದ್ರಲ್ಲಿ ಇನ್ನೂ ವಕಾಲತ್ ಬಂದಿಲ್ಲ.
I am for the petitioner, my lord.
They want some time, madam, please.
No, my lord, it's a simple mandamus, my lord.
Have to file their objections now. At the request of respondent, call next week.
My lord, serial number 60, my lord, 1 week adjourned.
60,
Yes, ma'am.
You are for?
Respondent 2.
The request of respondent, ಹೇಳಿದಿರಾ petitioner ಗೆ?
Yeah.
Request of respondent number 2, call next week.
Serial number 58, my lord. I want to file objections. Weeks time.
Arun.
Adರಲ್ಲಿ I tried, my lord. I tried, my lord, in this matter. ಯಾಕಂದ್ರೆ ಡಾಕ್ಯುಮೆಂಟ್ ಒಂದು ಸಿಕ್ಕಿಲ್ಲ ಸ್ವಾಮಿ, ಬೇರೆ ಎಲ್ಲ ಒಂದು ಲೆಡ್ಜರ್ ಎಲ್ಲ ತಗೊಂಡಿನಿ. It is allotted to Muttama only. It is not in disputed. The only thing is
They are asking for, it is in the 7th, 8th cross. As per the layout, it is in the 7th cross. That site.
ಅದೇನ್ ಸೈಟ್ ಅಲಾಟ್
ಅಲ್ಲ,
ಮಾಡಿದ್ರೆ
that's the reason
ತಪ್ಪಿದ್ಯಾ
why-
ಸರಿ
that's the reason why, my
ಹೇಳ್ಬೇಕು
lord,
ಅಷ್ಟೇ.
I want to see the file. ಆ file ನೋಡ್ಬಿಟ್ಟು ನಾನು submission ಮಾಡ್ಬಿಡ್ತೀನಿ. It is allotted to him only, her only. It's not in dispute.
See, that is not in dispute also. He has produced all the relevant documents. That he is asking for rectification of the sale. I remember that
Yes,
last
my-
date
yes,
of
my lord.
location, what I told you.
As per
Tell
the,
with it.
as per the plan, 177 ಏನ್ ಶೆಡ್ಯೂಲ್ ಇದೆ, ಆ ಶೆಡ್ಯೂಲ್ as per the sale deed ಇದೆ. 177A, that is incorrect. But they are asking 191 series ಅಲ್ಲಿ ಏನಿದೆ ಆ ಪೋರ್ಷನ್ ಅಲ್ಲಿ ನಮ್ದು ಬರ್ಬೇಕು ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. That is their contention. I want to see the file, my lord.
1540 site.
Why did you ask your client to come all the way?
He was very keen to come. I just called him.
Again, watch through the
But you
video
have to
con.
kindly see, my house was built in 1978.
Okay, you want some time or what to do?
ನಾನು ಹೇಳ್ಬಿಡ್ತೀನಿ, 78 my house was built. Then later on, when we realized, and even the Lordship kindly see my tax bill receipt. Tax bill receipt 8 crores ಅಂತ ಬರೆದಿದ್ದಾರೆ.
ಅಲ್ಲ, that is in BBMP, my lord.
BBMP.
That is not a dispute.
But you see, it is not a document that is engineered by me. The fact is,
See, he has to verify the original plan.
Lordship kindly see, there is a one file there.
BDA layout ಅಲ್ಲೇನಪ್ಪ ಇದು?
PDA, reconvey, my lord. It's a reconvey. It's a reconvey. They were in position. We have reconveyed that.
ಈ BDA layout ಅಲ್ವೇನಪ್ಪ?
PDA layout.
BDA layout ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ಮ್ಯಾಪ್ ಇರುತ್ತೆ, ಚೆಕ್ ಮಾಡಿ ಅದನ್ನ.
Yes, that's why.
Your Lordship kindly direct my learned friend. He's been actually extremely good. As a matter of fact, your Lordship kindly asked, there's a particular file. If that file is brought to the court, all the matter, the whole matter will be settled. Because that file contains everything. One PL node and the other node. Your Lordship
Yes, sir.
kindly make a judicial order on that to produce that file. Otherwise, they will not produce that file.
Yes,
They will,
I'll-
as a matter of fact, my learned
That's
friend
why-
said the file is not missing. That file
That's
is
the reason
missing.
why I'm not seeking time, my lord. 1 week time, because I want to produce that document.
No,
I'll-
you should kindly make a judicial order to produce that file. Otherwise, these people will play games.
The advocate for respondent BDA undertakes to file the produce the necessary documents for perusal of the court by next date of hearing in order to verify as to where the property of the petitioner is actually situated
PLO
and
number.
whether it warrants
PLO number.
Whether it warrants any amendment to the sale deed as paid for.
Yes, PLO number is, the file number is PLO number 84109.
Full stop. He undertakes to produce the file.
PLO.
ಹಾಕ್ಬೋದಾ?
Direction may be granted.
ಅದೇ,
Undertakes, but direction ಅಂತ. I don't know whether that number is the correct or not.
ಸಾಕ್ ಬಿಡಿ, ಸಾಕ್. ಕಾಲ್ ಆನ್ ಒಂದು ಡೇಟ್ ಕೊಟ್ಬಿಡೋಣ.
Because
30th. ಯಾವ್ದ್ರಲ್ಲೂ ಕೊಡ್ತಿಲ್ಲ, ನಿಮಗೆ ಕೊಡ್ತಾ ಇದ್ದೀನಿ ಡೇಟ್.
My lords, serial number 60, connected matter is on 1/8, my lords, kindly have it on 1/8.
ಬರುತ್ತೆ ಬಿಡಿಯಪ್ಪ.
In ಮೂಡ್ ಅವರು 2 ಸರಿಯಿಂದ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ. ಪ್ರಿಲಿಮಿನರಿ ನೋಟಿಫಿಕೇಶನ್
ಡೇಟ್ ಬೇಡ. Yes, because roster is changing. Otherwise, I would have given. Date.
61.
Password
Jain.
ಇಲ್ವಾ? Password ಇಲ್ವಾ?
61, Ajay Jain.
I appear for
Michel Pradeep Kumar.
I appear for the petitioner, my lords. Lords, preliminary notification is issued in the year 7/2/2007, my lords.
ಇದು 330 ಹಾಕೊಂಡು ತಪ್ಪು ಮಾಡಿದ್ವಿ. ಈ ಖಾಲಿ ಆಗತ್ತ.
Some difficulty to them.
No, go on.
ಇಲ್ಲ, I am ready, my lords. I thought 3:30 ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ಏನೋ ಬೇರೆ ಯಾವುದೋ ಮ್ಯಾಟರ್ ಇದೆ ಅಂತ ತಿಳ್ಕೊಂಡ್ಬಿಟ್ಟೆ.
ಬೇರೆ matters.
Yes.
Lords, one Mr. Abraham is the owner of.
You are ready, madam?
Sir, ಬರ್ತಾರೆ.
Okay, you are ready, but I can hear this.
ರೆಡಿನಾ ಮತ್ತೆ ಟೈಮ್ ತಗೊಳ್ಳಿ.
ಟೈಮ್ ಕೇಳಲ್ಲ ತಾನೇ ಬಂದ್ಬಿಟ್ಟು ಆಮೇಲೆ.
ಇಲ್ಲ, he's ready. He was there.
ಬರ್ತಾರೆ sir.
Okay.
Lords, one Mr. Abraham was the owner of the 3 survey numbers. So, one is 27/2, 3 acres, 4 guntas, 22/2, 11 acres, 11 guntas, 11.5 guntas, and 27/26 ಅಲ್ಲಿ 4 guntas. ಅವರು 2001ರಲ್ಲಿ ನನಗೆ GPA ಮಾಡಿ ಪೂರ್ತಿ ಸೇಲ್ ಕನ್ಸಿಡರೇಷನ್ I pay. Property is not transferred. I start running a school there from the year 2001. Once I start running a school from 2001, preliminary notification is issued on 7/2/2007 showing the name of that Mr. Abraham.
Now, the GPA, does it say it's for consideration?
Yes, it is for consideration. GPA is for
Is it
consideration.
registered?
My lords, it is not registered, but subsequently I obtained a decree from the court and thereafter it's been registered. So what happens, my lords, is that there's a sale deed at 2/5/2009. My lords will find the sale deed at page number 65 of the writ petition.
Okay, 2007 is.
It's a registered power of attorney. Yes, it's a registered power of attorney.
Yeah, 2000, but that is 2001, is it?
2001, yes. So I'll give my lords the date. One.
Can you show the GPA? Have you produced it?
Yes, my lords. It's produced, my lords, at page 56, my lords.
Where is the consideration clause?
One. My lords, consideration is separately shown, my lords, at page 62. It's a part of the document. My lords will see page 62 for a minute, my lords. My lords, have page 62, my lords. My lords, Mr. P.J. Abraham, he's received, acknowledged that 6 lakhs, 5 lakhs, 50,000, 1 lakh 50,000, then my lords 40,000, 23,500, 10,000, 26,500. Then my lords, he also gives a letter of assurance, etc. My lords, I start a school in that particular place.
Agricultural property.
Agricultural property.
You're not entitled to buy it then.
My lords,
Then you are not entitled.
then
to
I was,
buy.
exactly. My lords, thereafter, my lords, suit is filed by me because what this Abraham does is he sells the property. After selling it to me, he sells the property to one Francis. I file a suit. My lords will find the judgment at page 81. My lords, I file for suit of declaration and ownership. My lords, the trial court has held in my favor. My lords. Thereafter, my lords, appeal is preferred by Mr. Francis, and my lords, the appeal has been dismissed for non-prosecution. My lords, I've been told now they have filed an application for restoration, which is pending. But as on date, my lords, this order of the trial court is still in operation, insofar as I am. Now, my lords, what happens is that, pursuant the order of trial court, my lords, I obtain a sale deed in my favor on 2/5/2009. My lords will find the sale deed at, my lords, page 65.
That's 2005, it says.
I'm sorry, 2005 minutes. 2005, I obtain a sale deed in my favor, my lords. Now, what has happened, my lords, is that the preliminary notification was issued showing the name of Abraham as the khatedar. Thereafter, my lords, final notification is also issued showing the name of Abraham as khatedar. I am not heard when it comes to 28(3) regarding objection, because, my lords, school idre, my lords, there's a circular of KIDB which says that if there's a school, etc., the land has to be dropped. This entire acquisition was for the benefit of a company called as Woodcraft.
Now, my lords, insofar as my land is concerned, my lords, possession is also not taken. My lords, the possession document is at page 115, annexure F, my lords. Possession is not taken, award is also not passed insofar as my lands are concerned. Insofar as my lands are concerned, no award is also passed, undisputed, no award is passed. Preliminary notifications of the year 2007, and no award is passed even as of 2024. Final notification of the year 2009, manage. 17/12/2009. No award is passed. Then manage, have also filed a memo, manage. Manage, the memo shows, manage, that actually there's a school running, there's a certificate by the department. Manage, apart from that, manage, even KIDB in their 29-2 hearing, they have noticed that a school is running in that particular place. And the fact that there's a request made to considering dropping of plans. They have not considered that representation. But I was not heard, manage, no notice was issued to me. That is my short term. Insofar as this issue is concerned, in the statement of objection filed by my learned friend, there's a judgment of my lords, this honorable court, which is produced, which says that I must be heard. But my lords, that judgment is passed much after the 29/4 notification. That judgment, sorry, 28/4 notification. That judgment was passed on 3rd January 2013, which said that I must be heard because I have title and I have a decree in my favor. I must be heard by KADB before proceeding further in respect of any of these issues. So my request only, my lords, one of the two, my lords, because award is not passed despite lapse of so many years. And also, my lords, Woodcraft has now returned whatever lands of possession had been taken by KADB, my lords. Woodcraft has returned it and said we don't want the lands. Insofar as the remaining lands are concerned. The remaining lands, Swadhina KADB jotene ide. None land Swadhina, none school nadistane. That photographs produced money, not disputed, even KADB. My request, my lords, is either consider quashing the 28/1 and 28/4 on the ground that no award is passed. Alternatively, my lords, my submission would be that remand the 28/4 quash madbittu, remand the matter back to KADB so that then I can take the benefit of the circular. And my lords, insofar as the school is concerned, it can be saved.
Lord, first of all, my lord, the petitioner, my lord, was not, my lord, the notified Katida. No revenue records were, my lord, standing in the name of the petitioner as on the date of issuance of preliminary notification. So, my lord, notices, my lord, could not be, my lord, rowing inquiry, my lord, need not to be, my lord, made by, my lord, the deputy commissioner. Second, my lord, he approached this honorable court, my lord, earlier, my lord, in the year 2000, my lord, 10. This court, my lord, passed an order saying that to claim, my lord, compensation, my lord, if he is interested, my lord.
2010.
2010, my lord, he filed writ petition. Annexure R2 to my objection statement. 1963 of 2010.
My lords may read the entire paragraph from paragraph 18. My request is only that. It's only the last line he's relying on.
Page number 12, annexure R12. 11th, my lord, portion at annexure, my lord, page number 18, my lord.
Request my lords were to see the entire judgment. It is on 28. It is on 28/3 notification only. Hear me before 28/3 antane nan kelirodu. My lords may see page number 14 in the shuru agutte. Not sees at page number 17 minutes. In spite of the petitioner having filed his objections to notification under 28/1 and 28/2, final notification on 24/4 be issued, reflecting only the name of MC Francis, not disclosing the name of the petitioner.
See, come to page number 13, in page number, internal page number 2 of the writ petition.
Yes, my lords.
Writ petitions are filed under article so and so, praying for issue of certiorari, quashing the impugned final notification.
Yes.
Okay.
Yes, it was on the ground that I was not heard.
Yeah, correct. You need not be heard. Okay. So that was not quashed. Final notification was not quashed.
Not quashed.
This court did not quash the final notification. Per
Yes.
contra, it said in apportionment and distribution of compensation, they can consider your representation and take appropriate order, make appropriate orders. That's the relief that you have got. Now, how can you again file a writ petition asking for quashing of the same notification?
My lords, on the ground that award has not been passed, possession has not been taken. They said that the writ petition is premature. My lords, their contention was that the
See, possession, what happens, the moment final notification is issued, land vests with the government under KD Act. It's not like BDA or land acquisition. Okay.
My lords, I'm only on award, my lords. I'm only on the fact, my lords, only judgment is there, my lords, on award, which has been confirmed by.
So award is not passed for such a long time, why it should not be set aside?
Award is not, admittedly, it's not passed, my lord. My lord, there was a dispute, my lord, between my lord, the Francis and my lord, the
Hey,
petition.
mister, if there is a dispute, you deposit the award in the reference court. Where is the question of not passing the award? It has to be allowed only on that ground.
Award, now, my lord, the latest development is, my lord, the SLA was written letters to the development section, my lord, whether the land is required or not, my lord, the company, my lord, they know start.
See, the fact that preliminary notification is in the year 2007 and final notification is in the
That
year.
is true, my lord, I'm not disputing that.
See, I myself I have expressed in BDA matters. One, they can challenge after the issuance of notifications. Then they can challenge their possession is not taken under 16(2). Even after failing under this one. Then they can also challenge on the ground that award has not been passed, because acquisition is complete only upon taking possession and passing of the award. Here, possession will not come into picture because land vests with the government.
By operation of law.
By operation of law. Okay. But award, yes, definitely.
It's true, my lord.
We'll set aside.
Now, my lord. 28-1, my lord. Otherwise, my lord, it will be precedent, my lord, other cases. Award agila anta heli. Bere case.
Obviously. You want to address your argument, you address. Show me the case law. Show me the position of law. Within what time award has to be passed? I have said within reasonable time acquisition has to be complete myself in umpteen number of cases. Okay. Not passing an award till now.
Lord, they are whether they are entitled under new act, my lord.
That's a different thing altogether. You should have passed an award. You'll set aside both preliminary and final notification.
Is the case, my lord, I'll take instruction whether, my lord, they can pass, my lord, award under new act now.
No, that's not the question. The question is, as on till today, award has not been passed. It has to be allowed.
Lord. Next week. On the other time ಕೊಡ್ತೀನಿ.
ಏನ್ ಮಾಡ್ತಾರೆ ನಾಡಿದ್ದು ಹಾಕೊಂತೀನಿ ಅಷ್ಟ
ನಾಡಿದ್ದು ಹಾಕೋಣ.
ನಾಡಿದ್ದು ಹಾಕೊಂತೀನಿ ನೋ ಫರ್ದರ್ ಟೈಮ್.
ಆಯ್ತು.
Third in part. Call on. At 2:30, if you want at 2:30, you come.
Sorry. My lords, 25th 2:30 delegate come 2:30 on mat ಬೇರೆ
cancel ಮಾಡಿ. At the request of respondent, call next week.
ಸ್ವಾಮಿ ಬೈ ಕೈಗೆ ಬಂದಿತ್ತು ಬಾಯಿಗೆ ಬಂದು ನಾನು ಬರ್ತೀನಿ ಸ್ವಾಮಿ.
No, not like that. See, roster changes on 26th.
So ಇಲ್ಲ
I don't know what.
I don't know why he's asking what position of law is. My lords, I'll give all the judgments to my friend. Everything is squarely against him. I don't know why he is saying this. My lords may pass the order today. It's what 2 days ಅಲ್ಲಿ ಏನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತೊಗೊಳಕ್ಕಾಗತ್ತೆ ಅವ್ರಿಗೆ?
It's the state, they have to be given a long rope.
Swami, they've taken enough time to file objections.
That's why I fixed a date. I said part heard. So
Swami, 20 ನಾ ಬರ್ತೀನಿ.
ಬರ್ತೀರಾ ಆಗತ್ತಾ?
ಮಾಡ್ಬೇಕಲ್ಲ ಸ್ವಾಮಿ. When you're in my favor, I don't want to lose the opportunity.
Call on 25th at 2:30.
63. V. Srinivas, 63 serial number. V. Srinivas.
I appear for petitioner in this case.
I'm for respondent in this matter.
My lord, I sought for a writ of mandamus, my lord. My lord, in this case, my lord, the petitioner was the owner of land my site measuring 60/40, my lord. My lord, in the year 2011, a portion of the land have been acquired by the BBMP, my lord, for formation of the road. My lord, pursuant thereto, in the year 2007, 11 itself, I have executed a relinquishment deed in their favor, which is at Annexure D, my lord. Now, my lord, even 2011 is the relinquishment deed when I have executed in their favor, in favor of the BBMP. Till now, my lord, they have neither paid the compensation nor issued the TDR which they were supposed to issue, my lord. And in fact, my lord, in the plan also, my lord, it is a road plan, my lord, which is at Annexure E. In that also, my property is clearly shown. There is no dispute that the property have not been acquired, but they have not paid the compensation to me, my lord. Now, my lord, at this length of time, they have to pay compensation, my lord, because of the TDR. They are not, BDA is not issuing any TDR as of today. Let them my lord, work out and make pay compensation to me, my lord. My request is only that, my lord. Annexure FI is the representation seeking for compensation for having acquired the land.
Last week, my lord, I seek instructions in this matter.
My lord, 2011.
It's a
No, I'll have to file my statement of objections in this matter.
petition is of which year? 2024.
24, my lord.
24.
And 2011 in that they have not paid
Next week.
I
compensation.
filed last week only, my
Next week,
deeply obliged.
the request of respondent call next week.
My lord, a date may be fixed, my lord. Otherwise, in B group,
Next week, date for us, roster change ಆಗುತ್ತೆ.
26th, 26th, let him file objection because acquisition they
many
are not
matters are there
disputing.
and it's a CPC day. Yeah.
64 adjourned. 65. B. Vachan.
ಏನ್ರಿ ನೀವು petitioner
Prashant.
Private petition. Acquisition is for the Karnataka Neeravari Nigam Limited. Upper Tunga project. Lordship, I kindly come to page 55.
Prashant.
ಬರ್ಬೇಕು ಅದರ್ ಸೈಡ್
Interim production ಏನಾದ್ರು support.
Then what is your case, tell me?
My lord.
What is your case, tell me?
My lord, of 9 acre 34 guntas in survey number 68, award has been passed only for 1 acre 34 guntas, no award passed for balance 8 acres. And for survey number 70, out of the total 4 acres, award has been passed only for 20 guntas, not the balance extent. Now, my lord, the thing is this land was notified for acquisition for the Upper Tunga project, saying that it might get submerged in water, the backwaters. Now, my lord, after all these many years, we see that there is no submergence of this part of the land for which no award has been passed. So the authority is consciously not passed the award because this land is unlikely that it is needed for them. And therefore, I am seeking for the quashing of that.
Yeah. The case of the petitioner is that his lands have been acquired. ಬರ್ಕೊಳ್ಳಿ madam. Dictation ಕೊಡ್ತೀನಿ. The case of the petitioner is that his lands have been acquired for Upper Tunga project. Case of the petitioners is that their lands have been acquired. Petitioners plural. Their lands have been acquired for Upper Tunga project. In order pass ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ. Please, because he is not the
Please.
Upper Tunga project, but only a portion of the land has been submerged, and the remaining portion to an extent of
8 acre 20 guntas.
8 acres 20 guntas has not.
I'm sorry, my lord. 11 acres 20 guntas.
Submerged ಆಗದಲೇ ಇರೋ portion ಎಷ್ಟು?
11 acres 20 guntas.
11 acres 20 guntas has not been submerged. Submerged. Full stop. It is submitted that in spite of acquisition, way back in the year
2009. Notifications of the year 2008, 2009, my lord.
ಆಯ್ತು ಇಷ್ಟೆಲ್ಲ ಯಾಕಬೇಕೆಲ್ಲ ಸ್ಕ್ರಾಪ್ ಮಾಡಿ advocate for the petitioner present, advocate for respondent absent. Call on 25th. 25th ತಾರೀಕು.
Please, madam.
ಏನ್ ಬೇಡ ಅವ್ರು ಬಂದಿಲ್ಲ ಅಂದ್ರೆ
Please.
We will allow the writ petition.
66 adjourn, 67, K. R. Ramesh, C. Chennaigoda, here for petition this matter.
Responding.
In the previous date, my lord, dishonorable court direct to KADB to take instruction regarding whether the rival claimant is there or not. Whether any rival claimants in this matter.
See, page number 53, madam. May I read, madam? ಈ ಜಮೀನು ಭೂ ಪರಿಹಾರವನ್ನು ಪಿ ಎನ್ ಶ್ರೀನಿವಾಸ್ ಬಿನ್ ಲೇಟ್ ನಾರಾಯಣಪ್ಪ ಎಂಬುವರು ಕ್ಲೈಮ್ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಜಮೀನಿನ ಭೂ ಪರಿಹಾರ ಪಾವತಿ ವಿಚಾರದಲ್ಲಿ ನಾಗರಾಜ್ ಬಿನ್ ಲೇಟ್ ನರಸಿಂಹಯ್ಯ, ಗೋಪಾಲ ಬಿನ್ ಲೇಟ್ ನರಸಿಂಹಯ್ಯ, ಜಯರಾಮ ಬಿನ್ ಲೇಟ್ ನರಸಿಂಹಯ್ಯ, ಲಕ್ಷ್ಮೀಪತಿ ಬಿನ್ ಲೇಟ್ ನರಸಿಂಹಯ್ಯ, ಅಚ್ಚಮ್ಮ ಕೋಮ್ ಲೇಟ್ ನರಸಿಂಹಯ್ಯ ಮತ್ತು ಕೃಷ್ಣಪ್ಪ ಲೇಟ್ ನರಸಿಂಹಯ್ಯ ಎಂಬುವರು ತಕರಾರು ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಖಾತೆದಾರರು ಮತ್ತು ತಕರಾರುದಾರಿಗಳಿಗೆ ಕಲಂ 9 ಮತ್ತು 10 ಅನ್ವಯ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿ ದಿನಾಂಕ 23/11/2022 ಪ್ರಕರಣ ಕೂರಿಸಲು ಸದರಿ ವಿಚಾರಣೆಗೆ ಉಭಯತರು ಗೈರು ಹಾಜರು. ಪ್ರಕರಣವನ್ನು 29/11/22 ಕೂಗಿಸಲಾಗಿ ವಾದಿಯ ಪರವಾಗಿ ಮಗನಾದ PN ರವಿಕುಮಾರ್ ಹಾಜರಿರುತ್ತಾರೆ. ಪ್ರತಿವಾದಿಗಳು ಹಾಜರಾಗಿ ತಮ್ಮ ಒಟ್ಟು ಕುಟುಂಬದ ಆಸ್ತಿಯಾಗಿದ್ದು ತಮ್ಮಗಳಿಗೆ ಪರಿಹಾರವನ್ನು ಪಾವತಿಸಲಾಗಿರುತ್ತದೆ. ಅಂದ್ರೆ they are not made parties to this writ petition. Therefore, I pray for dismissal.
My lord, in this matter, as per the instruction given by the senior, my lord, there is there is no rival comments.
He says there are rival claimants.
I will take instruction, my lord. Kindly have it on next week.
What instructions? He is saying on oath there are rival claimants.
Otherwise, my lord, kindly have it. Day after tomorrow, I will take instruction and submit the writ. Day after tomorrow.
What type of arguments is this? When you find out you have no case, you want an adjournment. That's all. He submits there are rival claimants. What to do?
I will take instruction, my lord. In case any rival claimant is there, I will take necessary steps in this.
Read it. The records itself speaks that there are rival claimants.
Otherwise, my lord, I will include the rival claimants in case any rival claimants is there. I will
Dispose it of.
My lord, one request, my lord. Kindly have done tomorrow, my lord, I will take instruction and I will submit. Please. One request.
The request of petitioner call on day after tomorrow. Date.
Fine. 68, Vijay Kumar K. Chandrasekhar.
Representing for petitioners. Petitioners are challenging the preliminary notification issued by the KDB dated 12/7/2022. Not to dispose as seeking, my lord. We are the residential building is there and we are constructing by obtaining the license from the Gram Panchayat. Hollow bricks factory is running, my lord. I have produced the annexure. Page number may kindly look at photographs and Panchayat license, my lord, page 159. Not to dispose as, my lord, we are seeking.
Case of the petitioner is that KDB has acquired their lands, or his land, or
His land, survey number 30/4.
The
30/4.
petitioner is that his lands, which are the subject matter of the writ petition, has been acquired for the purposes of KADB. In spite of the land being fully developed and buildings being erected thereon. Full stop, it is submitted, the petitioner has not, it is submitted, but for that reason, respondents are directed not to dispose the petitioner from the lands which are the subject matter of the writ petition.
Is not already. If not already.
It is not already
Dispossessed.
The interim order shall continue till next date of hearing.
It's 70, 69 adjourn. 70, Anand L. C. Ramakrishna.
For the petition in this matter. This is the petitioners are the
owners of land bearing survey number 356, measuring an extent of 4 acres 34 guntas for the purpose of KDB ROL industrial area third stage minutes, wherein the preliminary notification is passed in the year 2006 and the final notification is passed in the 2010, and the award is passed at the later stages, which is in the year 2014, November minutes. Since there was a dispute with regard to the petitioners is concerned there, and the award is being deposited by way of general award before the trial courts. So by way of which we are not taken any compulsion so far. Now the case has been settled among us between the petitioners, and the compromise has been drawn, and I also filed the compromise petition and compromise decree before this honorable court annexure G, wherein since I have not taken any compensation so far under section 29 subclass 2, I am entitled for the compensation as per the consent by way of agreement, and also there is a annexure.
The disputing parties eligible.
Only between the family members, not with respect to the respondents.
Now you have all settled.
Yes, it's a compromise decree along with the compromise petition is also filed.
Consent award.
Next year, K-Nelly letter, our letter is
And also this
on deposits,
I made a representation to the respondents,
Withdraw to consent award.
consent of.
and also this honorable court has passed.
Madam, general award to consent award. ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ವಾ ಬರ್ಕೊಳ್ಳಿ ಹೇಳ್ಬಿಡ್ತೀನಿ ಅಲ್ಲಿ ಚೇಂಬರ್ಸ್ ಅಲ್ಲಿ ಇರುತ್ತಾ certain land of the petitioner in survey number so and so has been acquired for the purpose of respondent number so and so KDB. Two five four three seven 23 ಏನ್ ಹೇಳುತ್ತಾ? 25437 23 the writ petition.
That I annexed it as annexure H annexure H, my lords, by page number 67. Annexure is.
Based on this judgment only can decide by judgment. ಅದೆಲ್ಲಿದೆ?
Survey number ಎಷ್ಟು?
356, madam.
Chiluru village,
Please.
Survey number 356 of Chiluru village. ಮಿಕ್ಕಿದ ಇದೇ ತರ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ.
Same. I'm sorry, my lord, I was on my leg.
No problem.
Please, great.
You should encourage your colleagues to argue
No,
these
my
types
lord.
of matters. No problems.
Great.
Confusion ಆದರೆ ಕೇಳಿ ಹೇಳ್ತೀನಿ.
71. Part matter, Rajeshwar PN, Vachan.
Petitioner, lots.
Beಡಿ go ಸೇರೋನ್ಗೆ.
Other three matters which my lords delinked, and I filed a memo for posting. That is not low posted, my lords. I'm just saying that that is not parted. Delink ಆಗಿತ್ತು ಅದನ್ನ ನಾವು
ಆಯ್ತು,
memo
ನಾಡದ್ ಪೋಸ್ಟ್ ಮಾಡಿ ಅದು we had heard it substantially, but
ನಂಬರ್ ಕೊಡಿ ಸರ್.
ನಂಬರ್ ಕೊಡಿ, ನಾಡದ್ ಪೋಸ್ಟ್ ಮಾಡಿಸಿ.
ಸರ್ ಈಗಲೇ ಕೊಡಿ, ಲಿಸ್ಟ್ ಎಲ್ಲ
ಡೇಟ್ ಏನ್ ಬೇಡ, ಡೇಟ್ ಚೇಂಜ್ ಮಾಡಬೇಕು.
ನಾಡದ್ ಪೋಸ್ಟ್ ಮಾಡಿಸಿ ಹೇಳಿ. ನಾಡದ್ದು ಲಿಸ್ಟ್ ಅಲಾಂಗ್ ವಿತ್ ಅಂತ ಅಲ್ಲ, ಆ ಮೂರು ನಾಡದ್ ಪೋಸ್ಟ್ ಮಾಡಿಸಿ ಅಷ್ಟೇ. ದಿಸ್ ಐ ವಿಲ್ ಹಿಯರ್ ಇಟ್ ನೌ.
ವಚನ್ ವಚನ್.
At 1:30, he asked me whether you are going on with the matter. I said I'll be here till 3:30, but 3:30 I have one matter in commercial court. But 1:30 my lords were a little hot, so I did not want to take an adjournment at 1:30. Must kindly see this judgment, my lords, then I leave it to my lords. I understand my lords dilemma, whether to entertain this writ petition when the writ appeal is pending, pass any order. Lords, kindly see para 27, my lords, of this judgment. One more. What then are these sub-rights or strands of this Swadeshi constitutional fabric? My lords gets it? Constituting the right to property. 7 such sub-rights can be identified, albeit non-exhaustive. These are duty of the state to inform the person that it intends to acquire his property, that is right to notice. Duty of the state to hear objections to the acquisition, the right to be heard. The duty of the state to inform the person of its decision to acquire, the right to a reasoned decision. The duty of the state to demonstrate that the acquisition is for public purpose, the duty to acquire only for public purpose. The duty of the state to institute, restitute and rehabilitate, the right of restitution or fair compensation. The duty of the state to conduct the process of acquisition efficiently and within prescribed time limits of the acquisition, the right to an efficient and expeditious process. And 7, the final conclusion of the proceedings leading to vesting, the right of conclusion. Well, there are totally 7 rights that a landowner would have. Now, the writ petition or writ appeal, which is pending, my lords, would be falling within the first 4 rights, my lords. So whether there is no notice given, whether it has been heard, whether a reasoned decision is given, whether it's for a public purpose, it is at that stage. The other 3 stages, my lords, we have not reached. So in this writ petition, what I'm contesting is the 7th point, my lords, urging the 7th sub-right, that the land has not vested with the government finally. Lords, may I kindly come to para 30.7. Upon conclusion of the process of acquisition and para 30.7. Upon conclusion of acquisition and payment of compensation, the state takes possession of the property in normal circumstances. The culmination of an acquisition process is not in the payment of compensation, but also in the taking over of the actual physical possession of the land. If possession is not taken, acquisition is not complete. With the taking over of actual possession after the normal procedures of acquisition, the private holding is divested of the right, title and interest in the property, along with the possession is vested with the state. Without final vesting, the state's or its beneficiaries' right, title and interest in the property is inconclusive and causes a lot of difficulties. The obligation to conclude and complete the process of acquisition is also part of Article 300A. Section 16 of the Land Acquisition Act, 4 and 5 of the Requisition and Acquisition of Immovable Property Act, 37 and 38 of the Right to Fair and Compensation, Transparency in Land Acquisition, Rehabilitation, Resettlement Act, and Sections 3D and 3 of National Highways Act recognize this right of the acquirer. This step of taking over possession has been a matter of great judicial scrutiny, and this court has endeavored to construe the relevant provisions in a way which ensures non-arbitrariness in the action of the acquirer. For that matter, after taking over possession, the process of land acquisition concludes with the vesting of the land with the concerned authority. The culmination of the acquisition process by vesting has been a matter of great importance. On this aspect, the courts have given a large number of decisions as to the time, method, and manner by which the vesting takes place. The 7 principles which have been discussed are integral part of the authority of law, enabling compulsory acquisition of private property. Upon the states State statutes have adopted these principles, and union and state statutes have adopted these principles and incorporated them in different forms in the statutes, provisioning compulsory acquisition of immovable property. The importance of these principles, independent of the statutory prescriptions, have been recognized by our constitutional courts, and they have become part of our administrative law of jurisprudence. Therefore, my lords, 7 rights are there. The writ petition and writ appeal referred to by the BDA are only in respect of enforcement of rights, some were 1 to 4. Whereas independent of that, even if those, there cannot be any illegality in those 4 proceedings. If I can point out that there's no conclusion of the proceedings as per the 7th sub-right, then my lords, independent writ petition is maintainable. Even if the writ appeal is held in favor of BDA, my lords, this right under 30.7 is still available. Therefore, my submission to my lords is the pendency of the writ appeal would not be a bar for my lords to exercise jurisdiction at 226 if my lords comes to the conclusion that possession is not taken in the manner known to law and therefore there is no vesting.
You should have asked Vachan to stay back.
Vachan was here only. I thought he will stay back. My lords.
If you can get him, find him.
I will.
Vasu.
Please.
$73. 3:30 in 15 minutes. 73.
Very well.
Sir, 73. No, coming back. End up in quotal numbers. $73.
Declaration ಕೊಟ್ಟಿದ್ನಲ್ಲ ಎಲ್ಲಿದಾವೆ? Sir.
ಹಿಂದೆ 73.
ನಮ್ದೇನಾ?
ಈಗ ಫಸ್ಟ್ ಯಾವ ಶೆಡ್ಯೂಲ್ ಎಸ್ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬಿಡಿ.
ಅದೇ, so far as my writ petition
Schedule
is
yes.
schedule yes, I'll just make few submissions regarding my writ petition. That is available in ink page 39 of my writ petition. Only 2 paragraphs the learned judge.
Second question.
Para number 4 in ink page 39. I may be permitted to read that. Further, the plaintiff is intending to insert item 9 to 12 of schedule yes. My lord. Ink page 39.
16806, right?
Alla sir, 15799. Nandu.
Sir, 16806 ನಿಮ್ದು.
ಅದರಲ್ಲೇ ತಗೋಬಹುದು. ತಾವು ಎಲ್ಲಿ ತಗೊಂಡಿದ್ರು ಅದನ್ನೇ ತಗೋ. Continuation. Whatever my lord sir. But page 39, para 3 is the one that relates to schedule yes.
That is, ink page number, what are the judgments, sir?
ಅಲ್ಲ ತಾವು
Para number ಹೇಳ್ಬಿಡಿ.
ಪ್ಯಾರಾ ನಂಬರ್ ಯಾವ್ದಕ್ಕೂ ಕೊಟ್ಟಿಲ್ಲ ಸರ್. ಜಡ್ಜ್ಮೆಂಟ್ಗೆ ಪ್ಯಾರಾ ನಂಬರ್ ಕೊಡ್ಲಿಲ್ಲ ಅವ್ರು ಜಡ್ಜ್.
ಅಲ್ಲ ಯಾವ್ದ್ರಲ್ಲಿ ಓದ್ತಾ ಇರ 16806 ಅಲ್ಲಿ ಬೇರೆ ಇದೆ.
ಸರಿ, 15799. 15799 ಅಲ್ಲಿ ಇಂಕ್ ಪೇಜ್ 39 ಪ್ಯಾರಾ 4. Further, the plaintiff is intending to insert item 9 to 12 of the schedule S. In this regard, plaintiff has produced the copies of sale deed so-and-so which are purchased by Rocky Muttappa, defendant number 1 in the case. It is pleaded by the plaintiff that those properties were also purchased out of the funds of deceased Yamar. The learned counsel for defendant 1 and 2 has vehemently argued in regard to referring to Benami Transaction Act and has stated that no suit, claim or action to enforce any right in respect of any property held Benami against a person in whose name the property is held or against any other person shall lie by or on behalf of the person claiming to be the real owner of such property. Here in the present case, claim of the plaintiff is a partition of the suit shall properties with regard to schedule yes. The plaintiff has let in evidence and has produced copies of the sale deed as per 127 to 134, which are in the name of wife of deceased M.R. Rekarai and also in the name of Rikirai, defendant number 2. Now the plaintiff intends to insert 4 more properties which are in the name of defendant number 1. The contention with regard to the existing suit schedule yes and the contention with regard to the proposed insertion of properties are one and the same. Said properties were not included either while filing the suit or were not sought to be included at the time of filing IA-9 or IA-28. The reason tendered by the plaintiff for inserting such properties at a belated stage is that she had come to the knowledge of the said properties recently. Kindly now see, I had made a wrong submission so far as the Benami Prohibition Act. What I read to my lord was the amended act. I had made a mistake. My apologies.
This was prior to amendment, is it?
Nan ತಪ್ಪು ಮಾಡಿದೆ. I had made a mistake. I have now got the unamended, original.
No,
The amendment.
Because this was before amendment. Huh?
Yes, ma'am. Because the properties were purchased in 2005. The amendment came into force on 1/11/2016. ಈ ಬುಕ್ಕಲ್ಲೇ ಇದೆ, amendment came into force on 1/11/2016. The properties were purchased on 16/2/2005. Section 3 subclause 2 of the original act carves out exception only to the wife and an unmarried daughter. So the act was not applicable so far as the son is concerned. The right to recover is made in section 4 subclause 3 only against co-partners. Kindly now see section 3 subclause 2. There is a change.
One
That-
second, one second, one second. ಹಳೆ ಬೇನಾಮಿ ಟ್ರಾನ್ಸಾಕ್ಷನ್
ನಾನು ಕೊಟ್ಟನಲ್ಲ ಸ್ವಂತ.
ಅಲ್ಲ ಇದೆ ಬಟ್ ತೋರಿಸ್ಬಿಡಿ.
ಇದರಲ್ಲಿ if I may be.
Yes.
3 subclause 2. Old and unamended. 1988. 88.
When did they get married second time?
16/11/2016.
The marriage was in 2016.
Second marriage for both of them. ಮೊದಲನೇ ಮದುವೆಯಿಂದ ಇಬ್ಬರಿಗೂ ಎರಡೆರಡು ಮಕ್ಕಳಿದ್ದಾರೆ. ಎರಡನೇ ಮದುವೆ ಆಗಿದ್ದು 16/11. ಕರೆಕ್ಟ್. 16/11/2016. So the property is purchased much before the marriage, admittedly.
This is prospective, no? This.
Yes, for prospect. And I request my lord to kindly see that is 3 subclause 2. No person shall enter into any benami transaction. Nothing in this subsection 1 shall apply to the purchase of property by any person in the name of his wife or unmarried daughter, and shall be presumed unless the contrary is proved that the said property had been purchased for the benefit of the wife or the unmarried. So more dates. The amendment came into force on 1/11/2016. The properties were purchased on 16/2/2005.
Yes.
And this act came into force in 1988. So I respectfully submit that so far as this item of property is concerned.
Yes. And schedule S only.
Yes.
Yes.
Section 4, not subsection 3. No suit, but I'll read the entire section 4. 4(1) and 4(2) remain, Lord, on the statute book in the same form and manner as it is there in
Okay,
this.
okay, read it, because see, admittedly, this amendment is prospective.
Prospective.
It's not
Also,
retrospective.
a child and a definition baralike,
Barala.
that exemption. But Lord, 4(3) is more or less same as 2(9), which my learned friend had read earlier on the previous date. 4(3), Lord, may I read? Or 4(1).
First in the, no
4(1).
suit, claim or action.
No suit, claim or action to enforce any right in respect of any property held benami against the person in whose name the property is held or against any other person shall lie by or on behalf of a person claiming to be the real owner of such property. So, my lord, I cannot file a suit if the property is benami. Then no defense based on any right in respect of any property held benami, whether against the person in whose name the property is held or against any other person, shall be allowed in any suit, claim or action by or on behalf of a person claiming to be the real owner of such property. So, my lord, the same on the converse, defense I cannot take. Then not subsection 3, nothing in this section shall apply. A is not applicable, where the person in whose name the property is held is a co-partner in a HUF and the property.
That's not
is-
applicable.
Does not. B, my lord, where the person in whose name the property is held is a trustee or other person standing in a fiduciary capacity, and the property is held for the benefit of another person for whom he is trustee or towards whom he stands in such capacity. That
What
is
is the
fiduciary
document?
capacity.
What is the document to show?
But between the son and father, but it is a
But that, my lord, will have to be a matter of trial, my lord, whether it
You
is.
should prima facie show. Prima facie show, what is the document?
But that document, I have no document, not no doubt.
Yes, anything else?
That's about.
Okay, now come to this one. Yadu, E.
None, my friend has finished. You want to say?
E, you want to sum up? E, schedule A.
A, my lord, to sum up. But I'll pass on the synopsis after submissions. Your lordship had said both of us to file synopsis. Lord, in so far as A is concerned, Lord, my learned friend has read 3 subsection 2. Lord, it is purchased in the name of the wife. So, Lord, Benami Transactions Act, again, they are also not applicable. That ground is not available under that project. Lord, para 17, Lord, at page 44, which my learned friend relied upon.
A is not, has nothing to do with Benami.
A has nothing.
A has got everything to do with amendment.
Yes, yes.
Nothing more than that.
Yes, Lord, again, I'm sorry, Lord, to revert back to the my learned friend's petition.
His argument is only confined to due diligence. That's all. He says his argument with regard to why A should not be allowed is section, order 6 rule 17 proviso.
Due diligence, yes.
Okay.
Yes.
Due diligence.
Yes.
There is no pleading as to due diligence, and he relies upon judgments of Supreme Court and submits that you have not exercised due diligence because number one, you had the knowledge of the property at the time of filing of the suit. It's not that you did not have the knowledge of the property at the time of filing of the suit. Then second, you made an application by way of IA number 9.
Yes.
Okay. He has opposed IA number 9. IA number 9 was not allowed. It was deferred. During the pendency of IA number 9, you filed for deletion of Schedule C and D properties.
Yes.
Schedule C and D properties were deleted. And this was item number 19 in Schedule D property.
Yes.
Okay. And then again you make IA number 28, which is again not drafted properly. Then you make this IA number 29,
30.
IA number 30, where you sought to re-include it. In the meanwhile, the same transaction has taken place.
Yes.
And the purchaser is a purchaser for valuable consideration. The case of the purchaser is that they have paid money to you. Isn't it?
Yes,
They have paid money to you. The case of the purchaser.
even he has given a complaint to the sub-registrar also that not to register the property in my name. I have taken, I'll place before your
All
lordship
this
that.
submission, I don't know from where my learned friend is making, that complaint was not in relation to this transaction or any earlier transaction.
Sir, I served the copy, please kindly look it.
It
I
is
served
not,
the copy.
it is not on record. Where our ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದಾರೆ ಅನ್ನೋದು, it's nowhere on record.
That's a
It could not
separate
have,
thing,
and it's a matter of.
trial.
Yes.
But the point is, you will have to establish, see, whether he is a bona fide purchaser for valuable consideration is a matter of trial.
Yes.
Or not, is a matter of trial. But you have to establish that in spite of due diligence, you are not in a position to carry out the necessary amendments.
Yes.
Okay.
Yes.
See, at 2 stages, one
IA number 9 and
at the stage of IA number 9, second at the stage of deleting it and once again trying to include it in the light of the Supreme Court judgments.
Trial got concluded. Trial got concluded. In the trial, all these documents, except these documents, everything else is there. She was aware. Trial. Cross-examination.
Even she has given a complaint to the sub-registrar not to register the document. when filing an IA 9
This
Excel.
this is an attempt to mislead, my lord. That complaint was given in the year 2021 when D22 was nowhere in the picture. For
See, he is harping on the thing of due diligence, Ashta.
yes, my lord, but not about this transaction. It was never about this transaction. Just point.
Forget the impleading applicant, you concentrate on the respondent. Yes.
AE, my lord. Yes, my lord. Lord, annex this IA number 9, my lord, at page 127.
IA number 9, ಈಗ ನಿಮ್ಮ ರೇಟ್ ಪೊಸಿಷನ್ ಬರೋಣ.
Yes, my lord.
1579.
Yes, my lord.
IA, where is IA number 9?
Page 127, annexure D, page 127. Lord, your lordship may kindly, Lord, bear in, have this, Lord, in, while considering this IA, trial had not commenced, Lord. IA number 9 at page 127, the affidavit in support at page 149.
Trial had not yet commenced.
Not yet commenced. IA number 9.
Trial had not commenced.
Not commenced.
MFA ನಡೀತಾ ಇದೆ.
IA number 9, affidavit supporting IA number 9, page 150, paragraph 5, 6 and 7. Lord, I say that I was not aware of any of the above transactions until recently, and hence challenge to the said documents could not be laid at the time of filing the above suit. I said that the said documents in relation to suit properties are illegal and not binding. Hence the illegal and not binding on me or my entitlement. Hence the said documents are required to be challenged by seeking amendment to the pleadings, prayers and schedule to the plaint in a manner and extent detailed in the accompanying application. I say that the non-inclusion of the proposed amendments in the original plaint was not wanton, but for aforesaid bona fide reason. I say that the amendment sought in the application will not alter the nature of the suit in any manner, and the relief sought are only consequential to the main relief of partition. Further, the trial has not yet commenced the above case and in the above case, and hence there is no legal impediment to allow the application, accompanying application. So, Lord, this is the pleading insofar as, Lord, IA number 9, pre-trial. Then, Lord,
ಇದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಏನ್ ಹಾಕಿದ್ರು ಅವರು?
Some
ಅಬ್ಜೆಕ್ಷನ್ ಏನ್ ಹಾಕಿದ್ರು?
objection ಹಾಕಿದ್ದಾರೆ. Annexure. ಹಾಕಿಲ್ಲ ಅವ್ರದ್ರಲ್ಲಿ ಹಾಕಿದಾರ?
ಹಾಕಿಲ್ಲ
ನೀವು ಹಾಕಿದ?
ನೀವು ಇಟ್ಟಿಲ್ಲ.
ನೀವು ಹಾಕಿದೀರಾ?
ಹಾಕಿಲ್ಲ.
ಎಲ್ಲಿದೆ?
ಅಬ್ಜೆಕ್ಷನ್
ಎಲ್ಲಿದೆ?
Lord, in my friend's writ petition, page 189.
ಅದು IA 9 was wrongly shown as IA 11.
Page 189. This is the objection, Lord, to the IA number 9. Lord, paragraphs 1 to 15 of the objections, my lord, are all in relation to the amendments, proposed amendments. Paragraph 1 to 15 of the objections are all in relation to, are all, my lord, objections to the proposed amendments. Lord, the only objection your lordship will see at para 21, 22, 23 and 24. The averments made in the affidavit accompanying the amendment or amendment application are false and imaginary. It is submitted plaintiff who has made elaborate exhaustive statement in para 4 of her affidavit, has connived with D2021 and has compromised her illegal claim with them by receiving rupees 3 crores without even serving copy of the compromise petition and the advance application to the contesting defendants 1 and 2. This conduct of plaintiff would clearly demonstrate that she has not approached this court with clean hands. She has also not withdrawn her contentions made in para 4 of her affidavit subsequent to entering into compromise. The affidavit is extremely bald and do not indicate the exercise of due diligence by the plaintiff. The plaintiff has not explained as to when the contents of the application was not part of the pleadings at the earlier point in time. The documents clearly indicate that the plaintiff was aware of these transactions before she filed the suit. The amendment application is made subsequent to the order passed in the MFA number so and so, and therefore not maintainable. There are no bona fides in the application. The application is exhaustive, verbose and argumentative. It is not precise, and the relief sought are
FA 1891 pertain to what?
the TI application, IA number 1, which was substantially modified and this is the objections, my lord, filed by my lord friend to the IA number 9. Now, my lord, IA number 30. Lord, IA number 30. At page 255.
Your writ petition.
Yes, ma'am.
255,
255 is the application, IA number 30, annexure J. And the affidavit your lordship will see starts at page 260. But para 6, not the pleadings. I said that the property is described in 1 to 18. The lordships are at page 262, my lord. I say that the property is described in items 1 to 18 to the proposed schedule D to the amendment application in IA number 9 alone belong to Navilahalli plantation D3, and item number 19, that is Daitapura property, did not belong to the either Navilahalli plantation D3 or formed part of the compromise petition, as could be seen from the records. It was my intention to proceed with the amendment application by retaining item number 19 in relation to Daitapura property. However, instead of proceeding with the amendment by retaining the land survey number 36/2 of Daitapura property, Daitapura, by inadvertence, confusion, mistake and oversight, I had filed a memo that I do not intend to press the amendments to entire schedule D. It is pertinent to mention here that by considering my memo dated 6/3/2023, this honorable court had allowed IA number 9, the amendment as prayed. It is clear from the above facts that the said properties belong to my husband, Sri Muttapparai, and the sale of the Daitapura property by D1 and D2 by treating as if they are the absolute owners of the entire property, and by suppressing my share or rights in the said property, and
A was purchased in the name of mother of our
Mother.
D1 and D2.
the earlier wife, Lord, as she was. So these are the pleadings in relation to Lord, IA number 30 in support of Order 6, Rule 17.
When did the first wife die?
2012, Lord.
2012.
13.
Husband died in the year?
2013. Husband, Lord, 2020.
15/5/2020.
Okay, revenue documents after 2012 stood in his whose name?
ಇದೆಲ್ಲ ಇವರು ಅಲ್ಲ ರೆವಿನ್ಯೂ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ stood in the name of D1 and D2 after the death of Rekarai.
Now, after the death only, Lord, it was changed to D1 and D2.
Correct. These properties are of Rekarai.
Yes.
And para 9 also, Lord, at page 263. Para 9, Lord, may I read, Lord? I say that I was not aware of the existence of the property at the time of filing of the suit, and memo in respect of Daitapura property was filed by me for not pressing the amendment in relation to Daitapura property was a mistake, confusion on account of voluminous records and large number of properties in the case. Hence, the amendment to the pleadings, prayers and schedule to the plaintiff to lay a challenge to the said deed are absolutely necessary. I say that I had not given up my claim in respect of Daitapura, but had merely filed a memo not pressing certain amendments, in which by oversight I had included the property in Daitapura, that is how, that is now sought to be included under the accompanying application. I say the property is now sought to be, will not prejudice the rights of the suit. This is insofar as AE is concerned. But my respectful submission also in respect, in relation to my learned friend's writ petition, Schedule S property. Lord, at this stage, this writ petition has also become infructuous for the reason, Lord, after the IA was allowed, Lord, I have filed an amended plaint. Lord, my learned friend has filed additional written statement. Thereafter, Lord, additional issue is also framed. We have led evidence, been cross-examined also. Lord, to the extent of Lord, Schedule S, Lord, the writ petition would, in my respectful submission, would be infructuous because all the consequential actions have already taken place. But it is only for the trial court now to decide whether there is any right in the Schedule S property 9 to 12 with the plaintiff. But insofar as A is concerned, Lord, this is my respectful submission. But in reply to what my learned friend had submitted the other day, he had submitted, Lord, relied upon a judgment of the Honorable Supreme Court. Lord, my learned friend's memo dated 19/6/2024 with 9 judgments. In that, Lord, the 4th judgment my learned friend relied upon, Virgo Industries versus Venture Tech Solutions. Lord, to respond to my submission in relation to Order 2, Rule 2. Lord, I have relied upon judgment of the Honorable Supreme Court in the case of LIC versus Bharat Sanjeev Builders, where their lordship would say that Order 2, Rule 2 is not applicable within the same suit. Lordship recollected, no? Within the same suit, Order 2, Rule 2 will not apply. But in this judgment, Lord, at page 44, my learned friend relied on only para 17 at page 44 of this judgment. Lord, this judgment, para 17 itself would reveal that this was in a case, in the facts of that case, in a case where there was a subsequent suit. So their lordships would consider applicability of Order 2, Rule 2. Lord, I'll read para 17. The learned single judge of the High Court had considered and very rightly to be bound to follow an earlier division bench in R. Vimlachand holding that the provisions of Order 2, Rule 2 CPC would be applicable only when the first suit is disposed of. As in the present case, the second set of suits were filed during the pendency of the earlier suits. It was held on the ratio of the aforesaid decision of the division bench of the High Court that provisions of Order 2, Rule 2, Sub-Rule 3 will not be attracted. Judicial discipline required the learned Lord, your lordship has, Lord, memo dated 19/6/24 of my learned friend. There, Lord, ink page 44. It is judgment number 4 in the list of judgments.
Para 17.
Para 17. Yes, Lord. May I read, Lord? The learned single judge of the High Court had considered and very rightly to be bound to follow an earlier division bench order in R. Vimlachand versus Ramlingam, holding that the provisions of Order 2, Rule 2 CPC would be applicable only when the first suit is disposed of. As in the present case, the second set of suits were filed during the pendency of the earlier suits. It was held on the ratio of the aforesaid decision of the division bench of the High Court that provisions of Order 2, Rule 2(3) will not be attracted. Judicial discipline required that the learned single judge of the High Court to come to the aforesaid conclusion. However, we are unable to agree with the same in view of the object behind the enactment of the provisions of Order 2, Rule 2 CPC, as already discussed by us, namely that Order 2, Rule 2 CPC seeks to avoid multiplicity of litigation on the same cause of action. If that is the true object of the law, on which we do not entertain any doubt, the same would not stand fully subserved by holding that the provisions of Order 2, Rule 2 CPC will apply only if the first suit is disposed of and not in a situation where the second suit has been filed during the pendency of the suit. So, my lord, this is in the facts of that case, there are two different, one earlier suit, one subsequent suit is involved. Order 2, Rule 2, they said is applicable. In this instant case, my lord, squarely covered by LIC versus Sanjeev Builders, where the lordships would say Order 2, Rule 2 within the same suit does not apply. Then, my lord, 6 Rule 17, same Sanjeev Builders, my lord, LIC versus Sanjeev Builders, para 17, lord, guidelines are framed.
Sanjeev Builders, where is it?
But I had given it separately. I have not yet put it in the list for my lords. But separately, it's a standalone single judgment.
What is it?
ಅಲ್ಲ ಇವತ್ತಿನ ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಕೂಡ ಇದೆ ಬಟ್ ಸೆಪರೇಟ್ಲಿ ಇದೆ ಲಾರ್ಡ್ಶಿಪ್ ವಾಂಟ್ಸ್ ಟು ಮೇಕ್ ಯೂಸ್ ಆಫ್ ದಟ್ ಲಾರ್ಡ್ಶಿಪ್ ಹ್ಯಾಸ್ ಟುಡೇ ಸಿನಾಪ್ಸಿಸ್
ಗೊತ್ತಾಯ್ತು
Page 13. Page 13, the judgment starts. About order 2, rule 2, my lord, it is, the conclusions are there, my lord, at
Paragraph.
for order 2, rule 2, my lord, para 43 to 48.
ಎಲ್ರಿ ಅದು ಯಾವ ಬೇರೆ ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಅದು ಕೊಡಿ ಯಾವ್ದು ಹೇಳಿ ಅದು ಜಜ್ಮೆಂಟ್ ನೀವು ರಿಲೇ ಆಗ್ತಿರೋದು
My lord, your lordship may kindly take the synopsis that I have submitted today. 15,799 synopsis, sir.
ಇವತ್ತು ಕೊಟ್ರಲ್ಲ ಸಿನಾಪ್ಸಿಸ್
ಅದರಲ್ಲಿ ಅದರಲ್ಲಿ ಪೇಜ್ 13, 15,799. Your lordship has 15,799 synopsis. Page 13, LIC versus Sanjeev Builders. It starts from para 43 about order 2, rule 2.
ಇದೆಲ್ಲ ಇದೆ ಹಾ 2022 SEC
Yes, yes,
online
yes,
11/28
I'm
paragraph
43 onwards, 43 to 52 for order 2, rule 2 finding.
ಕೊಟ್ಟಿಲ್ಲ ಇದ್ರಲ್ಲಿ ಇದು ಬೇರೆ ಇದೇನೋ ಹಾಕ್ಬಿಟ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಇದರಲ್ಲಿ ಇಲ್ಲ ಅಂತ
The lordship is having today's synopsis.
ಇವತ್ತಿನ ಸಿನಾಪ್ಸಿಸ್ ಕೊಡಿ ಇವತ್ತಿನ ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅದು
15,719. Your lordship, no, there are two synopses today, my lord, in two writ petitions. If ಅದೇ 15,799 synopsis ಇದರಲ್ಲಿ page 20
ಇದೆಲ್ಲ ಓದಾಗಿದೆ ಅಲ್ಲ
22 ನಲ್ಲಿ.
Leonard friend has read all this.
ಕರೆಕ್ಟ್ ಜಸ್ಟ್
I won't have sufficient time to reply also. 4 ಗಂಟೆ ಆಗುತ್ತೆ.
ಹೌದು 22 ಅಲ್ಲ
Leonard friend has gone through all this.
No, I just want to mark the paragraphs. I need to write the judgment.
ಟೆನ್ಷನ್ ಮಾಡ್ಕೊ. ಹೌದು ಟೆನ್ಷನ್
Paragraph?
ಪಾಯಿಂಟ್ ಔಟ್ ಟೆನ್ಷನ್. Para 43 to 52 for order 2, rule 2.
43 to
43 to 52 for order 2, rule 2. Then Lord, for order 6, rule 17, para 70. At page 30.
Okay.
Lord, the sum and substance of para 70, about 16 separate guidelines, my lord, is my lord, that it has to be liberally construed, the application.
Okay.
As long as the issue of limitation is not there, as long as, my lord, it does not bring out a new case, it has to be liberally construed. Then, my lord, I have relied upon other judgments of the coordinate benches of this honorable court, in which case, my lord, in which cases, my lord, in the same list of judgments in along with the synopsis that I have submitted, 5, 6 and 7, 3 judgments of coordinate benches of this honorable court.
ಏನ್ ಬೇಡ
ಅಲ್ಲ ಅದು it is all after trial, all of them, 5, 6 and 7. Then not the last of the judgments, item number 8 of a coordinate bench of this honorable court, I have submitted about equitable partition in relation to insofar as defendant number 22 is concerned. Lord, he is a necessary party to the suit. Lord, if I am successful before my lords in my writ petition, if my lord the suit continues, and if I am successfully able to, my lord, demonstrate to the trial court also,
yes,
Lord, then defendant number 2 also can seek, my lord, equitable partition.
ಇದು IA ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
Yes, my lord.
ಅದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಿ
IA 29, my lord.
ಆರ್ಡರ್ ಮಾಡಿಲ್ಲ
ಮಾಡಿಲ್ಲ ಅಲ್ಲ
ಅದ್ರ ಮೇಲೆ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. IA 29 ನೋ ಆರ್ಡರ್ ಸರ್.
ಅಲ್ಲ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್
ಮಾಡಿಲ್ಲ, ಯಾಕೆಂದ್ರೆ IA 30 was dismissed.
ಅಲ್ಲ ಇಲ್ಲಿ he has been impleaded?
ನೋ
ಇಲ್ಲ
ಎಲ್ಲ ಮಾಡಿದಿರಲ್ಲ.
ಅಲ್ಲ he has been named because not he was permitted to file objections, my lord, to IA 30.
Here he is a party, no?
Yes, my lord, he is a party.
ಸರಿ ಆಯ್ತು ಓಕೆ
Here is a party.
ಅಷ್ಟೇ ಅಲ್ವಾ?
That's all.
Yes, I'll dictate it on Monday.
ಅಲ್ಲ ನಂದೊಂದು 15 ನಿಮಿಷ
ನಂದೊಂದು ಸ್ವಲ್ಪ ಇದೆ.
ಒಂದು ನಿಮಿಷ ನಂದೊಂದು 10 ನಿಮಿಷ
Oh, sorry.
apart from due diligence. Then the other way of looking at it is AE. Kindly make a note of this.
Confine yourself to A.
AE ಅಷ್ಟೇ. Not more than 8 to 10 minutes also. 51 acres, 15 gunta. 51 acres, 1/3. Evidently,
51 acres.
this is the last limb of my argument, my lord. Apart,
51 acres, 15 guntas.
correct. This was
Right, so 51 acres, 15 guntas.
held by Rekarai. Muttaparai's share will be 1/3. Everything goes in their favor, everything goes against me. 1/3. 17 acres, 3 guntas. Aduralli 1/3, 1/3, 1/3. Because 2 sons and a wife. Each of them will get 5 acres, 38 guntas. So ultimate their entitlement, even if they succeed.
ಅದಕ್ಕೆ ಹೇಳಿದ 50 ಲಕ್ಷ ಕೊಡ್ತೀರಾ ಅಂತ.
ಅಲ್ಲ ಅದಕ್ಕೆ ಇನ್ನೊಂದು ಸಬ್ಮಿಷನ್ ಹೇಳ್ತೆ, ಅದು ದುಡ್ಡು ಕೊಡೋ ಪ್ರಶ್ನೆ ಬಂದಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. This is the last limb of my argument before I reply to my learned friend. 5 acre, 38 guntas. 5 acre, 38 guntas can always be sorted out because he is a bona fide purchaser from me at the time of final decree, if at all they succeed. Because the property in the fray is more than 75 acres. And this is not a Bangalore property. This is an agriculture property in
Got it.
Sakleshpur. We have properties all around, including Bangalore property, Devnalli, Yalanka, everywhere. Varthur, everywhere it's property. So it can be offset. This is the one kind of argument.
So
Kindly
this
see.
comes in final arguments.
Huh?
This comes in final arguments in before the trial court, not here.
So bit. My lord can.
It's only with regard to.
ಅಲ್ಲ, ಯಾಕೆಂದ್ರೆ ಈಗ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಅಲ್ಟಿಮೇಟ್ ಅಫೆಕ್ಟೆಡ್ ಪಾರ್ಟಿ ವಿಲ್ ಬಿ ದ ಪರ್ಚೇಸರ್, ಬಿಕಾಸ್ ಅಲ್ಟಿಮೇಟ್ಲಿ ಐ ವಿಲ್ ಅಫೆಕ್ಟ್. ಯಾಕೆಂದ್ರೆ ನಾನು ಇಂಡೆಮ್ನಿಟಿ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅದು ಬೇರೆ ವಿಷಯ. ಬಟ್ ಅಲ್ಟಿಮೇಟ್ಲಿ ದಿಸ್ ಕ್ಯಾನ್ ಬಿ ಸಾರ್ಟೆಡ್ ಔಟ್ ಇಫ್ ದ ಕೋರ್ಟ್ ವರ್ ಟು ಟೇಕ್ ಅ ಲಾರ್ಜರ್ ವ್ಯೂ ಇನ್ ದ ನೋ ಕ್ವಶನ್ ಆಫ್ ಪೇಮೆಂಟ್. ಇಟ್ಸ್ ಅ ಕ್ವಶನ್ ಆಫ್
agreed. See, they're all.
ಮೈ ಲಾರ್ಡ್ ವರ್ಟ್ ಜನರಲಿ ನಾನು ನೋಡ್ತೀನಲ್ಲ, ತಾವೇನ್ ಮಾಡ್ತೀರಾ ಅಂದ್ರೆ ಸಾರ್ಟ್ ಔಟ್ ಮಾಡಕ್ಕೋ, ಮೊನ್ನೆ ಅವ್ರದ್ದು ದೊಡ್ಡ ಮ್ಯಾಟರ್ನ ಹಂಗೆ ಸಾರ್ಟ್ ಔಟ್ ಮಾಡಿ KIDB ಆ ಒಂದು ಆಂಗಲ್ ಅಲ್ಲಿ ಹೇಳಿದೆ. ದಿಸ್ ಇಸ್ ನಾಟ್
Ultimately, I'll tell you, they have the onus is on them. You are setting up a will. You are setting up a will. Okay. You will be proving that will. Supposing you establish the will, they don't get
anything. They won't get it.
Okay. The fact that revenue entries are changed into children name and not in the husband name. Affidavits produced over there.
Everything will come to before the court.
All these things will be coming
Subject
before the
matter of
court.
scrutiny.
Worse come worse, it is not proved, even bill is not established. Still, if he is a bona fide purchaser for valuable consideration,
Still he gets goes away.
for his mistake,
ಅರ್ಥ ಆಯ್ತು?
okay? Huh?
ಈಗ there is another judgment which I cited in the MFA, same between the same parties. 2006 SCC, Gurudas anta tavu probably my lords might have come across with your long and rich experience. Adರಲ್ಲಿ this is suit for partition. Karnataka ಇಂದ ಹೋಗಿದೆ, Bangalore City Civil Court. The Supreme Court says in a case of this nature where multiple properties are there, the watch and ward, everything, the other side also, that is the plaintiff who doesn't do anything other than giving 200 rupees stamp paper and goes on asking for so many benefits before the court. The Supreme Court comes down heavily and says that you will have to be put on terms, because the generally partition suits goes on for a longer time than the other suits. Therefore, Supreme Court says in 2006 SCC, Gurudas case, that the plaintiff will have to be put on terms because the watch and ward, taking care of the property, it doesn't come free of cost for the plaintiffs. I'll produce this ಇಲ್ಲ 2006 SCC ಇದೆ, ಆ ಕೇಸಲ್ಲೇ ಕೊಟ್ಟಿದ್ದೆ. ಇದು ಈ ನಮ್ಮಿಬ್ರಲ್ಲೇ MFA ಕೇಸಲ್ಲಿ ಕೊಟ್ಟಾಗ I argued before the court at that point in time, saying that they were just filed the partition simpliciter saying that these properties were owned by MR. Therefore, I'm entitled 1/3 without seeking for any cancellation of all these documents. So the court found favor in my argument. Thereafter, IA-9 was filed. So the reason for IA-9, it is not that I pointed out, it was subsequent to the first institution. Now coming back to this question of due diligence, my lord, kindly see. She had the benefit during evidence. Evidence was conducted for more than about 40 days. Their chief examination took place about 8 to 9 days because voluminous documents. Then cross-examination continuously for 30 days. At that point in time, nothing was stated. Kindly see, my learned friend did not read even for the second time, third time also, the affidavit concerning IA 30. That is most relevant for my lord's kind consideration. The only statement that is made is oversight.
Oversight mistake.
Oversight mistake. And the judgment that IA 28, they don't make a mention here before this court. My lord said, leave it at that. So I'm not pressing it again because I did make a mention of this, that before this court, IA 28 was not mentioned. My lord said, don't press that. In IA 30, except this, directly this is covered by the judgment of the apex court, wherein say in a similarly circumstanced matter, they had said that it is by oversight, we did not do it. So here, my lords may kindly see the length of time. That's
Judgment you had quoted that. Really?
That is at judgment court number.
1960.
8-7 ಅಲ್ಲ ನಾನು ಕೊಟ್ಟಿರೋದು ತಮಗೆ 8-7 ನಾನು ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ. ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡು 8-7.
Judgment is yesterday.
ಅಲ್ಲ ಒಂದು ನಿಮಿಷ ಕೊಟ್ಟು 8-7 ಮೊದಲನೇ ದಿನನೇ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ along with my first, that is on 6th month. Right, 6th month. ನಾನು ಕೊಡ್ತೀನಿ ಜಡ್ಜ್ಮೆಂಟ್.
First judgment with
ಬಸವರಾಜ್ ಅಂತ ಅನ್ಸುತ್ತೆ. My memory goes ಬಸವರಾಜ್. Yes, ma'am. Ink page. Second judgment starts from page 10. I request my lord to kindly see para 8 at ink page 18.
First judgment Vidyabai, that compilation.
ಮೊದಲನೇ ದಿನ ಕೊಟ್ಟು 6th month. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೊಡಿ, ನಾನು ಕೊಡ್ತೀನಿ.
ಎಷ್ಟನೇ ಜಜ್ಮೆಂಟ್ ಇದು?
ಎರಡನೇ ಜಡ್ಜ್ಮೆಂಟ್ commences from page 10, requesting my lord to see page 18 last 3 lines. ಓದಲ್ಲ, I won't read.
Yes.
ಇದರಲ್ಲಿ kindly see entire para where line 6 says all that was pleaded was oversight. ಇದರಲ್ಲೂ ಅಷ್ಟೇ. Now I will immediately take my lord to ink page 263 of my learned friend's writ petition. Last line. Kindly see, same thing that they have pleaded. I will read one sentence of his affidavit, para 10, line 3. His writ petition, IA 30, affidavit. I say that I had not given up my claim in respect of the Daitapura property, but had merely filed a memo not pressing certain amendments in which by oversight I had not included the property. Same oversight was the one that was. Kindly thereafter see page 20, para 9, line 5. Order 6, rule 7 prevents an application for amendment after trial has commenced unless the court comes to the conclusion that despite due diligence, the party could not have raised the issue. Here, during evidence also, I am repeatedly stressing on that. There was not one statement that was made. So far as this property is concerned, leave to amend may be refused if it introduces so and so. And in page 21 as well. Kindly now see the last judgment that I have. Idu bari due diligence mele. The last judgment in page 21. Monne kottitson. Ada in the last. Innon memo hakidini. This memo was filed on 8/7. Last judgment. I was reading it avaga bere eno aitu last time adu. Idin ಓದ್ಲಿಲ್ಲ ನಾನು. Last judgment 8/7 ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋದು.
9/7
in page 21.
Shobha Surendra.
Yes, ma'am. ಐದನೇ line head note ಅಲ್ಲಿ. Due diligence discussed. It is clear from the amended proviso that no application for amendment shall be allowed after trial has commenced unless the court comes to the conclusion that despite due diligence, party could not take up the plea before commencement of trial. Object behind insertion of the so-and-so enacting a bar for a party to commend at any stage apparently to check the delays. Once the trial commences on known pleas, the parties are required to proceed with their case without resorting to amendment. Kindly now, in page 23, line 2. The present suit is filed in 99. Written statement was filed on 2006. Issues were settled long back. Plaintiff evidence was completed. Ella ide ತರ ಆಗಿದೆ. Written statement was filed within 6 months or 4 months from the date of institution. ತೀರ್ಕೊಂಡಿರೋದು 15/5/2020. Suit is filed on 1/7/2020. Within a span, ಅದು ಎರಡನೇ ಇದೇ ಆಗಿರಲಿಲ್ಲ. 1/7/2020, the suit is filed. Written statement is filed somewhere in the month of November 2020. Thereafter, the IA orders were passed and to and fro e court ಬಂದು ಆಮೇಲೆ direction to dispose the matter. When the evidence of the defendants was to commence, present application is filed. Evidence ಶುರು ಮಾಡಿದಾಗ ನಮ್ದ್ರಲ್ಲಿ ನಮ್ಮ evidence ಹಾಕಾದ್ಮೇಲೆ ಇಲ್ಲಿ our cross examination ಆಗಿ. Kindly now see with this background, page 26. ಇದರಲ್ಲಿ order 2, rule 2 ಸಹ one of the points. Para 6. The court below has dismissed the application holding that as the petitioners did not establish that in spite of due diligence, they could not plead the facts sought to be incorporated by way of the proposed amendment in the written state. The amendment was not permissible in view of Order 6, Rule 17. It has also referred to the fact that as per the direction issued by this court, the suit was required to be disposed of by the end of July 2011. Namdrallo adu. 2023, there was a direction. And therefore, the amendment sought for, if granted, would result in protraction of the proceedings. The court below has also held that even in the absence of the proposed amendment, suit could be effectively, completely decided on merits. Similarly, circumstance. Even 28 ಅಲ್ಲಿ they withdrew. There also there is no due diligence that is pleaded. Same thing, what they did was, adrallu oversight and the pleading is oversight in IA 28. They did not explain why they withdrew IA 28 also. They filed a memo before the court, we will file. ಏನ್ ಮಾಡಿದ್ರು ಅವರು ಅಂದ್ರೆ IA 28 ಅಲ್ಲಿ ಇರೋದನ್ನ ಇನ್ನೂ ಆಡ್ ಮಾಡಿ. They added yes. IA 28 ಅಲ್ಲಿ yes ಇರಲಿಲ್ಲ. They added yes. Probably that's the reason why they withdrew. So the essence of the affidavit regarding due diligence is as bald as baldness could be. There is absolutely no effort that is made in the pleading. And the nature of events that have happened for long lapse of time from 21 till 2024 has not been brought about. And then they did not seek for any statement saying that this is what that has prevented me. In spite of me giving evidence, I could not get it. These were the reasons I could not get it. That benefit the trial court would have had and I would have had opposing that is not there. Therefore, it falls into the nature of thinking that has gone in the apex court as well as this court. And this idralli amendment ಹೇಳಿ kindly see in page 30 due diligence ಬಗ್ಗೆ ಇದು ಹೇಳಿ.
You have taken me through these things. I'll read.
ಇದು ಓದಿರಲಿಲ್ಲ ಸ್ವಾಮಿ, ಇದು ಓದ್ತೀರಿ, ನಾನು ಓದಲ್ಲ. Para 13.
13.
Thus, what is important to be noticed is whether the petitioners/defendants in the instant case have shown, despite exercise of diligence, they could not have raised the plea.
Do you have any case law where similar incidents has happened? They seek to introduce, then they delete it, then reintroduce.
ಆ ಥರ ಇದೆಯಾ ಅದೇ ಹುಡುಕ್ತೀನಿ ಆ ಥರ ಇದರಲ್ಲಿ ಇದೊಂದು ಚೂರು ಓದ್ತೀನಿ ಸ್ವಾಮಿ. Despite except diligence, they could not have raised the plea which is now sought to be raised by way of amendment before commencement of trial. The court below has found that there was no such diligence and the said essential requirement was not satisfied. Idrallu ade essential requirement is not satisfied because evidence ಆದ್ಮೇಲೆ ನನ್ನ evidence ಹಾಕಬಾರ್ದು. This is the one that illuve kindly see the next page ಅಲ್ಲಿ 16 para 16 ಅಲ್ಲಿ ನಾನು ಯಾವ judgment ನ cite ಮಾಡಿದೀನಿ, same judgment is also relied upon by this honorable court at an earlier point in time. That is Vidya Bai's case. We are also relying upon this. So then in para 19, they have said that this is the amendment, itara agide anta heli, then the application was dismissed. Bidu. ಈಗ ಡ್ಯೂ ಡಿಲಿಜೆನ್ಸ್ ಈಗ ನಮ್ಮ ರಿಟ್ ಪಿಟಿಷನ್ ಇದನ್ನೇ ನಾನು ಹೇಳಲ್ ತಾವೇನು ನೋಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಮೈ ಲಾರ್ಡ್ ಮೈ ಕೈಂಡ್ಲಿ ನೋಟ್ ದಿಸ್ ಇನ್ ದ ಮೈಂಡ್. ದೇರ್ ವರ್ 2 things that they had left. ದೈತಾಪುರದಲ್ಲೇ ಇನ್ನೊಂದು. What now they are trying to insert is 36/2 measuring 51 acres and odd. The one more was 14 guntas in 1/4. There is not a single statement that they have made as to why they are keeping this away. So effectually, they are not applied their mind even on this. There is absolutely nothing that is on record to say why they have left this.
Yes.
Next. If my lords are not convinced so far as order 2 rule 2 is concerned, my lords are not convinced, according to me, para 17 of the judgment, my lords can.
Para 17 of which judgment?
The one that my learned friend just read, which I have, nan prakara, multiple times have read it. Not, this was the one that I cited. Now, which one you just forgot?
The 2013 1 SCC 625.
I got it. This is Virgo Industries. This is page 35 of my compendium. Para 17. I had read this. I don't want to read it again. My learned friend just now read and made a statement that this is inapplicable. I beg to submit. I request my lord to kindly see para 17. I will not read it. Only requesting my lord to kindly see. There they say that ಇದರಲ್ಲಿ ಇನ್ನೂ ತುಂಬಾ ಜಡ್ಜ್ಮೆಂಟ್ ಬರಬೇಕು, ಆರ್ಡರ್ 2 ರೂಲ್ 2 ಇನ್ನೊಂದಕ್ಕಲ್ಲ ಈ ಕೇಸ್ಗೂ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿ. ಇನ್ನೊಂದು ನೆಕ್ಸ್ಟ್ ಪಾಯಿಂಟ್ I will not read. Point is order 23 rule 1. When we file an application, it amounts to abandonment. They have abandoned this particular aspect. So we need not take up this plea if they file a next case. It is gone. In the same suit, it is again come back. So what is abandoned? Therefore, I said that day that the estoppel is the gene. Res judicata, approbate and reprobate are the species about all this. So therefore, they cannot breathe hot and cold. Section 115 of the Evidence Act comes in the way.
Yes.
They have stated that they don't want, they have compromised. They can't introduce this. It amounts to a estoppel by conduct, estoppel by pleading. That is not open to a party. It need not wait for the subsequent suit. It can be in the same suit.
Yes.
Grateful.
Good. How much time you will take?
5 minutes.
10-15 minutes, man.
5 minutes, madam.
Lord, I'm submitting the synopsis and the documents and as well as the judgments, my lord. It's a classic case for perjury, my lord. Your lordship may kindly peruse the documents now I have sought to be produced, my lord. Please come to my lord the memo which I have filed along with the document. Please take page number 2. My documents, my lord. Today's documents. Page number 2. My lord, on 27/8/2021 itself, there was a complaint to the jurisdictional sub-registrar.
That is, what is this? This is an application. Page number 2.
Page number 2. ನಾನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಎಸ್ ಮೈ ಲಾರ್ಡ್, ದ ಸೇಮ್ ಥಿಂಗ್ ಮೈ ಲಾರ್ಡ್. ಕನ್ನಡದಲ್ಲಿ ಮೆಮೋ ವಿತ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂತ ಇದೆ. ಐ ಥಿಂಕ್ ಎಸ್ ಮೈ ಲಾರ್ಡ್, ಎಸ್ ಮೈ ಲಾರ್ಡ್. They have given a complaint through their advocate, Mr. Sulin, advocate and notary. Shall I read, my lord? ಉಪನಂದನಾಧಿಕಾರಿ ಆಲೂರು ತಾಲೂಕು ಆಲೂರು ಅನುರಾಧ ಮುತ್ತಪ್ಪರೈ ಕೋ ಮುತ್ತಪ್ಪರೈ. ವಿಷಯ ಹಾಸನ ಜಿಲ್ಲೆ ಆಲೂರು ತಾಲೂಕು ಹೊಸಕೋಟೆ ಹೋಬಳಿ ನವೀನಹಳ್ಳಿ ಪ್ಲಾಂಟೇಶನ್ ತಿಪ್ಪಾಪುರ ಮತ್ತು ದೈತ್ಯಾಪುರ ಗ್ರಾಮದ ಫ್ರೆಂಡ್ಸ್ ಕಂಟೆಂಡೆಡ್ ವಿ ಡೋಂಟ್ ನೋ ಎನಿಥಿಂಗ್ ಅಬೌಟ್ ದಿಸ್ ಅಂಡ್ ದಟ್. ನವಿಲಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ ಕೆಳಕಂಡ ಸರ್ವೆ ನಂಬರ್ಗಳನ್ನು ನೋಂದಣಿ ಮಾಡದ ಬಗ್ಗೆ.
Submitted a copy to him?
Yes, I served the copy, my lord.
Received. Yes.
Yes.
What do you say about this?
Yes, he has appended IA number 9 along with the MFA copies. And now he says that I don't know anything. I am the bona fide purchaser. I have secured these documents by RTI and inquired with the respondent number 1 and 2. As well as I gone through the pleadings of the court and as well as the memo file, the order passed by the trial court. What do I do, my lord? I have taken up the paper publication. You did not do anything. I have invested 3 and 4 crores. I have paid the money to through my the gentleman also. They have taken the money. And yet they files an affidavit stating that I did not know anything about the Daityapura property. It was a mistake. And they appended. It is not their case, my lord. She did not know the properties at all. Court al munde bandbiಟ್ಟು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಸ್ಪಿನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಪ್ಲೀಸ್ ಕಮ್ ಟು ಮೈ ಲಾರ್ಡ್, ಪೇಜ್ ನಂಬರ್ 10 ಆಫ್ ದಿ ಅಫಿಡೇವಿಟ್. ನೋಡಿ, ದೈತ್ಯಾಪುರ ಪ್ರಾಪರ್ಟಿ ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ಗೆ, ರಿಜಿಸ್ಟರ್ ಮಾಡಬೇಡಿ ಇದು ಅಂತ. They appended. I taken these documents through RTI and I made myself that this property is clear, it is not litigated.
When did you purchase?
I purchased the property, my lord, with the memo.
15/2/2024, annexure J1.
J1.
No, when did you purchase? Date of purchase?
Date of purchase, my lord.
15/2/2024.
24.
Annexure J1.
24.
Purchase,
Yes, my lord. ಅದಕ್ಕಿಂತ ಮೊದಲು ನಾನು ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ತಗೊಂಡಿದ್ದೀನಿ. ಕ್ಲೈಂಟ್ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ತಗೊಂಡೆ, IS ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ತಗೊಂಡೆ, ಆರ್ಡರ್ ಶೀಟ್ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ತಗೊಂಡೆ, ಮೆಮೋ ತಗೊಂಡೆ. My lord, I would like to draw your lordship's attention, my lord. They have contended that the lawyer has committed a mistake. The memo is filed by the very plaintiff itself. The memo is signed by the plaintiff and the advocate and record. They don't want to press. 5 crores has been invested and the coffee plantation is also there. I am the bona fide purchaser. In the light of these documents, my lord, can it be said that it is a mistake? MFA ಕಾಪಿನೂ ಎನ್ಕ್ಲೋಸ್ ಮಾಡ್ತಾರೆ, ಅದನ್ನು ನಾವು ತಗೊಂಡಿದ್ದೀವಿ. They suppress the very fact before your lordships as well as the trial court. The bona fide purchaser of this nature, my lord, he could not do anything more than this.
No. See, the point is, yes, they object to purchase of Navilahಳ್ಳಿ properties and Daitapura properties. By this is in the year 2021.
Yes, ma'am.
Okay, by that time they have filed IA number 9.
Yes, ma'am.
Okay, IA number 9 is unfortunately not decided by the court immediately.
I agree, ma'am.
It takes its own sweet time.
Yes.
Then you have this what
They filed a memo, my lord.
they
They filed a memo.
they entering into compromise with regard
Yes, my
to
lord.
Navilali Properties.
Then they filed a memo.
They filed a memo.
Yes, Bill. The order came to be passed.
Came to be passed.
Yes.
See, the point is, when the order came to be passed, after the order coming into pass, if they have done something of similar nature, before filing of IA number that
28.
28 or 30 as the case may be, then yes, what you say is absolutely right.
Millard, acquiescence, Millard, due diligence and acquiescence, Millard. Your Lordship may kindly peruse, Millard. I have cited a citation with regard to due.
ಇವರೆಲ್ಲ ಸ್ಕಿಮ್ ಚೀಟ್ ಅವೆಲ್ಲ ರೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಇಲ್ಲಿ ಬಂದು ಈ ತರ ಹೇಳಿದ್ರೆ
See, what is our case before the, what is our case before?
Sir, the question is, what happens? They file IA number 9 to implead. That is earlier to, to amend, that is earlier to starting of the trial. Okay. The affidavit filed in support of IA number 9 is sufficient to allow IA number 9 at that particular point.
Trial irlilla.
Trial earlier. That's the discretion of the court. Actually. Okay. S is different. Don't mix up with S. X, Benami, I think it's by and large clear with regard to that. But A, the issue is only regarding A. With regard to A, what happens? They file IA number 9. Unfortunately, court does not decide IA number 9. In the meanwhile, a compromise is entered into. They delete the properties. When we look at the compromise, it does not pertain to AE. It pertains to other properties in Schedule D, not the AE portion of it. That is a mistake only. It can't be considered as due diligence. Their contention is, by mistake, that entire Schedule D was sought to be deleted, wherein they should have normally said, except that AE other portions should have been deleted. So we sought to include AE is their issue. Okay. If you can produce a document to show that deletion of AE was deliberate, then I think it clinches the issue.
Due diligence.
The deliberate, Millard. See, she had the acquiescence from the
Due
beginning.
diligence is a thing to be interpreted.
See, from the beginning, Millard, from the beginning itself, she knows that there exists Daityapura property. The amendment is also categorically stated that the property of Daityapura was included. And the very fact, Millard, as my learned friend contended that there are two properties in Daityapura. If at all, if you wanted to include those properties also, even maybe the 14 guntas or 15 guntas, what made you to left as it is? It is not in respect of the compromise. After the purchase by my client, have you set up anything extraordinary to say that these 14 guntas is not in my knowledge, only this property is in my knowledge? The very fact, my lord, the very affidavit filed in support of IA number 9, it is wrongly submitted as IA number 11, categorically stated, my lord, please come to para 9.
Or you make out a case that IA number 9 itself could not have been allowed based on the affidavit?
Yes,
you have a
yes, my lord. Therefore, my lord, the IA number.
Which paragraph, sir?
IA number, please come to my lord, 263. Please come to the affidavit file in respect of IA number 30. Because whether the allegations made are bona fide or intentional. 263.
Yes, sir.
Yes, my lord. I only read para 9, my lord. I say that I was not aware of the existence of the property at the time of filing the suit and the memo in respect of Daitapura property. Therefore, my lord, it goes to show that in the year 2021 itself, you are aware. In the year 2021 itself, he has given a complaint to the sub-registrar not registered. Can this go, my lord? With the say of the plaintiff that it is a mistake. It is not a mistake at all. It is a deliberate act.
No, sir. See, it says, I say that I was not aware of the existence of the properties at the time of the filing of the suit, comma, Varvakale.
Illa Swami. And the memo in respect
In respect of the Daitapura property was filed by me for not pressing the amendment in relation to the Daitapura property was a mistake. ಪೂರ್ತಿ ಓದಿ
ಸರಿಯಾಗಿ ಓದಿಲ್ಲ ಅವರು.
ನಾನು ಅದನ್ನೇ
ಓದಿ ನೀವು
ಓದ್ತೀನಿ. Next, para 10, my lord. I say that I had not given up my claim in respect of the Daitapura property, but had merely filed a memo not pressing certain amendment, which oversight I had included the property in Daitapura, now said to be included in. Now, please come to, my lord, IA number 9. Affidavit. Affidavit of para 5, my lord. Para 5.
Page number?
Page number 151 of my learned friend writ petition. 15799. I say that I was not aware of the above transaction until recently. Yen's challenge to the said documents could not have been laid at the time of filing the suit. I say that the said document in relation to properties are illegal, not binding on me or my entitlement. Hence, they said the documents are required to be challenged, seeking the amendment of the pleading prior and the schedule to the plan in the manner and existent detailed in the accompanying application. I say that non-inclusion of the proposed amendment in the original print was not wanton, but the aforesaid bona fide reasons. I say that the amendment sought in the applications will not alter the nature of the social property and consequently the main relief on the parties. Further trial has not commenced and so on and so as stated. Para number 4 ಅಲ್ಲಿ what they say, what they contend is, para number 4 ಅಲ್ಲಿ ನವಿಲಹಳ್ಳಿ ಪ್ರಾಪರ್ಟೀಸ್ ನಾವು ಮಾರಿದ್ದು ದೈತ್ಯಾಪುರ ಗೊತ್ತಿರಲಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ನಾವು ಇನ್ಕ್ಲೂಡ್ ಮಾಡಲಿಲ್ಲ. The very fact that before the sub-registrar she has given the complaint in respect of Daitapura property also, it is not open for them to contend that I never.
That is after filing of IA number 9 alla, sir. That complaint is after filing of IA number 9.
That is true, my lord. Therefore, my lord, from the date of IA number 9 and the complaint till the sale was completed, they are aware. They had the knowledge, the acquiescence.
ತೋರಿಸಿ ಏನಾದ್ರು ಅದಕ್ಕೆ.
My synopsis may kindly be seen, my lord. On 2/8/21, my lord, IA came to be filed. IA number 9, page 127 to 148.
1 second. I think you can take shelter under para number 4 or 3 of that affidavit. Page 149, just check that once.
140. 3, my lord. I say that along with the written statement in the above
Did you
case.
file the written statement, sir? Ravi Shankar?
The statement was filed on 10/12/2020.
10/12.
2020.
2020.
Ah.
Okay. Huh?
and IA 9 was filed on 2/8/2021. 2/8/2021. IA 9.
2/8/21.
20.
Okay. Now. So, see, appeals defendant number 1 to 13, 20 and 21 have produced certain documents pertaining to transactions that are said to have taken place in respect of suit scheduled properties during the month of December 19 and thereafter.
Correct.
The said document pertaining to alleged will. So will may contain schedule D items. Daitapura idea adrelle?
ಇಲ್ಲ ಅದ್ರಲ್ಲಿ.
Ilva.
Will ಇದು ಯಾತಕ್ಕಿಲ್ಲ ಅಂತಂದ್ರೆ that consisted of properties of father. This is property of the mother.
Okay. Okay, this will, it does not pertain to it. Okay. ಹೇಳಿ sir, ಏನೋ ಹೇಳ್ತಿದ್ದೆ.
Yes, ma'am. Kindly take up my synopsis. My lord, I'll draw your lordship's attention with regard to the dates, my lord. Then your lordship's what is transpired. On 2/8/21, my lord, IA number 9 came to be filed. Your lordship would get it at page number 127 and 148 of the writ petition. On 2/8 also, she has stated in support of IA number 9 that she was not aware of anything with regard to the transaction till, and hence challenge the said documents. Now, please come to my lord. On 27/8/21, she has given a complaint to the sub-registrar, lodging a complaint. I produced along with the memo stating that including the Daityapura properties could not be entertained for registration. And my lord, on 6/3/23, during the pendency of IA number 9, the plaintiff filed a memo deleting. Therefore, my lord, while deleting the schedule, she was aware in respect of Daityapura properties, which my client has purchased. Having known those facts, considering those facts, she has filed a memo and deleting those properties, including other survey number in respect of 14 gutas of the land situated at Daityapura. Till now, in respect of those properties, no amendment is sought, nor there is no inclusion in the plaint. They have not explained. Now, my lord, on 6/3/23, during the pendency of the IA, they filed a memo and got it deleted.
No.
On 16/3/23, trial court passed an order, my lord. My lord, my humble submissions before this court is, my lord, whether it is an order passed on IA or an order passed on memo, is an order delivered by the court. And therefore, my lord, can an order passed by a court?
Not only that, 28/3/23, they carried out the amendment.
Yes, my lord. When they are amending the plaint itself, my lord, when they are amending the plaint itself, my lord, my submissions would be, my lord, they had an acquiescence in respect of the property, and therefore they abandon their claim.
On 28/3/23, you carried out the amendment.
Well, till now, my lord.
At that time, you deleted the Daityapura property from the amendment.
Yes, yes, my lord.
Because it was not there ever in the plaint.
My lord,
Only from
rightly or wrongly, my lord.
paste, copy and paste, delete.
My lord, kindly take into this submission, my, for judicial notice. My. Rightly or wrongly, my lord, there is an order passed by the trial court. Without setting aside that order, can an amendment, by way of an amendment, can you take away that order is a question to be determined. My submissions would be, my lord, without setting aside, my lord, you cannot have a backdoor entry to insert these properties, and therefore is my submissions as a bona fide purchaser that you had a due diligence, and therefore to make me to come to a compromise table once again to have some kind of course to be paid. This is the dilatory tactics has been used and filed a successive applications. And thereafter, my lord, on 28/3/23, the amendment came to be amendment plaint also. And thereafter, my lord.
When was the evidence of plaintiff closed?
Closed. Plaintiff examined. 25/2/4. 5/2/24. The evidence of plaintiff side got closed.
26/3/24 ಅಂತ ಇದೆ.
ಇಲ್ಲ, ನಾ ನೋಡ್ಕೊಂಡು ಬರ್ದಿದ್ದೀನಿ.
ನೋಡ್ಕೊಂಬನ್ನಿ.
5/2/24 ಅವ್ರದ್ದು ವಿಟ್ನೆಸ್ ನ ಕ್ಲೋಸ್ ಮಾಡಿದ್ರು.
ಹ್ಮ್.
She not only examined herself as PW1, she examined a witness. That witness examination got over on 5/2/24. Her complete cross examination got over on 11/1/24.
What is 26/3/24? Your memo ನಲ್ಲಿ ಇದೆ ನೋಡಿ.
26/3.
My synopsis, my lord.
Plaintiff adduced evidence, marked exhibits.
ನಾನು
was
ಅದ್ರಲ್ಲಿ
cross-examined and,
ನಾನು ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ, ಅದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ನೋಡ್ಕೊಂಡು ಕೊಟ್ಟಿದ್ದೀನಿ. ಅಂದ್ರಲ್ಲಿ ಎಲ್ಲ ಇದೆ.
ಏನಂತ?
ಅದು ಡೇಟ್ ಅಂಡ್ ಇವೆಂಟ್.
ಯಾವತ್ತು ಕ್ಲೋಸ್ ಆಗಿದ್ದು?
ಅವ್ರದ್ದು PW1 got closed on 11/1/24. PW2 got closed on 30/1/24. ಅಲ್ಲ 5/2/24.
Evidence closed on
Last time
11/1/24.
PW2 got closed on 5/2/24.
5/2/24.
My evidence was let in on 11/3/24.
11/3/24, your evidence.
33/24 IA 28 file.
11/3/24.
11/3/24 ನನ್ನ ಎವಿಡೆನ್ಸ್ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದು. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಹೋಗಿದ್ದು 27/3/24.
ಇವ್ರು ಹಾಕಿದ್ದು ಯಾವಾಗ?
ಇವರು 33/24 IA 28 file.
24 IA 28 file.
ಹೌದು.
28 and 29 filed together.
ಹೌದು.
29 for what?
Impleading.
ಅದೇನು ಕೋಲ್ಡ್ ಸ್ಟೋರೇಜ್.
29. So evidence ಎಲ್ಲ ಮುಗಿದ ಮೇಲೆ ನಿಮ್ದು ಡಿಫರೆಂಟ್ ಎವಿಡೆನ್ಸ್ ಆದ್ಮೇಲೆ
ನಮ್ ಸೇಲ್ ಡೀಡ್ ಆದ್ಮೇಲೆ ನಾವು ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ತಗೊಂಡಿದೀವಿ, ಎಲ್ಲ ಮಾಡಿದೀವಿ. ಆಮೇಲೆ
yes, no objection was received by anyone. 7/3/24. Then proposed defendant being a bona fide purchaser, the plaintiff once again filed IA 28 under order 6 rule 17. This is on 27/3/24.
ಐಎನ್ಎಲ್ ಇತ್ತು.
ಯಾವಾಗ ಹಾಕಿದ್ ನೀವು IA?
ಯಾವ್ದು IA? ಯಾವ IA?
My IA not IA number 30.
28 ಸಾಹೇಬ್ರು ಕೇಳ್ತಾರೆ.
ಅಲ್ಲ 28 and 29.
ಅದ ನಾನು ಹೇಳಿದ್ನಲ್ಲ ಸರ್,
30 ಇರ್ಬೋದು ಸರ್. 27/3 ಅಂತ
33/24
30.
Yes. IA 30 filed on 25/4.
ಅಲ್ಲ ಸರ್,
28 yes not. My lord filed
33. IA 30 filed on
25/4/24.
25/4/2024. IA 35.
ಹೌದು ಸರ್. 25/4/2024.
This may go against you. We don't know.
ಅವತ್ತು ಕೊಟ್ಟಿದ್ದೇನೆ.
Next one.
Yes, my lord. With regard to 6 rule 17, my lord, my learned friend is a canvas. With regard to my lord, acquiescence, my lord, your lordship may kindly take up Dasamuni Reddy and Apparao. And then subsequently in all judgments, my lord, you see, the Supreme Court has referred this judgment and then said, my lord. Then
Where is the judgment? Dasamuni Reddy.
I place, my lord. I place. ಇವಾಗ ಕೊಡಿ.
ಇದು
ಇವಾಗ ಕೊಟ್ಟಿದ್ದೀನಿ.
Dasamuni Reddy.
Yes, my lord. Para 13. An abandonment of right is much more than a waiver, acquiescence and laches. The decision of the High Court in the present case is that the appellant has waived the right to evict the respondent benefit claim and so on. So the doctrine, the court said that the doctrine with the court's law will recognize as a rule of judicial policy that the person will not be allowed to take inconsistent position to gain advantage through the aid of the court. This is my submission. Paragraph 13 ಅಲ್ಲಿ ಇದೆ, my lord. Ink page 9 of my synopsis, my lord, I have called out. Ink page 9 of my synopsis.
Yes. Okay.
Paragraph 13, my lord.
Hmm.
And, my lord, 1992 supplements 1 SCC, my lord. ಇದರಲ್ಲೂ the principal waiver connotes the paste ನಲ್ಲಿ
Okay.
and it would amount to putting the premium and dilutory and dishonest conduct. And therefore, the conduct, please kindly look into the conduct of the plaintiff, my lord. It is not their case, my lord. The memo is came to be filed by the advocate herself. It is their case, my lord. See, she has also filed, signed the memo, as well as she has given a complaint. I taken up the paper publication, not in once, thrice. I paid the money and then invested the money, and then the conduct and the affidavit and other the documentary proof which I produced, deliberate intention, she filed IA. Therefore, there is already an order passed by the trial court. Until and unless that order is set aside or recalled, or whatever the reasons which they taken up in IA for amendment, the same thing could have been done before the trial court, and if they succeeded, then the amendment follows and application has to be considered.
Yes.
Therefore, my lord, in the light of this, my lord, I am the bona fide purchaser. I invested the money and paid the money, and then I have taken all due diligence in respect of purchasing the property, and therefore, my lord, in respect of my items, my lord, there cannot be any amendment. The contention taken are deliberate and malafide.
Yes.
Not this Dasamuni Reddy judgment, Lord. It is in.
There are enough arguments, sir. I heard it. I'll dictate judgment on Monday at 3:30. Just
ಇರ್ತೀನಿ.
facts ಏನಾದ್ರು ಬೇಕಿದ್ರೆ ಕೇಳ್ತೀನಿ. Clarify ಮಾಡಿ. I'll pass my judgment on 30.
Last one submission, my lord.
29th.
But till then, Lord, my friends,
If last one submission, my lord.
gentleman agreement.
ಇಲ್ಲ
ಅಷ್ಟೇ.
ಸರ್,
ಬೇರೆ
they should go. ಇದು ಒಂದೇ ಪ್ರಾಪರ್ಟಿ ಅಲ್ಲ, A2
ಅಲ್ಲ, I have done, Lord. I have done.
30 ಐಟಮ್ ಪ್ರಾಪರ್ಟಿ ಇದೆ ಸ್ವಾಮಿ, 30 ಐಟಮ್. ಒಂದು ಐಟಮ್ ಪ್ರಾಪರ್ಟಿಗೆ ಕ್ಯಾನ್ ಯು ಹೋಲ್ಡ್ ಇಟ್? ನಾನು ಹೇಳ್ತೀನಿ, ಪ್ರತಿ ಸಲ ಇದು ಬಂದಾಗ as a gentleman I kept quiet, my lord. Last 2 days I just kept
Last
quiet.
time your lordship were about to dictate.
26 ಐಟಮ್ ಇದೆ. ಈ ಒಂದು ಐಟಮ್ಗೋಸ್ಕರ 26 ಐಟಮ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಸ್ವಾಮಿ ಅವ್ರಿಗೆ. They want to deliberately avoid, harass us. That's the only intention that my learned friend has.
Next submissions I'll pass on.
ಅಲ್ಲ,
My lord.
ಅಲ್ಲ ಹಾಗಲ್ಲ. This is unfair and unfortunate from my learned friend. While my lords were about to dictate the order for status quo on the last occasion.
No, no, my lord never wanted.
ಒಂದು ನಿಮಿಷ ತಡ್ರಿ, ದಯವಿಟ್ಟು ತಡ್ರಿ.
Let him not lie. Let him not lie before the court.
Lord, I will withdraw my petition if I am lying.
You have
If
then
there is
withdraw
a-
it.
if there is a
Because you are
recording-
lying. Withdraw it.
Lord, then I request my lord to kindly, my lord,
I'm passing the order, sir.
Lord,
I'm not granting any interim order.
Lord, then I have to go ahead tomorrow, my lord, if my learned friend is not continuing with the.
You'll have to go.
Very well. This is a real unfortunate behavior on the part of my learned friend.
Further arguments, ಇದು ಇಟ್ಕೊಳ್ಳಿ, ಇದು notes ಇಟ್ಕೊಳ್ಳಿ. Further arguments on 29th. ಅಥವಾ 29th ಅಲ್ಲ, ಹಳೆ ಕಮ್ಮಿ ಇರುತ್ತಲ್ಲ.
ಒಂದು ನಿಮಿಷ, ಟೈಮ್.
ರಶ್ ಇದೆಯಾ? 86 ಆಗಿದೆಯಾ? ನಾಡ್ದು? ನಾಡ್ದು ಟಿಕೆಟ್ ಮಾಡ್ಬೋದು. ನಾಡ್ದು ಟಿಕೆಟ್ ಮಾಡ್ಬಿಡ್ತೀವಿ.
Grateful.
25th.
Time ಕೊಟ್ರೆ.
3:30.
My lord, my synopsis and maybe
Yes,
taken
sir,
up.
it will be considered.
Grateful.
I'll put it for further hearing anta, but in fact it is for judgment.
ಆಯ್ತು.
That's how it will be. So further hearing. Further hearing, because if I want some clarifications, I will ask you before telling my judgment.
Very well.
Yes.
Lord, I have filed not both the synopsis today.
Yes, it will be considered. Yes. 2:30. Allah, 3:30. 3:30.
Rajeshwar sir.
71. ನಾಡದ್ದು 2:30 ಹಾಕೊಂತೀನಿ.
ಸರಿ,
ಅವತ್ತು ಇದ್ಬಿಡಿ ಇಬ್ರು ಅಷ್ಟ.
ಕ್ಷಮಿಸಿ ಸ್ವಾಮಿ, ಬೇರೆ ಕೋರ್ಟಲ್ಲಿ ಹೆಲ್ಡ್ ಅಪ್ ಆಗಿದೆ.
No problems.
Day
It
after
happens. We also have bad practice. But see
day
to it, day after tomorrow, both of you there at, there
please,
at 2:30.
2:30.
See, I want you to study one judgment and come, which Rajeshwar quoted. Where is
He
the
has
judgment?
given it to me.
He has
Sir has
given
given
it
it.
to you. He enumerates the kinds of rights that are available in acquisition, similar to what I had expressed earlier.
Correct, madam.
He says that The earlier writ petition does not pertain to the rights that are being agitated in this particular writ petition. What he says is, you should not look at acquisition as a whole, but on the basis of the rights enumerated in that particular writ petition. Okay, so the Supreme Court judgment says that 7 types of rights they have got when it comes to acquisition of property. And the first writ petition, which is now at the writ appeal stage, pertains to the first 4 rights. And this pertains to the 7th right that is enumerated. So because of that, this is a distinct writ petition, and it may not be appropriate for this court to direct him to implead himself over there. And furthermore, it is the responsibility of, it is the, what do you say, it is for the person who agitates that particular litigation to implead somebody or not. So under the circumstances, he says, the pendency of writ appeal is not an impediment to go ahead with the writ petition. This is what his sum and substance is of his arguments. This is only with regard to maintainability of the writ petition.
I understand.
Merits of the writ petition are separate altogether.
I understand.
Okay.
I understand.
So see, one thing on parity also you will have to argue. How you have treated similarly situated properties in terms of denotification and all that. Possession you will have to argue. Okay. These are the things that you need to apprise.
16 notification.
16.2 alone may not be sufficient. Anand Reddy judgment is all.
Scheme implement agi.
Adondu, it's staring at you. You should do something.
Because 2016 is when they approached the court.
I mean, see, Supreme Court allo hingagate. It's like we are also getting different judgments.
Correct.
See, the earlier division bench judgment, Oka Sahibrado Bandra, it's in your favor.
Correct.
The latest judgment,
Justice Arvind Kumar or different.
Ad Bandra ಅವ್ರಿಗೆ ಬರುತ್ತೆ. See, there also it's happening like this.
I'll study it and come.
So we require some assistance.
Please,
See, these are all ಇಲ್ಲಿ ಏನಾಗತ್ತೆ ಗೊತ್ತಾ? And what weighs in the mind of the court? See, problem is, one is legal aspect. The second aspect is, see, unfortunately, the authorities have not been fair enough. ಅದು ಒಂದ್ ಕಣ್ಣಿಗೆ ಬೆಣ್ಣೆ ಇನ್ನೊಂದ್ ಕಣ್ಣಿಗೆ ಸುಣ್ಣ ಈ ತರ ಆಗತ್ತೆ.
ಈ ಕೇಸಲ್ಲಿ ಸ್ವಾಮಿ, I understand.
You can't treat any case.
Writ appeal ಅಲ್ಲಿ stay ಇದೆ ಅನ್ಸುತ್ತೆ. Writ appeal ಅಲ್ಲಿ stay ಇದೆ.
ಅಲ್ಲ, stay with regard to what he says, this can be independently.
Status quo order ಇದ್ರೆ section 27 they may not be able to plead because I have to get the benefit of the status quo order.
Oh, correct.
Not having implemented the scheme.
Then get that writ appeal order.
I am trying to get.
ನೋಡ್ಕೊಂಡು ಬನ್ನಿ. Writ appeal stay ಇದ್ರೆ, can we pursue it over here? That stay is for BDA.
Already the Vanshankari 6-stage matter, division bench of this honorable court has concluded that the event of there having been a stay or passed by the learned single judge, non-implementation of the scheme as a ground cannot be urged, and the benefit of that has to be given to the authority because there is an order of status quo. Vanshankari 6-stage matter, Narayanappa case, it has been held by the honorable division bench. I'll produce it also for your lordship. I'm trying to get a copy of the order in the writ appeal. 2008 or 9 interim order ಆಗಿತ್ತು. Swami, I was not aware of it because it is 2006 writ appeal. Not decide agila. I'll try to get an order copy to show it before your lordships. And also, my lord, also is that as on the date of filing of this petition in 2000.
So writ appeal is filed by whom?
There is a person.
The petitioners alva.
Illa, the person who claims to have purchased the property from the petitioner.
That may not come in their way.
ಆಮೇಲೆ ಅದರಲ್ಲಿ ಏನಾಗಿದೆ, ಆ writ petition ಅಲ್ಲಿ the petitioner herein has filed an affidavit saying that they have sold the property in favor of the petitioner. ಆ petitioner. So ಹಾಗಾಗಿ ಏನಾಗಿದೆ,
ಆ petitioner then they will lose complete rights.
ಹೌದು, ಆ ತರ affidavit ಹಾಕಿದ್ದಾರೆ. ಆಮೇಲೆ ಇನ್ನೊಂದೇನು ಅಂತಂದ್ರೆ ಸ್ವಾಮಿ, as on the day of filing of that writ petition, the possession had already been taken. If they have not taken that particular ground of possession not having been taken correctly, they are, my lord, an order to rule to not permit to take up that contention once again in a subsequent litigation. I understand, my lord, they are different petitioners. I understand.
That's okay.
I understand. I'll assist your lordships.
Just assist ಮಾಡಿ ಅಷ್ಟೇ.
Please,
So
madam.
that we can.
One
come up
sufficient.
with-
Another two petitions.
ನಾಡ್ದಾಗ
ಇದನ್ನು day after tomorrow. Please, please, madam.
ಹಾಗಾದ್ರೆ 2:30 ಅಂತ ಹಾಕಿದ್ದು. 2:30.
2:30.
Please, my lord.
Come by 2:30.
One sufficient, my lord. WP 159660, two times memo of posting ಹಾಕೊಂಡಿದ್ದೀವಿ. 19 date.
ಯಾವ್ದಪ್ಪ GMCPC
ಹೌದು.
GMCPC ಅದ್ರ ಏನದು B ಗ್ರೂಪ್ ಬ್ರಷ್ ಮ್ಯಾಟ್ರಿಸು
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಎಕ್ಸ್ಪರ್ಟ್ ಆಗಿದೆ, ಅದರಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಕಮೆಂಟ್ಸ್ ಮಾಡಿ.
B ಗ್ರೂಪ್
ಹೌದು 39 ಹಾಕೊಂಡಿದ್ದೀವಿ. ನಾಟ್ ಟು ಡಿಸ್ಬರ್ಸ್ ದಿ ಕಾಂಪನ್ಸೇಷನ್ ಅಮೌಂಟ್ ಅಂತ ಹೇಳಿ application ಡಿಸ್ಮಿಸ್ ಮಾಡಿತ್ತು ಟ್ರಯಲ್ ಕೋರ್ಟ್. 26 ಮೇಲೆ ಪ್ಲೀಸ್. 26
ಯಾವತ್ತಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೆಕ್ಸ್ಟ್ 12th ಇದೆ.
ನೆಕ್ಸ್ಟ್ ಮಂತ್ 12th ಹಂಗಾರೆ ಅದನ್ನ ನೀವು 29th ಆದ್ಮೇಲೆ ಮೂವ್ ಮಾಡಿ. 29th ಆದ್ಮೇಲೆ ಮೂವ್ ಮಾಡಿ. ಬೆಂಚು ಚೇಂಜ್ ಆಗಿರುತ್ತೆ ಅವ್ರು ಹಾಕೊಂತಾರೆ.
ಆಗಸ್ಟ್ ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ
ಬೆಂಚು ಚೇಂಜ್ ಆಗಿರುತ್ತೆ ಹಾಕೊಂತಾರೆ. ನಮ್ ರೋಸ್ಟ್ರು ಇಟ್ ಕಮ್ಸ್ ಟು ಎಂಡ್ ಬೈ 26. ವಿ ಡೋಂಟ್ ನೋ ವೇರ್ ವಿಲ್ ಗೋ.
ಮಚ್ಚ.
That's the reason. Yes.
Obliged, madam.